आपने पता नहीं सुल्तान के कौन साथ खेला हुआ आप तो हमें प्रोग्राम शुरू होता नहीं होता कुछ पहले आप कहते हैं आपने उनके साथ यार पावन का पहले भी मैसेज
أعوذ بالله من الشيطان الرجيم بسم الله العظيم
Good morning everyone and welcome to IPRI and CICA's International Law Summer School on Arbitration. Our summer school is part of our capacity building initiative to make more students aware of the multiple facets of international law while at the same time being exposed to how different kinds of international law have impacted Pakistan over the years. Our two-day summer school will focus on all facets of international law related to arbitration, including lectures on international commercial arbitration, international investment arbitration, the role that international organizations such as the World Bank's International Center for Settlement of Investment Disputes and the International Chamber of Commerce play in shaping the landscape of arbitration and arbitral awards, and most importantly, what Pakistan's experience and interaction with international arbitration has been. Pakistan's experience with commercial and investment arbitration include two facets. The first is the bilateral investment treaty and its parameters, and the second is the actual litigation of a case. You will hear from speakers on both these issues and how Pakistan maneuvers the international arbitration landscape and has done so over the years. These lectures will be delivered by speakers who have been directly involved in both promoting the landscape of arbitration in Pakistan by negotiating bilateral investment treaties and by being involved in the academic circles, and by also representing the federal government in historic arbitration cases such as the Karki arbitration and the Recordec arbitration. We hope that you have as much fun learning about international arbitration as we had in putting this school together for you. International arbitration is becoming one of the main avenues for the settlement of disputes, not only in Pakistan, but globally. And so we hope that this summer school exposes you to the multifaceted nature that international arbitration has. Thank you. I now request President IPRI, Ambassador Dr. Raza Mohammed, to please come and say a few words and officially open the school. Thank you.
Thank you so much, Mohammed. Bismillahirrahmanirrahim. All praises to Allah, the Almighty, the most beneficent, the most merciful. Salam be upon Prophet Sallallahu Alaihi Wasallam and you all, and Mumlakat-e Khudadad Pakistan. I'm sure this is going to be a very, very useful session. Not a session, but 2 days school. I must appreciate and compliment Mohammed team for putting this all together, selection of the speakers, and we are very grateful to Sika for provision of the assistance, and Rana Sahab for you being here. And we are also grateful to the JS Bank, which basically is the sponsor of our law chair, and it is because of them that we are hosting and holding lot of events and writing so many papers and conducting so many activities related to international law, lawfare, and so many problems of the which are being faced by the country. Since I am a non-lawyer, so I cannot talk too much about the arbitration, but what little I understand from the arbitration is that we go into the agreements, we go into the MOUs, we make certain agreements, and later on we run into certain problems. Although all the agreements must have some dispute resolution mechanism built in those agreements, but sometimes we run into problems and we have to perhaps go to the courts and all that. And arbitration, if I understood it correctly in simpler ways, is kind of out of court settlement thing. That you do not fight a case completely, but you sit somewhere, talk to people, you have the arbitrators who help you and you resolve disputes. अगर मैं गलत समझाऊं तो आप लोग ठीक कर दीजिएगा, लेकिन मुझे थोड़ी जितनी समझ है वो इतनी है. But I think this is very, very important thing. Pakistan has been having problems and is likely to have problems. Major 2-3 things which come into my mind are, first of all, the Indus Water Treaty. Although the wise people say this was the best thing which could have happened to Pakistan, there are few people who say that no, this shouldn't have been done. But when we see the kind of relationships which we have with India today, and the kind of relevance which India enjoys today in the international power matrix, then one comes to the conclusion that good that it was done, good that World Bank was the broker in it, and it has a very, very strong clause we were discussing yesterday that it cannot be amended unilaterally. But naturally we keep going into various disputes, arbitrations, international experts are hired and all that. The other things I think which will be discussed is the IPP, which we face lots of problems. Circular debt आपने बहुत सुना होगा. I think one of the reasons is that the independent power production units के जो हमारे एग्रीमेंट्स हुए थे इनिशियली वो ठीक नहीं हुए थे. क्या उनको ठीक किया जा सकता है कि नहीं किया जा सकता? Because there are people who are ready to renegotiate, there are countries which are not ready to renegotiate. वो कहते हैं जी कि मुआहदा तो आपने खुद ही किया था. अगर आपको याद हो एक कार के वाला वो जहाज़ वाला डिस्प्यूट था, जहाज़ इधर खड़ा रहा, बिजली प्रोड्यूस नहीं हुई, बड़ा आपके ऊपर दे levied lots of fine on you and ultimately perhaps the president of Turkey waved it off. Similarly, Recordec एक बहुत important case है, उसके ऊपर भी discussion होगी. Recordec का जितना मुझे पता है कि there are 3 world's largest gold deposit is perhaps in Alaska. The second one is in Western Sahara. Both are unextractable or inextractable, whatever you may call it. The third one is the Recordec, which is open pit mining. And open pit mining, as I understood it correctly, that you just keep digging the earth, put it into the smelters and keep separating it. And this is by default world's first gold deposit, largest gold deposit, copper deposit, or third at least. लेकिन जो अनफॉर्चुनेट बात यह है कि हमारे पाँव तले सोना है, तांबा है, चांदी है, व्हाटएवर, और पिछले 20-25 साल से तो हम सिर्फ इसके डिस्प्यूट में पड़े हुए हैं और अभी भी ये सेटल हो गया, बट वी आर स्टिल नॉट एबल टू एक्सट्रैक्ट इट. पता नहीं कब ये हमारे नसीब खोलेंगे, ये चीज़ें बाहर निकलेंगी. बट दिस इज़ ऑल रिलेटेड टू आर्बिट्रेशन, दिस इज़ ऑल रिलेटेड टू लॉ, दिस इज ऑल रिलेटेड टू डिस्प्यूट्स. एक लास्ट बात ज़रा आपको वो कॉमिक सी बात है कि हमारे जब एग्रीमेंट्स होते हैं, हम लोग जब जाते हैं एग्रीमेंट करने में, हूँ कोई और हो, तो मोस्टली हम लोग पढ़ते नहीं. कई दफ़ा हम ये भी तकलीफ़ नहीं करते कि लॉयर को हायर कर लें. लॉयर को हायर भी करते हैं तो वो कुछ कहते नहीं नहीं ठीक है हो जाएगा, तो उसी फिक्र ना करो, जाके हम साइन करके आ जाते हैं. जब वापस आते हैं कुछ अरसे बाद पता चलता है तो गड़बड़ हो गई, ये चीज़ गलत है, ये क्लॉज गलत है, फिर हम कहते हैं सिहूनी साजिश हो गई है. तो वो साजिशों से बेहतर है कि अच्छे वकील को हायर करें और उसकी एडवाइस ले और फिर आगे चलें. तो वी आर गोइंग टू हैव 2 days. माम ने एक्सप्लेन किया आपको. विल बिगिन विद राना साहब. राना साहब इज़ वेरी काइंड टू बी हियर फ्रॉम सिका. देन वील हैव मिस डॉक्टर नुदरत एंड आफ्टर द लंच ब्रेक डॉक्टर सादिया जहूर विल बी हियर. शी इज़ पार्ट ऑफ द नेशनल सिक्योरिटी, if I'm not wrong, National Security Division. Tomorrow we'll have Zuhair Waheed Saab and Ali Zahid Saab. But more importantly, more interesting would be the panel discussion tomorrow, in which we have all the big heads, law heads, which we could gather sitting here and guiding you, the young people, about the future of international law and how you could actually opt. ये एक किस्म का career counseling session भी बन जाएगा. And in between, in the breaks, you can talk to the senior people, you can seek their advice, you can ask their opinions कि आगे ज़िंदगी में हमने क्या करना है, international law में जाना है, arbitration में जाना है, litigation में जाना है, किन चीज़ों में जाना है. With this, I hand you over back to Maham and wish you all the luck, and I'm sure it is going to be very useful for your future, inshallah. And thanks for coming. Good luck for you all. Thank you.
Thank you, President IPRI Jan Raza, for your introductory remarks. Now we'll introduce our first lecturer for the session on international commercial arbitration. This session will be conducted by Mr. Rana Sajjad. Mr. Rana Sajjad is the founding partner of Center of International Investment and Commercial Arbitration. He's a dual qualified lawyer, licensed in New York and Pakistan, having over 15 years of experience of practicing law in Pakistan and the United States. His practice area includes contracts, cross-border transactions, commercial litigation, and domestic and international arbitration. He has acted as co-counsel on international arbitration proceedings, including proceedings under the rules of International Chamber of Commerce, the Dubai International Financial Center, and the London Court of International Arbitration. He's also the fellow of Chartered Institute of Arbitrators. He earned his BSc in economics from Lahore University of Management Sciences, LUMS, and subsequently completed his LLM from Columbia University, New York. Sir, the floor is all yours.
Assalamu alaikum, everybody. Thank you for the very gracious introduction. I'm pleased on behalf of SICA to collaborate with the IPRI. Quickly about SICA. SICA was launched about 8 years ago. I'll talk in detail about what SICA does perhaps sometime tomorrow. But one of our objectives is to raise awareness about arbitration, to promote arbitration here in Pakistan, and to build capacity. So I'm glad we're collaborating with IPRI here today to sort of further our mission as well. So I have about 90 minutes to introduce you all to international commercial arbitration. Of course, I have no idea how much knowledge you have about international arbitration, how much understanding you have, but I'm working on the assumption that all of you are either law students or young practitioners who have a keen interest in international arbitration. So based on that, although it's difficult to essentially talk about international arbitration, cover all the facets, all the aspects of it in 90 minutes, but I will try my best. And I think my primary focus would be on drafting an arbitration clause and how the proceedings are conducted. Besides that, I think I'd also like to talk about the format of this workshop, because generally I like to have an interactive session, because growing up we went to schools, colleges where the professor used to walk in, give a lecture, essentially a monologue, and just leave the class without any engagement with the class. So I'm not one of those, so I'd be happy to engage with anybody. I believe that no question is a silly question, so please, if you have a question, have a comment, feel free to interrupt me, stop me at any point, and I'd be happy to answer your questions. And I think, of course, we have 90 minutes, we have limited time, but I'll try to cover everything that is on the slides, but in case we cannot, and if you prefer to focus on a particular aspect, I'd be happy to talk in detail about that as well. Okay? With that, I will start. Let me figure this out. I'm hoping I'm getting this right. All right, sorry. Okay, so this might be a bit of a surprise. You might think this is the wrong slide. This is a very professional setting. What is this guy doing here, having this animated slide up on the presentation? But I just thought we should lighten things up and have a little bit of fun with the international arbitration. I'm assuming that most of you know a bit about international arbitration, but let's just start with the story of international arbitration with this animation. So as you can see, this is a construction site. There's a hotel being built. And the reason why I have this slide up here is to give you a sense of the cultural, geographic, and the true international dimension of international arbitration. This is one of the reasons I actually fell in love with this field, because the kinds of cultures, the diversity of people, lawyers, arbitrators, jurisdictions, laws that you have to deal with, it is incredible. So let's just get started here. As you can see, there's a hotel being built. So let's assume, assuming all of you are Messi fans, this is being built in Argentina, in Buenos Aires. So the physical location of the hotel is Buenos Aires, Argentina. Let's assume that the hotel is being built by Marriott, which is an American company. Let's also assume that the hotel is being built by a contractor from Spain. And then let's also assume that the materials for the hotel are being built, manufactured in China. Okay. So you have what, 4 or 5 countries right there. So Argentina, Spain, America, China. Right, so of course there could be more as well. Let's say if you say that one of the engineers is from perhaps Australia. Now, the reason why I lay this out for you is, this is of course sort of an unusual scenario, but the reason why I bring this up is to give you a sense of how many kinds of nationalities you have to deal with in terms of the law, the jurisdiction, the procedure, the nature of the dispute, the physical location, right? So there's a lot for you to process here, but I just thought I'll get started on this. This could also be a hotel being built in Pakistan by a different company as well, which is where people like you would become relevant as Pakistani lawyers. So just keep this image in your head while we proceed with the sort of the nitty-gritty of international arbitration. Now, first and foremost, what are the considerations for choosing a particular dispute resolution method? Of course, I see some people wearing black suits who are lawyers. I'm guessing go to court on a regular basis, and what you do in courts is litigation, right? And why do you go to courts? To resolve a dispute. Two parties have a difference, disagreement, and they need to resolve it. They need to have it decided, so they go to court. That is what lawyering in Pakistan is essentially about. For the most part, people know that there's only one forum to resolve disputes, that is the courts. Now, where is arbitration different? I'll talk about that in a little bit. But the considerations are cost and time. How much money you have to spend to resolve the dispute, how much time it will take to resolve the dispute, the nature of the business relationship. This is important. So for instance, you've had a long-standing business relationship with a party. Let's say you're a distributor for a phone company. You've been doing business with them for 10 years. You don't want to hurt or undermine that business relationship. You want to continue doing business with them. And you think, if I go to court, it's an adversarial mechanism. Perhaps I'll sour the relationship with the other party. I might as well choose a method which is not that adversarial, a bit more conciliatory. Binding or non-binding, any court judgment that you get is binding. Of course, you have to comply with it. If you don't, there's contempt. Procedural flexibility. Court doesn't really have any flexibility. There's a very rigid, very clear procedure laid out for courts. CPC, CRPC, you must be familiar with that. There isn't much flexibility there. And confidentiality. Now, confidentiality essentially means, whether you would like the information about your dispute to be disseminated amongst the general public, right? Now, all these are relevant for arbitration as well. I'm sort of building towards that. And one of the considerations, let me see the next slide, for choosing arbitration. So arbitration is a private mechanism. By private, I mean there is no public official involved. There is no court. There is no judge for resolving disputes. So in very simplistic terms, you think of arbitration as a mechanism where the judge is replaced by the arbitrator or a tribunal of, let's say, 3 arbitrators, and the CPC or the court procedure is replaced with the arbitration rules of the institution that is administering the proceedings, or in the case of ad hoc arbitration, by the law under which proceedings are conducted. So these are the 2 big differences between litigation and arbitration. So it is very similar to litigation in terms of the formality of the proceedings. You must have heard of ADR, alternative dispute resolution. So arbitration is the most formal mechanism of ADR. It is very similar to litigation in terms of procedure, evidence, cross-examination, oral arguments, all that. But the biggest differences are that it is a private mechanism. You get to pick your arbitrator. And I'll talk about why that is important. And of course, there is no court, there is no public body involved. You could have your arbitration proceeding conducted in a boardroom, in a conference room, in your own house, right? Arbitration, generally, they say it's cost and time efficient. I respectfully disagree, especially international arbitration is not anything but. So because international arbitration ends up taking 2 to 3 years on average, it costs a lot of money because the bulk of the money is actually paid to the lawyers, the arbitrators' fees. In case of institutions, they have a substantial component of the cost as well. So it is not cost efficient by any measure. But I'll get to why we still choose international arbitration. Choice of arbitrators now, when I say you get to pick the arbitrator, if you compare to litigation, you say, I get to pick my judge. That sounds unethical and very inappropriate, right? You can't pick your judge, right? You should not be picking your judge. But the reason why in international arbitration you get to pick an arbitrator is not because he or she will decide in your favor, but because of his experience and expertise, his impartiality and independence. You pick somebody who you think knows the industry well, who knows the issues well, who will decide it well. So I'll give you an example. So for instance, when I was a younger lawyer, I used to go to civil court a lot. Not that often now, but I was arguing a case regarding the telecom sector, and the civil judge, with due respect, he did not know much about the telecom industry, right? I did not expect him to understand the technical issues in the case, but if I had picked arbitration, the arbitrator that me and the other party would have picked would hopefully be somebody who has relevant experience in the telecom industry. Same goes for, let's say, technology, oil and gas, mining. You pick a person who has relevant experience and expertise, because when you're deciding a dispute and the stakes are that high, you need to have somebody who understands the issues, not just from a legal standpoint, but from a technical standpoint as well. And I'll get to how you can have a diverse tribunal as well, in which you can have technical experts. But that is why you have the luxury of choosing your arbitrator, not because that arbitrator will be biased or partial, but because he or she will know the issues better than an ordinary judge. Okay? Confidentiality, this is something prized by a lot of the parties. So think of big businesses in Pakistan. They don't want to wash their dirty linen in the public. They don't want their disputes to be talked about in the national media, which is all too keen to actually jump on such stories. So confidentiality is something prized by a lot of parties, especially in international context. When you're doing business with the parties from other nationalities, you want to make sure any disputes stay behind closed doors within the knowledge of the parties, and nobody else finds out, because reputation is important for a lot of parties. A lot of people interpret disputes in a very different way. So if it's in the public domain, good luck convincing parties, whether you were right or wrong or what actually happened. So confidentiality is very important, whether it's for domestic arbitration or international arbitration. Binding award, any court decision, as I said, is binding as well. Now, an arbitral award is binding as well. By that it means that a party has to comply with it. If it doesn't, then it'll have to be enforced. I'll get to enforcement in a little bit. But by binding, I'm also trying to tell you that there is no appeal of an arbitral award. So unlike a court decision, let's say by a civil judge or a session judge or a high court judge, a decision by a tribunal or an arbitrator cannot be appealed. Now, it's a double-edged sword. On the one hand, it's good because it saves you the rigmarole, the delay in appealing, because let's say you have a favorable decision, it might take you another 5-6 years to have it definitively decided by the superior courts in Pakistan, right? But you don't have that problem in arbitration. It's a final binding award that a party has to comply with. That said, again, I'll talk about that in a little bit. It can still be challenged, and there's certain grounds, especially international, a foreign arbitral award can be challenged. Under Article 5 of the New York Convention, there are 7 grounds under which it can be challenged. But it's not an appeal, which means it cannot be challenged on the merits. There's some technical grounds on the basis of which it can be challenged, but it cannot be appealed. Again, for those who choose arbitration, this is a huge advantage. Because think of it this way, in large international commercial disputes, the dispute amount quantum could be in the millions of dollars, right? So the last thing you want is it takes about 2 years to decide the dispute, and then you spend another 6 years, having it decided by some appellate forums. There's no such thing in arbitration. You still have to go to court in a lot of cases, but not to appeal or to contest an appeal. Okay, so there is no appeal in arbitration, whether it's domestic or international. Limited judicial review essentially is the same thing. Recognition, enforceability. Now, this is where I'd like to distinguish domestic and international arbitration. One of the key advantages of international arbitration is the New York Convention on the enforcement of foreign arbitral awards. This was enacted in 1958. I'll discuss this later. But basically, it gives international arbitration edge over litigation as well as mediation. Why? Because all the countries that are signatory to the New York Convention, it is binding on the courts of that country to enforce an award that has been rendered in another contracting state. Now, that is a lot for you to process. So for instance, let's say the dispute proceedings were conducted in London, the seat of arbitration was London, and the award has been rendered by the tribunal, right? And the party, let's say it's unfortunately against Pakistan. They want to enforce on that award. Now, enforcement essentially means that the Pakistani party has refused to pay the amount of money the tribunal ordered them to pay, just like a court decree. They said, we're not going to pay this is unfair, and they try to challenge it. But the other party says it's a final binding award, we'd like to enforce it. They come to Pakistan, where the assets of the party are located, to enforce it. And Pakistan will say, oh yes, we're a signatory, we've ratified the convention, we actually enacted the New York Convention, therefore our courts are bound to enforce that award. Okay, and this is true for, I think, more than 150 countries around the world. So to put this into context, for disputes involving multiple jurisdictions, for disputes in which parties have assets in multiple jurisdictions, this is a huge advantage, because what that means is you're a Pakistani party, you have won a case you have an arbitral award in your favor, and the other party, let's say, is a German party that has assets, let's say it's an automobile company, which has assets all over the world. It's in China, Singapore, Australia, England, right? You can actually enforce that award in all those countries where the assets of that company are located, as long as that country is a signatory of the New York Convention. So you see, when the stakes are that high, you know why parties choose international arbitration, because they know that once we have a decision, we can take it to all those countries. This is a luxury, unfortunately, a court decision decree does not have. All of you familiar with the CPC section 44A, section 13, 14. So even for, like, speaking of experience, getting a UK Chancery Court decree enforced in Pakistan is a challenge. And that's just one jurisdiction. So you don't have to worry about those things for international arbitration. For an award, you can take it to all those countries and enforce them. So that's another huge advantage of international arbitration. So nationality, so people say, what is the difference? One big difference is usually the nationalities of the parties are different. So it would be a Pakistani party on the one hand, and the other, let's say, a textile manufacturer based in Faisalabad. He's exporting textiles to a company in France. Two different nationalities. Dispute between them would be an international dispute, and if they have an arbitration clause, it will be an international arbitration clause. Degree of court intervention. So the New York Convention essentially ensures that there's minimal court intervention because of the very specific grounds which have to be interpreted very narrowly by the courts before they can try to set aside an award or try to intervene. Unfortunately, that is not the case, at least in Pakistan, for domestic arbitration. So that is another advantage that international arbitration offers. Greater party autonomy, international. So party autonomy. I talked about procedural flexibility. So that basically means you get to choose not just your arbitrator, but the procedure that will be adopted for the proceedings. You can't just come up with the procedure. It is usually, let's say if you pick institutional arbitration, it'll be the rules of the institution. So let's say we have SICA. Internationally, of course, there's ICC, LCIA, Singapore. All those arbitration centers have their rules. So think of them as the CPC, their procedural rules for conducting an arbitration. So it is conducted under those rules. That said, so when parties are picking an institution, or let's say picking ad hoc versus institutional arbitration, they're actually designing the procedure for the arbitration as well. So ad hoc arbitration, for those who are not familiar, is an arbitration which is conducted without an institution. It is, I would say, unfortunately very common in Pakistan because we are promoting institutional arbitration, but I think ad hoc arbitration happens when, let's say you have a clause in which it says any dispute will be administered, decided under Arbitration Act 1940, parties will pick an arbitrator. There is no institution involved. What the institution does is facilitate the entire process. So if parties choose ad hoc arbitration, they're essentially saying, we don't want to have an institution, we know how to run the proceedings, the arbitrator will decide the procedure, they'll have terms of reference, they'll decide. So you have this party autonomy, freedom to choose your procedure as well. The New York Convention, I already talked about it. Now, drafting the arbitration clause. So I believe that there are two types of lawyers. Actually, there are two types of lawyers. So one are those who are corporate lawyers who draft contracts for the most part, and then there's litigators or dispute resolution lawyers. I personally believe, although I do both, that the corporate lawyers have a more pivotal role to play, because at the time of drafting the contract, you can actually mitigate, minimize a lot of the potential issues if you have that imagination to think of all the possibilities that could lead to a dispute, right? So the more comprehensive your clauses are, the less the likelihood of a dispute arising in the first place. Which is why drafting an arbitration clause well is very important also, because a poorly drafted arbitration clause could lead to a lot of confusion and would defeat the whole purpose of actually saving time and money, because then you will spend time and money figuring out what the clause meant, how it was interpreted. Now, I call these 6 words arising out of in connection with the 6 magic words. I urge all of you to use these 6 magic words because I think it would make your arbitration clause as broad as possible, because it will cover essentially all kinds of disputes related to your commercial contract. Because the last thing you want, one of the parties which is not well-meaning, which in bad faith wants to defeat the arbitration clause, would say, this type of dispute is not covered by this clause. It is not within the scope of this clause. So by using these 6 magic words, of course, it's not a guarantee, but I think you try to ensure that all disputes are covered by this clause. Again, I talked about ad hoc institutional arbitration. You need to be very clear about what you want to do. Again, I encourage parties to opt for institutional arbitration for all the benefits it offers. But of course, parties choose ad hoc. So you have to specify that in the clause as well. Multi-tier clause, General Saab talked about different methods of dispute resolution. So arbitration is one of the alternatives to litigation. Mediation you must have heard of as well. So by multi-tier clause essentially mean a three-tier clause, which basically means you start off by trying to amicably resolve the dispute, which basically means it's bilateral. It's between the parties. No third party gets involved. You say, we've had a great business relationship with you. We don't want to go to a third party mediate. You know, we're grown people. We can resolve this amongst ourselves. So you try to negotiate a settlement, amicably resolve. So that's the first step. If that fails, you move on to the next one, which is mediation. Now, mediation, of course, this is not within the ambit of today's discussion, but mediation essentially, I would say the cheapest and quickest way to resolve a dispute, because in that there is no formal proceedings as such. You need to appoint a mediator, but to me and to a lot of people, the biggest downside to mediation is it is not binding. By that I mean that you need to attempt to resolve the dispute by mediation, but it is not binding on you to resolve it fully and finally by mediation, unlike arbitration, which is binding. So not to confuse you a bit, so mediation is great if it works. It is growing around the world, especially in Asia. But it all comes down to the good faith of the parties. If the party really want to resolve this, they can, but if not, it's not binding. They can just walk away. They'll say, we tried to resolve this, but we can't. So that is where a multi-tier clause comes into play. Again, it's a good idea to have that as part of your contract also. Leave options open, you never know. Number and appointment of arbitrators. So I talked about a tribunal, could be one person or three, usually it has to be an odd number, of course. The considerations for having either one arbitrator or three is, of course, a big one is costs. If it's a small dispute, it doesn't make sense for you to have three arbitrators, because that means 3 times the arbitrator's fees, 3 times the cost. And then, of course, if there's 3 arbitrators, they'll take more time to deliberate their decision as well. There's some back and forth, you know, where a sole arbitrator, you know, decide it quickly. Another consideration is the nature of the dispute. So let's talk about construction contracts, which usually take a very long time, which are very complicated. A lot of disputes arise all the time. You want to make sure that there is somebody with a legal background on the panel and somebody with a technical background. So let's say what happens in Pakistan, generally around the world, is a 3-member tribunal of arbitrators. One is, with due respect to all the judges in Pakistan and around the world, judges don't sit as arbitrators, but let's say you have a judge or a practicing lawyer, and third could be an engineer, right? That makes perfect sense because you're covering the technical and the legal aspect, and then they can divide their duties amongst themselves. Maybe the retired judge or practicing lawyer can write the decision or the award. The engineer can give some technical insights. He can, assess the technical issues. So in that sense also, it makes sense perhaps to have 3 arbitrators, assuming the quantum of the dispute is large enough for you to pay that much money to all those arbitrators, right? So that, and again, you would know the nature of the contract, the nature of the transaction. So you should be able to figure out whether having 1 arbitrators or 3. And the other option is don't specify it. So the rule of thumb for contract drafting generally is, for all your rights, draft very broad clauses. For all your duties, draft very narrow clauses, right? In this case, you can do that as well, but the only problem is, again, interpretation, misinterpretation, right? You could be like, should we have 1 or 3, and then it would waste more time. So generally, it's a good idea to actually specify the number of arbitrators in the clause at the time of drafting the contract. What you can also do is, if you want to be more specific, specify the qualifications. You could say we'll have 3 arbitrators, 1 will have an engineering background, 1 will have a legal background, 1 will have some other technical background, 2 will have legal background. You can specify that as well. In international arbitration, there's another dimension. You can specify, so let's say it's a contract between a Pakistani party and a German party. And you specify that the 3 arbitrators will be from 3 different nations, neither from Pakistan nor from Germany, for them to be neutral. You would say you could specify the nationality as well. You could say, you could either specify they will not be either from Pakistan or Germany, or could you say they'll be from China, Australia, the US, right? So you can do that as well. You can specify the nationality. You can also specify their experience and expertise. You could say that we'll have a person with a technical background with at least 20 years of experience. or 10 years of experience. Okay, you could specify that as well. So it all depends on, again, the nature of the transaction and how high the stakes are, But again, as I said, the only problem is that if you become too specific, it might take you a long time to find the relevant arbitrator who fits all those requirements and qualifications. In a very extreme scenario, people actually specify the name of the arbitrator as well, that this person is sit as an arbitrator. Now the problem with that is, in extreme scenario, the person has died, right? Especially all these senior guys, they're very well known, right? So what do you do then, right? So that is the problem in being too specific. So you have to walk this fine line between being too specific and too generic. But again, I think it all depends on your client's preferences, the nature of the transaction, your industry, history, background, how things pan out. So you have to have that view before you decide this. Seat of arbitration. So the seat of arbitration, it's the slippery concept in the sense that people use it interchangeably with the venue or the place of arbitration. Now, seat is a juridical concept. So it essentially means that it is the legal place of arbitration. There is not a physical place of arbitration. The physical place of arbitration is the venue. So I'll give you an example. So let's say you have specified the seat of arbitration will be in London. It has to be a city, it cannot be a country. You have to specify the city. And you say that when the dispute arises, you say, we're not going to travel to London, airfares are very high, the hotel prices are very high as well. So can we conduct the proceedings here in Pakistan, or perhaps Dubai, or on Zoom, right? Cyberspace is the new venue, right? You can do that. There is no bar on that, right? But the seat of arbitration would still be London. Now, what that means is you're not physically conducting proceedings in London, but all relevant procedural aspects of the arbitration. So procedure is not governed by the law, but there can be nothing about the proceedings that are in conflict with the seat of arbitration's procedural rules. So again, to simplify it, let's say the institution who's administering the proceeding is the International Chamber of Commerce, ICC, and the ICC arbitration rules govern the proceedings. The seat of arbitration is London. So there can be nothing in the ICC arbitration rules that conflicts with the procedural rules of UK's arbitration law. If there is, you have to comply with the UK's laws. You cannot conduct proceedings at the seat of arbitration in violation of the laws of the seat of arbitration. So that is the significance of the seat, which is why you have to think this through. You have to be very careful about what city you pick, not because you like to vacation there or the weather is nice. You could pick Hawaii as a seat as well, but you should know the law as well, right? Generally, it's not a problem. Generally, a lot of these seats, their laws don't conflict with institution rules, and institution rules are fairly standard as well. So that is not an issue. But seat has another significance as well. So you've heard of injunctions, injunctive relief, stays, all that, right? So during the course of the proceedings, if you want to seek injunctive relief, you go to the courts of the seat of arbitration as well. Even if you're sitting here in Pakistan, the courts of the seat of arbitration are the competent courts to issue any type of interim relief, any injunctions, any other adverse inferences or any sanctions. You have to go to the seat of arbitration. So that is also why it is significant. And I quickly mention this as well. I'll talk about enforcement later. But another reason why the seat of arbitration is important is when the award is rendered, the decision is made. If you're dissatisfied with the decision, the first place where you can challenge the award is at the seat of arbitration. So let's say Pakistani party says, the arbitrator messed up, the decision is unfair, illegal, whatever. The first forum that you can go to will be the courts of the seat of arbitration. Okay, so you have to keep all these three in mind before you pick a seat of arbitration. You can't just say, everybody likes London, everybody likes Paris, New York. No, you have to think all these things through. Of course, cost is an important component as well, but you have to do your research. And I think a good lawyer is somebody who keeps all these factors into consideration. And of course, you will have to research a lot of the laws as well. But I think you need to have that holistic, comprehensive view before you can advise your client on what seat of arbitration to pick. I'll just stop it to see, are there any questions so far? It could mean two things, either I'm crystal clear or you're not getting any of this. Please, finally, go ahead.
I wanted to know if you could use a third country or India and Pakistan, for example. You have this issue going on. Now, for the state of arbitration, can you use the third country for it, or do you have to go on with
the country of dispute? I mean, as you talked about, like, you can go to Dubai or you can have a seat in London. So why would they host us, the two stranger countries who have a dispute going on somewhere? Why would Spain host Pakistan and Germany's issue?
The seat can be anywhere. Generally, it's a neutral city. That's why I'm talking about a dispute between a Pakistani and a German party. That's why I said English law. Had it been Pakistan, England, most likely, although Pakistan, unfortunately, most of the countries in the developed world just cave to the demands of the more powerful countries, and they say it's going to be London, it's going to be Paris. They're the go-to seats anyway. But if you have more bargaining power, you can pick a more neutral venue. But the seat could be even be Pakistan. You could say, let's say Lahore, Islamabad, Karachi. But see, arbitration, it's a creature of the contract. So everything is subject to mutual agreement. If the parties agree, anything can happen. In an unlikely scenario, the London party could agree to have Islamabad as the seat of arbitration. And in a highly unlikely scenario, Pakistan could agree to have London as the seat of arbitration, even with the dispute with an English party, right? So it's subject to mutual agreement. But generally speaking, it's usually a city in a neutral country. But yeah, that said, governing law, hang on. Yeah, governing law is coming up. So governing law generally for a lot of national commercial arbitration matters is English law, but that is something different. The seat is slightly different. So, but yeah, if both parties are satisfied with the choice of the seat, taking all the things I just discussed, then you can pick any seat. Third country won't have any problem welcoming people to their country. It's more business for them, so they never have an issue. Okay. Any other questions? Yeah, please. It would be helpful if you could just let me know if you're a student, a lawyer, so that'll help. Yeah.
My name is Mohammad Faisal Yar, and I am from Nurse University, Islamabad. So my question is related to the lex arbitri, the seat of arbitration, and the governing law. So each seat of arbitration is only related to the procedure of the arbitration, or it can also examine that what law should govern the arbitration agreement. Because sometimes, for example, if the parties have formatted an arbitration clause and they have write the law to govern the substance of the contract, but they are missing on the part that what law should govern the arbitration agreement. So should we apply the seat of arbitration law to the arbitration agreement, or should we apply the lex contractus, that the law of the contract should apply to that? Thank you.
I'm impressed with your Latin. I like the lex part in your question, so I think you know quite a bit. I'll get to your question a little bit, sir. You had a question?
I'm Asif Durrani. I'm from Ambassador. I'm intrigued a little bit about the state of our legal expertise in the international law. First, it comes to our mind is about Kulbhushan Yadav's case. We had to rely on non-Pakistani or international lawyers. Same happened with Kishan Ganga. We had to engage UK lawyers. Don't we have the expertise here in this country as far as legal profession concerning arbitration or international relations are concerned?
Yes. So my short answer to the question is yes, we do have it, and I think we'll discuss it in detail tomorrow. But yeah, I think we do have the expertise, but I think some of it has to do with our mindset as well. I think we are just sort of so beholden to lawyers in the West that they're the only ones who can do a good job. I think there are some capacity issues, but I don't think they're serious enough to merit appointment of foreign firms in pretty much every case across the board. I think that is something I disagree with. But of course, they certainly bring value to the table. I don't disagree with that. But I think keeping in view the amount of money that the government ends up spending, I think it makes sense to actually consider alternatives, within Pakistan. And this is part of that objective as well. That we're trying to get to the point we can have a pool of lawyers who understand international arbitration. So to your question, it's a very good question. And it ties in with the poorly drafted arbitration clause. So some hotshot lawyer who missed out on specifying the governing law, but he thought that the seat of arbitration is more important. So I'll specify the seat of arbitration, but I won't talk about the governing law. Yes, in that case, So the closest contacts, so essentially the theory is that, when you're trying to figure out, the tribunal is trying to figure out what law should govern the dispute, they look for relevant contacts. So they'll see, where the contract was signed, where the transaction was performed, where the duties of particular parties were performed, where they're from, and of course the seat of arbitration. So they do consider seat of arbitration, the law of that seat, to be the governing law as well, in case parties do not specify. That is the only time when there's a connection between the governing law seat of arbitration. Otherwise, they two altogether different concepts and their purpose is totally different. But yeah, that's a good question. But in a case in which they haven't specified governing law, the seat of arbitration would be considered as a potential law that would govern the contract. Okay. Yeah.
शायद मेरा सवाल बहुत सिली लगे, लेकिन मुझे बाकी कॉन्सेप्ट ग्रास्प करने में बहुत मुश्किल हो रही है, क्योंकि हम बार बार ये बात करें कि ये आर्बिट्रेशन आउट ऑफ कोर्ट सेटलमेंट है. तो इन्फोर्सिबिलिटी के लिए क्या अगर हमें दोबारा से कोर्ट्स की तरफ जाना पड़ेगा, तो क्या एग्जीक्यूशन ऑफ डिक्री में जितना हमें पाकिस्तान में वक्त लगता है, अगर पाकिस्तान के कॉन्टेक्स्ट से देखें, तो फिर आर्बिट्रेशन का भी हमें किस तरह फ़ायदा हो सकता है अगर हमने कोर्ट्स पे एट द एंड ऑफ द डे रिलाई.
जी. First of all, as I said, there's no such thing as a silly question, so fire away. Secondly, first of all, this is not settlement. It is not out of court settlement, so it is a procedure that does not involve the courts. So in that sense, yeah, it is out of the courts. But so out of court settlement generally done by parties, the amicable resolution. Arbitration is not settlement. Mediation is settlement. Parties settle. Arbitration is not settlement. It's a decision. Just like a court order, there's an award. One party wins, one loses. One party wins more, the other party wins a little bit. But there's a final definitive decision. That is not a settlement. Okay. Achha, to your point. So in an ideal world, the losing party in arbitration voluntarily complies with the award, which basically means the tribunal says you have to pay $2.5 million because you wronged the other party, you were in breach, and you have to pay $500,000 in damages. And the party says, yes, of course, we'd be happy to do that. They voluntarily comply, just the way in Pakistan nobody complies with the court decrees. In a lot of arbitration cases, the losing party does not comply with the award, right? They come up with their challenges. And if the party does not comply, just like a court decree that you have to get executed, an arbitral award has to be enforced, recognized and enforced by the courts. So it is very similar to litigation in that sense. Only if the party fails to comply or just in a court decision abide by the court's decision that you go to court to in contempt or for execution. In arbitration, you don't have to go to court in ideal world if the party voluntarily complies. It does happen in some cases, but in a lot of cases it doesn't. Okay. So, all right, moving. Yeah. Yep, go ahead.
Assalamu alaikum, sir. I'm a student of Qaid Azam University, 6th semester. Sir, I have a question. It could be I could have missed something. Lekin, sir, assuming most of our clientele would be international, so would it come in handy if we have an international exposure, or is the exposure we have around here in this country is enough? Assuming the market will have competition as well. Obviously, we will compete with other arbitration associates as well. So, in that context.
Yeah. So I mean, you could have two kinds of clients. You could have a Pakistani client who's involved in a dispute, international commercial dispute, or you could have a foreign client, right? Chances are that you're a Pakistani lawyer, most likely the Pakistani party should be hiring you. But of course, a foreign party can hire you as well. So in a lot of cases, when you act as the co-counsel for both commercial and investment arbitration, so the foreign firm usually takes the lead. And then the local Pakistani firm is the co-counsel, even when it comes to representing the Pakistani party. Again, the question sir raised here about sort of the lack of capacity and all that. I personally think I don't think it's rocket science. If you've practiced international arbitration, you can handle most of the case yourself. But parties generally prefer to pay more money to firms that are American or British because they think they have the expertise. But I think yeah, if you have the training, if you have some experience, you can handle yourself. So yeah, to answer your question, most likely you'll be hired by a Pakistani client. But yeah, there is no bar on it. If you're really that good, you can be hired by a foreign firm as well. Especially if part of the proceedings relate to the Pakistani jurisdiction also, let's say some evidence collection, witnesses. So even for the foreign party as co-counsel could hire you as well. Okay. Any other questions? Okay. Shadip, how much time do you have? Because I don't know when we started. I want to keep track of that. All right. So next is governing law. So
12:15. You have around.
you said 12:15?
Yeah.
About an hour? Okay. So governing law. Governing law essentially means the governing law that governs, it's a substantive law. So in law, of course, there's substantive and procedural law. Substantive essentially governs sort of the merits of the dispute, and procedure governs, of course, the procedure. So why is the governing law important? Perhaps I can just ask this question. Does anybody just take a guess? Why is the governing law of the contract important? And it's not the seat of arbitration. It's not where proceedings are conducted. Or actually, what does the governing law do? What is the purpose of the governing law? So let's say you're an arbitrator, and the governor of the contract is English law.
The main importance of governing law is you have to use only single law that will be used for the institutions of contracts. Like two nationalities are there. One is German and one is Pakistan. So if we use Pakistani laws, maybe Germans will accept. Or the laws, there are differences. So they have to come up with the governing law, only common law which will be used for the contractor.
Anybody else? Yeah.
The governing law should be one, and it will be used as a standard to refer to.
As it will define the rights and responsibilities of both parties.
Yeah, right. One more and then we can, yeah.
It's very important because that you have to choose that which goal arbitration. For example, if we look into the Iranian law, and if we have like that, then we have certain restriction that we need a party to go. And if you have chosen that law, then you have to compare with all these restrictions. So it's very important to know that arbitration agreement will be required.
Yeah, so for any contract, governing law is the law that decides, governs the rights and duties of both parties, right? So if one party has breached its duties, breached the contract, whether or not there was a breach will be decided by the governing law. So a Pakistani party in a dispute with the German party, Pakistani party's rights and duties and the German party's rights and duties will be decided by English law, not by Pakistan, not by German law, not by the law of the seat of arbitration, but by that governing law. So the arbitrator ideally should be somebody who has knowledge or perhaps is licensed in the UK, should know about English law, because the arbitrator or arbitrators will be applying that law to decide whether this party was right or wrong, whether breach was committed, amount of damages, so all the substantive aspects of the dispute are decided under or by the governing law. Okay, so you need to have a very developed jurisdictions laws, your governing law. That's why a lot of parties choose English law as the governing law. So that's something. So again, it's very different seat arbitration. You need to know the governing law. Ideally, you should know about how the contract law in that country works, because that will be one of the fundamental laws being applied by the tribunal, the arbitrators. So you need to have knowledge of that as well. Finally, language. Generally, it's understood, it's assumed that it'll be the arbitration proceedings will be conducted. So the language refers to the arbitration proceedings language. Generally, it is English, but let's say, we talk about CPEC, Chinese investment, a lot of them, they prefer Chinese. So then you have to sort of mutually agree what the language would be. And then, of course, if it's a different language, let's say Chinese, then you have to figure out, how the translations will work, the transcripts and all that for the tribunal. So that's why it's important. Yeah, model clauses. All institutions have their model clauses, which essentially means it's like a sample clause that any lawyer or any party can just copy off their website and put it in their contract. But this here is, even if let's say you're not picking institution, it still makes sense for you to actually specify all these elements that I just discussed. The number of arbitrators, 1, 3, seat, legal place, city, and then country, language to be used, we just discussed, and the governing law. So I think these are the four fundamental components of an arbitration clause, and you need to make sure these are at least specified in the clause. And if you want to spend more time on the clause, you want to, bill your client a bit more, you can have a longer clause, or you can have more information within the clause. You can even specify some procedural aspects as well. Let's say you pick expedited arbitration, and within expedited, you could say that you cannot have more than one witness in the proceedings. The claims and all the, let's say, answers and rejoinders will not be more than 5 pages long. You can be more specific as well. So it's up to you and depends on the party's own preferences. Yeah, so AAA American Arbitration Association, their center is called the International Center for Dispute. They have this model. I just thought I'll run this by you guys. So this is the standard. They use those 6 magic words as well. So in the event of any controversial claim arising out of or relating to this contract, the parties shall consult and negotiate. So this is a multi-tier clause. Consult and negotiate with a view to amicably resolving the dispute. Recognize that mutual attempt to reach a solution satisfactory. If they do not reach within a period of 60 days by notice of the party, you can demand mediation, and then it's not the complete clause. And then if not reached within 60 days, after service of written demand for mediation, any unresolved claim arising of shall be settled by arbitration. So it's a 3-tier clause. Amicable resolution, settlement. If that fails, mediation. So this is fairly standard. So all those lawyers who can't even draft a dispute resolution clause like this, it's actually quite shameful, because you can get this on the internet, right? You don't have to be an arbitration practitioner to know this. This is basic contract law. I also had a CCAS clause, which is also very similar. Now let's talk about the arbitral proceedings. So the arbitral proceedings, so let's say dispute has arisen, parties have tried to amicably resolve, to mediate, it hasn't worked. How do you think the arbitration proceedings start? What is the first step? So let's say those of you familiar with the court proceedings, you go to court, you file a petition, you file a plaint. How do you think international arbitration proceedings are initiated? What do you think is the first step? I actually mentioned this anyway, but.
You go to the institution with an arbitration clause.
Yeah.
And then they will send a notice of arbitration to the other party, and the other party have to send the response to the notice of arbitration.
And what if there is no institution? Then who do you send the notice to?
If you send a both arbitration, then you directly send to the arbitrator, and through arbitrator.
No, how can you have the arbitrator without the consent of the other party?
You will have it in the arbitration clause.
No, but so that is actually the second step. Appointment of arbitrator happens later. So the initiation of arbitration happens a step earlier that precedes the appointment.
That you can also give a name of the arbitrator.
Yeah, in that case, so yeah, of course, then parties will know. But generally, there is no name, so parties have mutually agree. So in that case, the notice is sent to the other party. In case of ad hoc arbitration, where there is no institution, you send a notice of arbitration to the other party, which is like a legal notice that you must be familiar with. You notify the other party that dispute has arisen, and we are hereby initiating arbitration. So the sending of the notice is essentially a signal that you have essentially initiated arbitration proceedings.
Actually, when the mediation is unsuccessful, then they issue notice for dissatisfactory notice.
Right.
To the other party. That we don't agree with the mediation, and we're supposed to go for the arbitration. And for that, they mutually agreed for the arbitrators.
Right. Yeah, so it is basically a requirement you have to comply with. You have to notify the other party that proceedings are initiated. Appointment of the arbitrator or tribunal happens later, whether it's institutional or ad hoc. So that is a first step. The appointment of arbitrators. So as I said, mutual consent. Again, assuming there is no name specified, you don't know, there is no nationality, so you have to decide. And assuming it's a tribunal of 3 arbitrators, how do you think you nominate an arbitrator? Or do you nominate or do you appoint? There's a big difference between the two. Yeah.
So we can't appoint, it will be one way, we have to nominate, and the 2 parties will agree with them mutually.
Right. Anybody else?
It's actually one party will appoint one arbitrator, and the other party also, and then those 2 arbitrators will select independent.
You look like you practice arbitration on a regular basis, right?
Actually, it's 24/8.
Oh, okay. No, good to know. Anybody else? I think I saw a hand here. No, okay. Yeah, so in the case of 3 arbitrators, there are 2 party appointed arbitrators. So one party, so essentially a nomination, they're essentially suggesting the name of this person. And usually in the case of three arbitrators, the other party does not object to your appointment because they're appointing or nominating their own. So, essentially it's sort of an unstated rule that, unless of course, the appointment is of somebody who's known as somebody who's biased, who doesn't have the expertise, experience, there are major conflicts of interest. So what you should do is when you, let's say you're the aggrieved party, when you send in the rules of arbitration, you should nominate your arbitrator as well. Even in the case of sole arbitrator, you could nominate the sole arbitrator. I suggest, the name of this person as sole arbitrator. In the case of three arbitrators, you say, I suggest the name of this arbitrator as my party appointed arbitrator, and hopefully the other party responds. Okay. So what if it's happened in Pakistan? It does happen. You send a notice of arbitration to the other party, whether it's institutional ad hoc, and they don't respond. Are you supposed to wait for them, or what happens? Yeah.
We can file application of section 20 before the court.
No. So thank you. So that's domestic arbitration. We talk about international arbitration. So in case, so the court will not come to the rescue. It'll either be the institution or the parties amongst themselves. So what do you think will happen, or what should happen? You should keep waiting for the response. And then what happens after waiting? You can proceed. So I think what I'm getting at is ex parte proceedings. So in court you heard ex parte proceedings, right? You can have those in arbitration as well. Actually, interestingly, a lot of people don't know about this, saying how can ex parte arbitration again? As I said, it's very similar to litigation. So in the case of institutional arbitration, the institution will of course specify the time frames for this as well. And you can't wait for the other party to respond, especially the party which in bad faith will try to defeat the whole process. You can't keep waiting for them. So you can have ex parte arbitration as well. If there is no institution, then ad hoc, perhaps I guess you have to wait for a reasonable time period, and then you notify them again that you're going to proceed ex parte, but you have that option as an arbitration. I highlight this because I'm trying to highlight the advantages of arbitration as well, that, people say, oh, but, we can proceed ex parte in court, but you can do that in arbitration as well. Yeah.
If you proceed ex parte in arbitration, how will we decide to appoint the arbitrator if the other party is not cooperating?
I think
I
think you answered your own question. Yes, there is nobody else. So the party gets to decide. Yeah, it might sound unfair. You're literally your own arbitrator, your own decision, but they still have to comply with every single step. There is evidence. So they could still, let's say, render a null award. Like they could give you like zilch, nothing, right? Or they could even decide against you, strictly speaking. Although highly unlikely. But the arbitrator's duty, just like a judge's duty, is still very ethical. Just because our party does not show up does not mean, they will be condemned unheard. Principles of natural justice apply to arbitration as well. Yeah.
Shouldn't the arbitrator's provision be given in the contract itself? Because normally in sovereign countries, when agreements take place, then there is a dispute clause, and the dispute clause decides about that, how it is going to resolve, including arbitration.
Yes, sir. So I referred to that earlier as well, that it's up to you. You can actually specify the number of arbitrators, their qualifications. You can even give their name if you like. That's completely up to you. And if the parties mutually agree that it makes sense to actually have somebody, so let's say in the engineering community, a lot of people know a lot of other people, right? So they say, we trust this person, there's going to be no objection to his appointment, so let's just put his name in the clause to save us the hassle of, or the uncertainty. You can do that. That's entirely up to you.
Yes. There are some international bodies like World Bank. उसको अक्सर एग्रीमेंट में मेंशन किया जाता है कि they are the grantor for this agreement. उनका रोल कैसे देखा जाता है?
You're referring to the Indus Waters Treaty?
Yes, we may say.
So that is a state-to-state arbitration. I am talking about national commercial arbitration, which is like a baby compared to that. So there's three levels. That will be a talk about international investment arbitration. So what we're talking about here is, I guess I'll just put this into context. This is international commercial arbitration, which is between two private parties. There is no government entity involved. International investment arbitration has to have at least one government entity as one of the parties. And what you're talking about, Indus Waters Treaty, it's state to state, has to be two states. So we're not talking about that, so it'll only confuse you. But yeah, whatever the role is specified in that particular agreement. Yeah.
Sir, as per my understanding, the governing law, if it is comprehensive, it should be.
it should include the procedure if the other party is not replying, then what should happen? If the other party is not replying to the notice or not finalizing the appointment of arbitrators, it should be in the international law, the governing law itself.
Can I get some water? No. So governing law has nothing to do with the procedure. So remember, the procedure is governed, thank you, either by the institution's rules, the institution that you picked, or the procedure is governed by what the terms of reference are given by the arbitrator. So in the case of ad hoc arbitration, the arbitrator has more work to do. He could actually specify that, very standard rules for procedure, this is how evidence would be submitted, this is when you have to submit the claim, the answer, rejoinder, they'll give you a timetable. But yeah, governing law has nothing to do with the procedure, with the ex parte, no.
Sir, I say this because I think the UN Charter the other day, and it was very comprehensive, so I'm assuming that all the governing laws are fulfilled.
Which UN Charter, UNCITRAL?
But the UN Charter was very comprehensive. I think the procedural...
No, UNCITRAL model is a comprehensive law on the procedure of arbitration. But that will come into play if you have specified UNCITRAL model. It can't just, apply to your arbitration if you haven't chosen that particular law. In international arbitration, if you haven't picked institution, a lot of the times, you're right, the UNCITRAL model law governs the proceedings, almost by default. Although, of course, arbitrator can specify that as well. But we're talking about a case in which, ex parte proceeding, I'm talking about a principle. Even if it's not specified, that is how arbitration works. You can proceed ex parte within the discretion of the tribunal. They'll give it some time, but the aggrieved party has the right to proceed ex parte. Okay. So appointment of arbitrator sometimes takes a long time. There's a lot of back and forth, objections, whether sole arbitrator, party appoint, because when party appoint arbitrator, then you have to appoint a third. In Pakistan, they call umpire, but they call chair or president of the tribunal, like international arbitration. So it takes a long time. So take the example of the recorded case. Again, that's investment arbitration. But there's a lot of back and forth in appointment of the arbitrator as well. Pakistan raised objection to the impartiality of one of the arbitrators. So it can take a year, 2 years sometimes as well. So although it seems like a small step here, but it's a pretty cumbersome process sometimes. Preliminary meeting, conference. So the first thing that happens after the appointment of the arbitrator, another thing that you need to do when you accept appointment, if there is any conflict. So by conflict, I mean, if you have actually been a counsel, a lawyer for one of the parties, you've advised them in some capacity, you worked with that company in some capacity, let's say you're not a lawyer, and you have to disclose all those potential conflicts as an ethical arbitrator, right? Because we're talking about impartiality, we're talking about, independence. So you can't have an arbitrator who's actually worked with or been associated with one of the parties, because most likely it is human nature. Even if they say, I'll be impartial, I'll be independent, in the back of their head, you never know. They could be more inclined to decide in favor of the other party. So they're obligated to disclose all the conflicts. That's what a good arbitrator does. Because it's sort of a value judgment. It's very subjective. People say, I didn't think it was a conflict. I'm very clear in my head. I'm a man of good conscience and all that. Nobody buys that. So it's good to have this in writing and disclose all the potential conflicts. And what happens is generally other parties respect and appreciate it, and they let that person be the arbitrator, because he's being honest about his conflict. So you need to do that as well. In terms of procedure, so just the way when you go to court, you file a petition, application, plaint, you file a claim. You're the claimant, the party that initiates the proceeding. So you have to draft a fairly comprehensive claim. Again, this is not a class in drafting, but people think that, drafting an arbitration is, again, some rocket science, something that is a preserve of foreign lawyers. I think the big difference is the claims are much longer. Yeah, please go ahead. जी ऐसे ही So we need to get over that. That was my point. So the claims would be, let's say, 80, 100, 200 pages long. Like investment arbitration, perhaps even longer, but even commercial arbitration, depending on the nature of the dispute, they're much longer than your typical court petition, which are like 8, 10 pages. And so it's longer, but the substance is essentially the same. You have a claim, you give the facts, the factual background, the reasons for the dispute, the law, the evidence, all those things. You have exhibits. So it's very similar. So the reason why I keep giving this comparative analysis with litigation is to give you confidence and encouragement that you can be arbitration practitioner. Somebody says arbitration, you're like, I don't know how to do arbitration. So as counsel, if you have done litigation, it should be very easy to make the switch. And as an aside, I think a lot of the international arbitration practitioners, Goras or Desis, had absolutely no experience in international arbitration until 15, 20 years ago. I won't name names, but I know a lot of people who were just active litigators and they made this switch in a very seamless way because the skill set is the same. So not to get into the detail, but the claim is very similar to, let's say, petition plain. It's longer, the structure is slightly different, but the substance is essentially the same. There's a prayer, you claim damages, all those things. So that is very similar. Written submissions, document evidence. So in arbitration, it's fairly common to have written witness statements because they think it saves time, because it doesn't make sense in a lot of arbitrations to actually have examination in chief, have the witness and then examination in chief and then cross-examination. So it's pretty much a given that you'll have written witness statements. Now, written witness statements, so it's a bit controversial because a lot of people think that the lawyer should not be advising on the draft of the witness statements, but a lot of them do, and they admit it as well. They say there's nothing unethical about it because the witness is a layperson who doesn't know the legal implications of his statement. All his views are reflected accurately in the statement, but we just sort of brush it up to make it more presentable for the tribunal. So you have to be careful. You're basically not drafting the witness statement for the witness. You're essentially tweaking it to make it more coherent. Otherwise, you sort of cross the line, it's wrong. You can't have a witness who has nothing really to say and you are basically the mouthpiece, you're the one who drafting it. So you have to be careful with that. So again, witness statements, you can find templates, standard drafts. It's not very difficult. I think even some court proceedings, sometimes you can have written witness statements as well. So you can cross-examination, of course, that is something that is done in person or of course via Zoom, virtually. And just to give you an idea, so in international arbitration, even with domestic arbitration, but more so in the case of national arbitration, guess how many hearings you have in a standard international commercial arbitration proceeding? Just guess how many? Okay, anybody else? How many hearings do you think? A few dozen? Wow. You must be an active litigator then, who likes to have a lot of hearings. Anybody else?
It could be 10 to 15.
Okay. I hate to break it to you, but it's usually 1 or 2. Actually, you should lawyers don't like it, but parties do. So the reason why I bring this up is because usually, and of course in arbitration, you can also have documents only arbitration. You can have, so I was involved, it's actually concluded in the Dubai International Arbitration Center arbitration, and we requested the tribunal, we don't want to have a hearing to save time, money, and we didn't feel the need, right? So again, procedural flexibility, you're designing the procedure yourself. You have the luxury, subject to mutual agreement, to have all these things because you think either they're not required or they save you time or money. So in a national arbitration proceeding generally, so you can have more hearings when, of course, you're looking for an interim award, like a decree, right? So in a recent case, we need interim awards because, the other party had initiated proceedings in the civil court here. So we wanted to bring that to a stop. Then we got interim awards. Then, of course, you need hearings because as a separate application, interim relief, you need to have a hearing. But generally, if you don't need interim relief, usually there's just one final hearing. And usually the way it works is there's this, they book a venue for 1-2 days and hearing goes on, in which the main things that need to be done at a hearing are cross-examination of witnesses and your final and closing submissions, arguments. Okay?
Actually, mostly document examinations are used in this arbitration. This cross-examination of witnesses are really
rare, yes. Yes. Anybody, I think somebody had a question?
Sir, can we file a separate application for relief, like...
You have to file a separate application, just the way you do it in courts. Huh?
Without going this room?
No. Okay, so yeah, I'm glad you raised this though. So let's say So there's a concept of an emergency arbitrator, which, as the name signals, means that there's an emergency, you don't have time, even let's say 3 weeks to appoint an arbitrator, right? So what do you do in that case? So what he's saying is you can do that. So, for instance, SICA and all institutions have provision for emergency arbitrator, which basically means he or she can be appointed within 24 hours. You don't have to do a back and forth. The institution will mandate, they will have the rules that emergency arbiter will be appointed within 24 hours, and the institution does it for you. I don't know how it works in ad hoc arbitration, but yeah, that's where there's a problem with ad hoc arbitration, because you won't know where to go, which rules to follow. But you can, you have discussed with the other party that we need to have an emergency arbitrator, because let's say some assets, there's apprehension of them being disposed of, and we can't wait for the arbitrator to be appointed and then seek interim relief. You can have an emergency arbitrator, and that person will be appointed only to the extent of that particular issue. Once that interim award is given, that person leaves. He or she has nothing to do with the rest of the proceedings. So you can do that. Again, so if you have institutional arbitration, it'll be easier. Yeah.
Sir, is a decree as binding as I do?
I think decree is more binding because people think that, you know, whatever the courts say has more weight. I agree with that. And the reason for that is, so the term is coercive power. Courts have coercive power, which basically means they have the ability to have their orders implemented, or they can punish the offender for not complying, right? Contempt of court is an offense, right? Arbitrator doesn't have that luxury. They don't have the power to coerce the parties to comply with the order. So that is where, yeah, decree has more weight than a... So a foreign decree and a foreign award? See, foreign decrees, I can speak for the UK, and I think we have with these bilateral agreements with the UAE and I think 1 or 2 other countries. The advantage is that, of course, CPC has provision for the UK decrees. You can follow that, but again, I won't name the judge, but that judge even, you know, refused enforcement of a UK court's decision. With arbitration, so I'll give you an example. So recently I was in the High Court. It would have been actually breaking new ground. To my knowledge, there has never been a recognition enforcement of a foreign interim arbitral award, right? So the law is a REFA, Recognition Enforcement of Foreign Arbitral Awards, 2011 Act. Under that, you can apply to the High Court for enforcement. Again, enforcement comes later, so I don't want to talk in detail. But it defines foreign award as an award, you know, rendered by a tribunal and all that. But there is no distinction between partial award, interim award. So that's what I argued to the judge, but he wasn't convinced. So I think based on that, it might be more difficult for you to enforce an interim award as opposed to, let's say, a foreign injunctive decree, because, you know, courts are taken more seriously. So, all right. So you've done the cross examination. Cross examination, of course, is one of the most exciting parts of any proceeding. I think a lot of lawyers, you know, dig that. You know, they become lawyers too. If you watch that movie, A Few Good Men, in which Tom Cruise grills that witness, so I think a lot of people decide to become lawyers after watching that movie. So cross examination, of course, is very similar to litigation as well. You have a witness, you grill the witness, you try to extract some, you know, adversarial information, some incriminating information. It happens in international arbitration as well. It depends on how many witnesses, and then of course you present your witnesses as well. I think that is very similar. I think the only one big difference is that, you know, you rely heavily on written witness statements, which are then cross-examined. Another thing I want to touch upon is expert evidence. So in technical disputes, so let's say construction disputes, as I said, so what the tribunal does sometimes is, so let's say if it's a sole arbitrator who's a, let's say, retired judge or practicing lawyer who doesn't have any technical background, they would like to have an expert witness to give a report and findings on the technical issues. So what that does is that it saves parties the money of having, let's say, 2 more arbitrators and having one with technical background. So that expert witness can actually fill that void of having a technical person on the tribunal. He can provide relevant information of the technical aspects of the dispute to the tribunal. Now, who chooses the expert witness? It could be appointed by the tribunal, but generally what happens is, you know, both parties bring their own expert witnesses. in larger disputes. One party says, I'm going to engage this particular expert witness. He or she submits his report and the other one. And of course, not surprisingly, the expert witness appointed by one party, his report is slightly more favorable to that party that hired him. But they can be very creative. Just like lawyers, they can be very creative with their findings. I am not saying they're unethical, but end of the day, it's not all objective. So the subjective aspects get a bit tweaked. But then it's up to the judge to decide. Sometimes, the arbitrator. Sometimes the arbitrator actually interviews both the experts in one hearing, in one session. He or she asks them to actually come before the tribunal, and then they fire off questions, and then they cross-checking the answers with them, and then they agree on that, because the expert witnesses' reports are not binding on the tribunal. They can cherry pick, they can pick and choose, because if they think that the person prepared the report in bad faith, they can perhaps not rely on the entire report and just on the reliable parts as well. All right, oral hearings, as I've mentioned. Award, yeah, that comes in the end.
I have a question.
Yeah.
An expert witness can be crossed by any party?
Yes, they are crossed. Actually, it gets pretty ugly sometimes, because they really go after the expert witness of the other side, and yeah, I've seen some pretty nasty proceedings. Yeah, tribunal, we talked about number, qualification, independence, challenges. I'm actually trying to sort of move things along. I think we have about 30 minutes left. Okay, challenges. Now challenges, so I said arbitrator is supposed to disclose any potential conflicts of interest, but you can challenge as well, which happens a lot in Pakistan, international arbitration. You challenge the arbitrator. Why? Because you think either he or she is not qualified, or they're from the same country, or let's say you find an award. You can't find international commercial arbitration award, because again, the one difference is for international investment arbitration, the awards, a lot of them, or large parts of them, are published because it's public international law. But for international commercial, you can't find international commercial arbitration awards because it's confidential. Okay, so you can look those up as well, and say, okay, in case of investment arbitration, that this person, let's say, always decides in favor of the telecom companies, or always decides against the automobile companies. It could be like a bias towards an industry as well, right? So you look at that as well. Yeah, jurisdiction and powers of the arbitrator. So there's this principle called competence, which basically applies to courts, and surprisingly for you guys, to arbitrators as well, which basically means that the arbitrator, just like a court, can decide its own jurisdiction. This is when you go to court, you try to challenge the jurisdiction, they say, we can decide our own jurisdiction, right? With the same arrogance, an arbitrator can do that as well. They can say, we know our jurisdiction, which a lot of people find surprising. People say that, so let's say in the case, you say that when the agreement was being drafted, the signature was forged. It's not a valid arbitration agreement, okay? Or let's say the entire contract is not valid. It's tainted with fraud. And you say, which is why this tribunal does not have jurisdiction. The whole contract was illegal, right? Now, so there's two concepts. One is called the separability doctrine, and the other one is competence, which basically means that an arbitrator or tribunal can decide their own jurisdiction. Parties, even if they challenge, the ultimate authority decision lies with the tribunal. They can say, yes, you're right, we don't have jurisdiction, and they can say, in most cases which they do, that we have jurisdiction. Okay, and the separability ties in with this in this way. So the concept is that even if the entire contract is alleged to be illegal because of, let's say, an unauthorized person signing it, or forged signature, any other reason, you can separate the arbitration clause from the agreement, assuming it is part of the contract. Generally, it is part of the contract. Some people have separate arbitration agreements, but generally it's part of the contract. You can separate that arbitration clause from the agreement and deal with it in and of itself as a separate, distinct agreement. Okay, so if you separate that, even if the contract you think is illegal, that particular clause is legal, therefore the arbitrator's jurisdiction is legal, and they will then decide whether or not the contract is illegal or not, and whether they can proceed with arbitration. Okay, so competence, and these are two principles that tie in with the jurisdiction of the arbitrator. And power, oh yeah, sorry, go ahead.
So I understand that separate principle is to the jurisdiction to the tribunal to find the debt that has been reached. But what's the point of any arbitration? The home tech is doing. What's the point of having
No. It's not about what's the point of having. It's about defeating all those bad players who never want to resolve a dispute, whether it's litigation and arbitration. I'll give you an example, which is sort of distinct possibility in a lot of cases. One party that has wronged the other party, most likely the party which is in breach, would never want to have the dispute resolved because they know most likely they will lose the case, right? If that is the case, they will come up with very creative ways of challenging the arbitration clause. So the whole purpose of this is that for those parties that don't want it to be resolved, you're giving them one less reason to challenge the arbitrator's jurisdiction, because if there is no separability doctrine or competence principle, I can't speak for Pakistan, I shouldn't be, but I think maybe 50% of arbitration would never proceed, because the party that is in breach will be like, oh, this is tainted, you have no jurisdiction. So what is the point of having arbitration? Everybody will then end up before the courts. So that is the rationale for giving the arbitrator's issue, because you trust the arbitrators more than you trust the party that is in breach. Because the party that is in breach will come up with a lot of ways to challenge. So that is the rationale for this.
if the contract is void of issue, for example, it was made by paying the driving amount then it means that the arbitration clause in the contract is also. So market is not like we have to do this separability principle, the market is to restrict that.
That's a good question, and that reminds me of the black spots in Pakistan's international arbitration jurisprudence, the Rekode case and the Hapko case. This is exactly what happened, and I completely disagree with the Supreme Court's judgments. And the reason why, so this is an evolving issue. It's a controversial issue whether or not arbitrators can decide issues such as fraud, bribery, irregularities, right? Because they're criminal offenses, right? So as a general rule, tribunals don't have jurisdiction over criminal matters, because crime generally is, it's committed against the state as well, so it has to be within a public domain, right? That said, in a lot of cases, arbitrators still have jurisdiction to initiate investigation to confirm whether or not there was bribery. They can find out as part of the process, as part of determining their own jurisdiction. Okay, and until that is decided, in parallel they can still proceed with those proceedings, because on the assumption that they still have jurisdiction, they can still continue. And a lot of times what they can do is they could say that a public authority can deal with the bribery allegations, and as far as the commercial issues, maybe they won't be the, let's say, 10 issues in dispute. Maybe they'll say these 2 issues there is no connection with the bribery allegations, and we can perhaps decide these. So they can do that. But I see your point, and this is more relevant for your next session, investment arbitration, because whenever state gets involved, a lot of times kickbacks, procurement, all that comes into play. It's not very relevant. It is somewhat in commercial arbitration, but not so much. But yeah, to your point, they still have jurisdiction to even decide whether or not this bribery was committed based on some investigation, or based on the judgment that this is a frivolous allegation, and there was based on the evidence before the tribunal. Of course, there will be evidence, because the party which claims that there was no fraud will still present evidence, and they can decide on that as well. So it's not that they don't have jurisdiction at all. They can still say, on the face of it, prima facie, it seems there was no bribery, we can proceed.
Just for clarity purposes, when we talk about contract law, there's a rule called contract referendum. I guess it's the person who drafts the contract is, if there's an ambiguity or any issue, the person who hasn't drafted the contract gets a little bit of benefit of the doubt. So does that rule apply for arbitration as well? If there is an ambiguity in the agreement regarding anything, will the arbitrator be supposed to be neutral? Will he give any sort of benefit of the doubt to the party who hasn't drafted it?
Yeah, so it depends on whether or not this principle is either part of the governing law of the contract, right? Or parties have said that, let's say the arbitrator has the power of, it's called amiable compositor, which essentially means the powers of equity as well, that the arbitrator tribunal can decide under equity as well. It can be an equitable decision, which has no basis in law as such, right? So if you're relying on principles which are not part of the law, of the governing law of the contract, yeah, perhaps they can apply it, but I haven't come across any such instance, partly because when the contract is drafted, there is no sort of a name on the contract that this was drafted by this particular law firm, this particular party, both parties sign off on it, so it's not like one party owns it more than the other. So at least in international commercial arbitration, I haven't seen this issue come up. Yeah.
Assalamu alaikum, sir. My name is Umar and I'm a graduate of NUST and now I'm enrolled in London School of Economics. Sir, I do not have a law background, but I would like to ask a question of an international dispute. Philippines recently went to International Court of Arbitration and clearly said that China is not abiding the United Nations Convention Law of Seas because of the South China Sea conflict. And the court gave the judgment in the favor of Philippines. But sir, China rejected it. So does it raise a question on the credibility of the judges of the court, or is it China who is violating the international law? Thank you, sir.
Yeah, so international law, unfortunately, it's not binding, right? That's one of the issues with the international, generally, broadly speaking. But yeah, if you are subject to certain jurisdiction, you submit to jurisdiction, then you have to abide by, comply with the decisions. So I would support the International Court of Arbitration, because I think if the Chinese had decided to submit to their jurisdiction, they need to abide. If they're dissatisfied with the decision, they should figure out a way to sort of challenge it. But if there is no provision for that, they have to comply with it. So I think, as a lawyer too, I think that the default or sort of the gut reaction is that, you trust the judiciary or the arbitral tribunal more than you trust one of the parties, especially the parties which is either losing the case or has already lost the case.
Sir, as we are heading towards a more bipolar situation, where Moscow and Beijing are applicants for London and Washington, and where we talk and Huawei are being facilitated for the channels. Please, जब हम देखते हैं कि ये जो चीजें arbitration का मामला है कि उसमें ज़्यादा जीन्स के खिलाफ पाकिस्तान ने कोऑर्डिनेट को कॉपरेट किया था और इस साइड सेंटीमेंट को पाकिस्तान में हुए और इसी तरह अमेरिका में एंटी चाइनीज सेंटीमेंट्स बढ़े। तो जब ये आर्बिट्रेशन का चीज़ें जब बिजनेस इनके दरमियान जो कॉन्ट्रैक्ट्स हैं और ये एक हमें ज़्यादा एक बाइपोलर वर्ल्ड की तरफ लेके जा रहे हैं जहाँ पे ज़्यादा मीट कॉस्ट हो गई और सेंस ऑफ इनजस्टिस है ऊपर ट्रेड्स को ज़्यादा नुकसान। So why does the arbitration exist when it can lead to a third world war or a new world war?
Yeah, arbitration isn't that bad. You think it's going to lead to a third world war? It's a bit of a stretch.
It can stop one.
It's about resolution, not escalation of. Yeah. No, so I'm sorry I have to cut you off because it's not really part of the discussion. We have about 20 minutes left. So quick response. Yeah, I've heard that as well. Conspiracy theories, controversies. I do get it. But I mean, my response to that is, I think I was chatting with my colleagues before the start as well, that, if you want to beat them at their own game, you need to be better than them, right? And how do you get better? I was reminded of Sir Syed Ahmad Khan, he said you have to learn English to actually compete with Indians, right? You can't just be like, keep complaining. So my point is, my realistic view is there is no better option than international arbitration. I'm talking about commercial arbitration. Investment arbitration is controversial, yes, I know. Even in South America too, a lot of them have, denounced exit and all that. That is happening. Maybe some of the decisions are unfair too. But international commercial arbitration is the most popular method for dispute resolution across the world for cross-border transactions, trade and investment. It is not controversial because it doesn't involve governments. But when governments come into play, then it becomes controversial. And yes, I think politics come into play as well, but yeah, it's not as bad as you think. Okay. I think we've discussed, so these are the different types of laws that come into play in international arbitration. Government law, of course, we discussed. Now, in some cases, you could have a separate law governing the arbitration agreement as well. Maybe that ties in with the discussion about the separability doctrine. You could say this agreement wasn't part of the main agreement anyway, so even if you think the main agreement is illegal, there's a separate law that governs the arbitration agreement which will decide its validity, seat, procedural rules, and enforcement jurisdiction. I think we need to get there quickly as well. Yeah, so quickly skim through this. Institutional arbitration, these are the advantages of institutional arbitration over ad hoc arbitration. So there is pre-established rules, very clearly laid down, streamlined rules. You know, you don't have to worry about the arbitrator figuring out what the timetable should be, how should the examination be done, when it should be done. Professional. So every arbitration center has a secretariat. So secretariat is like the registrar's office at the High Court. So what they do is they manage cases. Not the way management is understood in Pakistan, not that kind of case management, but from start to finish, they ensure there's like a smooth, seamless flow of how the proceedings are conducted. A system with the appointment of arbitrators, of course, if there's disagreement between the parties, time is being wasted, then they step in to appoint the arbitrator. You don't have this luxury in ad hoc arbitration because then you're like, let's go to the court, as ma'am pointed out as well, especially with domestic arbitration. It's ad hoc arbitration. There is an institution like, let's go to the court and you request the court to appoint an arbitrator. So you save all that hassle and time by adopting an institution's rules. Panel of arbitrators, most institutions have their panel as well, from which you can pick somebody, an industry expert, a lawyer, retired judge. So they have their panels as well. So these are the advantages of choosing institutional arbitration over ad hoc arbitration. And the only downside that people see is the additional cost of the institution. For international arbitration, yeah, it is substantial, but I think it still would be less than like 5% of the costs that you have to pay to the lawyer and the arbitrator. So I'll give you an example. In a recent case, this international firm I was working with, they charge around $2 million US as their lawyer's fees. Of course, we don't know the arbitrator's fees because that person was appointed by the institution. And the institution's fees were perhaps like 10,000, 15,000. So institution fees aren't a substantial component anyway. So, and here in Pakistan, of course, you could offer a discount as well to people if that is a concern. But that is the only downside, the additional cost. Otherwise, there's nothing wrong with institutional arbitration. Generally, it is better than ad hoc arbitration. But we're trying to promote it here in Pakistan through SICA. We're trying to create that culture here. Okay, now, so this is sort of the final phase, arbitral award and its enforcement. Yeah. So once the award is rendered, let's say decision is given, I think I'll talk about the New York Convention here as well. So let's say the arbitration was seated in London, the tribunal, 3-member tribunal rendered an award, and it's in favor of Pakistan. Let's think positive. What do you think the other party, German party, would do if it does not want to comply? In an ideal world, as I said, they would say, okay, tribunal, we have to pay, let's say, $1.5 million US to the Pakistani company, let's say textile manufacturer. But they say, no, we're not going to give it because of this particular reason.
In an ideal case, it should be isolated in the international arena, or in the worst case scenario, it becomes a prior state.
Who becomes a prior state?
Germany, which does not comply.
No. It's a company in Germany. The state of Germany is not involved. It's just a.
So the company gets isolated.
What do you mean isolated?
Sir, it cannot. The other companies stop their contracts. Do not continue with
It is confidential. Nobody knows about it yet. You haven't gone to court yet. You will probably go, and I'm getting to that. It's confidential. Nobody knows about the decision. It is not being blacklisted. And it's being supported by the German Chamber of Commerce. The Berlin Chamber of Commerce is supporting them like, we'll support you. We don't give Pakistani party a single dime.
Sir, if the rules are stated, then the governing law, or whatever the reference is, it should be followed. And if they are mutually agreed, then whatever was agreed, that should be followed.
So if both states are...
No states, parties, the no states. States will come later in the next session. It's a Pakistani textile manufacturer, I don't know, Al-Karam come up with the name, German importer of textiles.
They can contact the Chamber of Commerce with that industry registered, and they can dispute that award.
That's what a lot of lawyers in Pakistan do, unfortunately, yeah.
Sir, it is asked to give preparations, whether or not it gives, that's another question.
Okay, so let me rephrase the question. What I'm trying to get at is, I said there is no appeal. There is no appeal mechanism. You can't appeal an arbitral award, but you can challenge the award. How do you challenge the award and under what grounds? And this is part of the discussion of the New York Convention as well, because I heard a comment, yeah. Yeah, 5 plus 2, yeah. Right.
And if it's related to public policy,
or if due to the lack of staff, it's easy payments, they can submit.
Okay, so you got that. So there are grounds for challenging. So I talked about the benefits of international arbitration, and one of the big benefits of international arbitration is the New York Convention for the recognition and enforcement of foreign arbitral awards. There is no such convention or treaty for international litigation, for court decrees, court judgments. There is no such thing, especially which has been ratified, signed by like more than 150 countries, right? And I bring this up because some people are very opposed to international arbitration. I'm saying this is why it is the most popular method for international commercial dispute resolution, because of its recognition around the world. And once you have a decision, you don't have to worry about going to a local court to get enforced, because of the New York Convention. They've already accepted how it will be done. But the New York Convention, Article 5 lists 5 grounds. 5, and actually, the sub-Article 2 has another 2 grounds for challenging. One of those grounds is, as you mentioned, incapacity of the parties. So let's say, in our case, the German party, because Pakistan has won, right? So the German party is thinking of a challenge. They're saying, by the way, when this agreement was signed, it was signed by the assistant of the secretary of the CEO, who did not have the authority or the capacity to sign off on that agreement. Therefore, this party didn't have the capacity, and it's the entire proceeding is invalid. Another ground is the party could say that I did not get proper notice of the arbitration proceeding. In courts, you have to send a notice, and you have to send another notice, and all those. In arbitration, you have to do that as well. I think 2 or 3 times is fairly standard. But the party comes back from the dead and says, "Oh, what was going on these 2 years? I wasn't aware. Proper notice wasn't given." Then, of course, you have to make sure you have proper proof of the notice being given. So that is one reason they could say, principle of national justice violated, condemned, unheard, we couldn't appear. Another ground is composition of the tribunal. They say, the composition wasn't in line with the parties' agreement, their preferences, it wasn't in line with the procedure we agreed to, or the rules that were applicable, or the law of the seat of the arbitration. The composition of the tribunal, or some part of the proceedings did not comply with those, with the parties' will or the law. Another one is, hang on, I think this is probably the only thing for which I have to refer to my notes, because it's a arbitral misconduct. Yeah, so technical, hang on, this will be quick. So there's 2 more. Yes, going beyond jurisdiction. So the decision or the award covers an issue which is not within the contemplation of the parties. It was not before the tribunal to decide, right? So let's say the issue that the tribunal decided was, how soon can, they're supposed to say that the German party has to pay via a bank account, which is located, let's say in Dubai, right? So they specify the payment method as well, and German party says, the issues before did not include the specific payment methods. You went beyond your jurisdiction, something like that. That could be grounds for challenge. Otherwise, award is not yet binding. So this is where I'll talk about the seat of arbitration as well. So as I said, you challenge the award, or the German party will challenge the award at the seat of arbitration as a first step. Seat of arbitration was London. They lost the case. They went to the competent court in London to challenge the award, right? And while the proceedings are going on for the challenge, the Pakistani party goes to Frankfurt, to relevant court in Frankfurt, because in Frankfurt, the German party has a lot of assets. Let's say they're headquartered in Frankfurt. They say, let's go to the court in Frankfurt to enforce this award. The German party will come there and say, Your Honor, that we have actually challenged this award in the court in London. The challenge has not been decided yet. It may well be set aside. Therefore, you wait. So that is another possibility. And there's 2 more grounds that they specify. There's also part of the Article 5 of the New York Convention. One is public policy, as rightly pointed out. So what is public policy? I won't get into the detail, but unfortunately we've had a bad experience with public policy as well. It is the crutch that is used by a lot of the courts around the world to defeat or obstruct enforcement of an arbitral award. It's a very vague, very broad term. It could mean a lot of different things. But I'm here at a think tank which is all about public policy, so you're more qualified to understand what public policy means. But something, that they say is in violation of public policy, you will not enforce. Again, this is I think it's an abstract term. It needs to be defined a bit more clearly, but this is one grounds for the challenge. So for instance, in a Muslim country, they could say, in arbitral awards, they can actually add interest as well. They say, if the payment is not made by this time, you have to pay interest. So let's say you go to, Saudi Arabia or another country, say this is riba, this is interest, this is haram. So if you recognize and enforce this arbitral award, this would be in violation of our country's public policy, right? So that's one example. Another one, the final one is the subject matter is not arbitrable. I discussed with you criminal matters. In a lot of countries, even family matters are not arbitrable. So they could be very creative with it, this subject matter could not have been arbitrated. Therefore, it's not. They went beyond their jurisdiction. Therefore, this is an invalid award, and you can challenge it on those grounds. So we have 5 minutes left. Any questions? I know I'm rushing through it, but so New York Convention, as mentioned earlier as well. So the two primary principles, overarching objectives of the New York Convention are, of course, one is to make sure that courts refer matters to arbitration, for which there is an arbitration clause. Unfortunately, Pakistan, a lot of times, there is huge jurisdiction of matters which should be referred to arbitration. So New York Convention is encouraging courts around the world to refer it to arbitration, unless, of course, which in law, of course, can be a very powerful word, unless, because then the courts decide, oh yes, this is void, this is null. And the other one is, of course, obligational conduct to recognize awards as binding. So basically what the New York Convention does is it's encouraging states that have signed, ratified it, to enforce an international foreign award just the way they would enforce a domestic award. That is what the New York Convention essentially accomplishes. UNCTAD model law, I wish I had more time to discuss this. So our center is actually has been granted observer status for, so UNCTAD is the United Nations Commission on International Trade Law. So what they do is they work on modernization, reform and harmonization of international commercial and trade laws. So Alhamdulillah, our center has been granted observer status. We get invited to 3 of their sessions every year, New York and Vienna. We're the only Pakistani private organization that attends those sessions. And what they do in these sessions, they discuss new laws to reform and modernize commercial laws. And of course, they have this model law on international arbitration as well, which I think somebody was mentioning, has very detailed provisions on the procedure. So unfortunately, UNCTAD model has not been enacted in Pakistan yet. We, from the center standpoint, are trying our best that it should be enacted, because any foreign investor who comes to Pakistan would know that, since Arbitration Act 940 has no provisions regarding international arbitration or procedure, we need to enact the UNCTAD model as well, because it has very clear set of provisions regarding procedure as a standard. Okay, I wanted to, instead of having a thank you or any questions on the last slide, I figured I might as well have powerful proverbs. So this is one of those proverbs or lines that I almost live by. The best time to plant a tree was 20 years ago. The second best time is now. So the reason why I have this up here is because I think we talk about change, we talk about changing our mindset, culture, which are tough battles. I think we're here today. I like to think that we are hearing IPRI and SICA are sowing the seeds for the promotion of arbitration, for its understanding, for spreading the wealth of the knowledge of arbitration. Because I think, I won't get into the detail, but we've made some mistakes along the way. We've lost, unfortunately, huge cases. Not entirely because of our own incompetence, but I think because of our disregard for international law and, sort of our blind indifference to international conventions and treaties, and I think that has to stop. And you guys are all, much younger than me too, so the idea basically is, I didn't have the privilege of attending such a session when I was your age. So I think you guys are lucky in that sense, and hopefully the idea is that, having attended this session, I don't know what your takeaway is, because again, I try to have an engaging session, because I think to me it's not about what I teach, it's about what you learn. So I'm hoping that in these 90 minutes, even if you understand and retain maybe 20-30% of what I've taught you here, I think my job is done. So hopefully that'll help pique your interest in international arbitration as well, and I encourage people to join it. Tomorrow we'll have a very interesting chat about careers in international arbitration, and I'm excited about that because I think I want to sort of break this myth about international arbitration being very difficult to break into. So we'll have a chat about that. But yeah, so I think hopefully we're planting a new tree, and hopefully it'll grow and we will do good things with it. And on this note, I'd like to thank IPRI once again. It's a pleasure to collaborate with them. And hopefully you've enjoyed the session, and I wish you all the best.
Next coming July month is the ideal month plant with the seafood. So you can add one
Sure.
July is the ideal month, March, and July is the ideal month for planting trees. So
We can have our own billion tree tsunami. All right, thank you.
thank you.
Very erudite lecture. Now I will invite you all for a 15-minute break before we have a lecture on international investment arbitration by Dr. Elizabeth Raja.
आपको दो फैन भेजिए, एक तो रिपोर्ट अच्छी है। मेरे पास बैक कर तो हेडर ठीक है, ये एक लाइन में सचा मोहर वाली कॉल भी हम मुश्किल गलत दे देंगे ठीक है। हाँ नहीं सुकून से ये जब बिहार से डॉक्यूमेंट दिखाना है बिहार से अप्रूव कर दो उसके स्टॉक आपसे मांगेगा उसे ही करके मैं निकल रहा हूँ फिर कल चला
ये हाँ ये पेन है तुम्हारे पास? एक्सक्यूज मी, पेन चाहिए। ये तो वो है। अच्छा हाँ ठीक है, एक और पेन चाहिए। लेकिन
क्या वो जो है फिर वो आपको चल गया ना अपडेटेड वाली वो आ गई हाँ भाई क्या चल रहा है आज जो चला है ना बड़ा शोर लगा है प्रेजेंट तब क्या क्यों किस बात पे तिलावत पे अच्छा सही जगह चल रही है मैं जवाब में दिया मैंने कहा बाद में जब बुलाएगा तो सही बात है पास की तिलावत ये भी साथ है कल मैंने डीए को कहा मुझे बताओ तिलावत कहता डायरेक्टर से पूछिए और डायरेक्टर तो आ जाया नहीं हमारा मैं किसे खैर मैं तो मैंने कहा जाहिर है वो पढ़ने पढ़ाने से उसमें तब गया कि नहीं ये नहीं हमारे बार यही लगा देते सही तो पाया ये चक्कर है सारा दिन पहले इसने फ्रेश कर दिया हाँ पहले पहले जैसे खत्म हो गई है ना मुझे बुलाया ऐसे डीए बुलाया चलाता हूँ जब बुलाया सही करना आज नींद नहीं आई होगी गला जागता ही रहा वैसे आज भी अच्छा तेरा लेकिन आज बोरियत नहीं थी टेंशन तो फ्रेश हो गया है आज फ्रेश मतलब 2-1.5 घंटा बैठे फील नहीं हुआ वो मीटिंग हो गई आपकी हाँ अभी खत्म यार वो मेरे सामने तो कलर पेंट देने हैं टी ब्रेक लगाया हुआ सामने भी आ रहा है उधर तो नहीं आ रहा यूट्यूब पे जा रहा है वो पावर पॉइंट है हर तरफ बताया होता है ना सही है अच्छा हाँ मुझे फैजान ने क्या भेजा वो कितने मिनट चली इनकी मीटिंग हम भाई दूसरे बंदों को खराब करने वाले खराब किया यार असर भी बताएगा क्या हुआ थैंक यू सर आप कोई लिफ्ट नहीं आज जी जी प्लीज प्लीज सर प्लीज आज कोई लिफ्ट नहीं है मुझे थोड़ा सुधार बेटा बोल रहा मेरे को पता चले कौन सवाल कर रहा है किधर से कर वो मेरे ख्याल से क्रॉस क्वेश्चनिंग थी ना,
बीच में ही शुरू हो
क्लास
गया था
वाला
ना,
था।
वो उसी वजह से तो
वो मुझे बार बार गए, मैंने कहा मैं किसको पकड़ूं, मेरा दिल था मैं किसको पकड़ा दूं, पकड़ यार आगे नहीं
पकड़ा देना तो पकड़ जाएगा।
पता है क्या था, क्वेश्चन शुरू कर रहे थे ना, 5 जो ना आधे से ज़्यादा क्वेश्चन हो चुका
हाँ वो जाएगा, वो बीच में शुरू जो हो रहे थे।
फिर मैंने इसको आगे दे दी, मैंने कहा रख दिया।
एंड में ही होना चाहिए ना क्वेश्चन आंसर, वो जो बीच में होता हो तो फिर मना किसी का।
इसको यार दोनों सीनियर बंदे हो, हम दोनों तो उसको कुछ कह नहीं सकते, आप दोनों उसको मिलो जरा बात करो उसके साथ भी। जेएस बैंक वाला आज क्या अजीब इत्तेफाक है,
कल भी यही
निकल तो नहीं आज ही,
2 दिन है ना,
3-4 है, 3-4 2 को वो था कल जो हो गया, भाई तो मुझे 2-3 नजर आया, हो सकता है
कल वाला तो अलग था।
वो यार गुस्से की गेड़ी कल तुमने 2 वाला देख लिया, आज 3 वाला यार फुल हो गई यार, फुल हो गई हो जाता है। आज बड़ा अजीब इत्तेफाक है, चाय चल रही है, बंदा बैठा हुआ है अभी तक,
बंदे ना बैठना, आज बंदे को टेंशन नहीं है ना, आज भूख शुरू लगेगी आज
ये पहले फुल हो गया है
किधर सबसे बड़ी फुल
सेशन स्टार्ट फुल करने वाला ने कर दिया।
फुल हो गया।
अच्छा वैसे भाई इस टाइम कोई भाई ने नजर नहीं आया यार, सुबह किधर वैसे किया, हमें बताओ, हमें कोई जगह देख ले।
क्या चीज?
हमारे तो ना करीब एक दरगाह है ना, बाबा से
इससे भी फुल होना
है इसमें,
बाबा से
पता नहीं लगा फिर कैसे।
वो बाबा जी वो भी बाबा जी
नहीं बात सुनो
कौन सी भी हस्ती हैं वो पहुंचे
ऐसा उनके ना, उनको क्योंकि 1971 में उनका पर्दा हो गया, तो उनके जो पास जिस कमरे में उन्होंने मिसाल किया ना, उस कमरे में उनकी तस्वीर लगी। जब वो होता है ना पालकी, जिसको कहते हैं कुलीन कहते हैं, पालकी को निकालते हैं ना, तो वो कमरा खोलते हैं, लोग कमरे के पास जुड़ के खड़े होते हैं, उनकी तस्वीर देखते हैं, बड़े बड़े बेनज़ीर उनकी उधर जाती है। अच्छा तो मुझे ना एक दफ़ा ना ऐसे में बगीचे में दरवाजे की दूसरी साइड में गया ना, खिड़की से मुझे तस्वीर नजर आ गई। अच्छा मैंने उधर ही,
आप 4 बंदे इधर मत खड़े हो। हसन डॉक्टर नुदरत की प्रेजेंटेशन चल गई है
जी सर।
लोड है हैं?
लोड
मसला तो कोई नहीं है ना?
नहीं सर नहीं आज वो कह रहा असम को डिस्टर्ब ना करो, आज ऐसे नहीं वो सही कह रहा है, आज वो मेरे हाथ में
वो मैं
बेइज्जत वो भी हुआ है ना,
क्या फिर मैंने करते करते
मुझे पता, मैंने क्या आगे बोलना
वो जो खुफिया रास्ता है,
बोल देना कि मेरा कल इसको फिर प्रेसिडेंट इसके ऊपर चढ़ जाना।
हाँ तूने कल इसको सुनाई थी ना?
हाँ देखिए
ये क्या कहता है?
छोड़ो
तो ये कहता होगा ट्रैक्टर के पास जाओ।
सही जगह ये खुफिया रास्ते के चक्करों में कि जहाँ से तुम उतार के आए इसको भी थोड़ा गाइड कर, बड़े भाई से छोटे भाई आसिफ
नहीं कुछ नहीं आता भाई, अली साहब सिद्धार्थ साहब आगे रह गए सिद्धार्थ साहब के सामने क्या हो गया? सिद्धार्थ साहब नहीं आए दोबारा, परेशान हो गया वो सभी क्लास ले रही है, परेशान आप लग रहे हैं क्या? ऐसा डी हर बार मरवाता है। कल मैं उसके पास तिलावत करने गया था, थोड़ा आज उसे प्रेसिडेंट ने रगड़ दिया, मुझे खुद नहीं बोलना मेरे बच्चे मैंने भी करते हैं, क्या बोलो छोड़ो करना
नहीं ठीक है ना।
अच्छा सुनाई उसने दोनों बहना जाहिर है, फिर जो दोनों आधी आधी सुन
ट्रैक्टर उधर ही बैठा है सामने, अपने उधर ही बैठा है।
मैं कह रहा हूँ डीजल करवा देता है। कल मेरे पास तिलावत लेके गया, मैं बता दे कल क्या चला, छोटे छोटे ब्रेकफास्ट डिस्कस कर हाँ वही तो मेरा तभी तो उसको साथ लेके गया मुझे सुनानी है मुझे कच्ची सुना गलत सुना
बड़ी पूरा अंदाजी निकल आई
फिर दोबारा से
हाँ नाम फिर निकल आया चांदी साहब
चांदियों की क्लास होगी मैं कहूँगा सर भी 6-7 हैं हमारे पास लेकिन आज की जो थी गर्मी
Hello everyone, we'll be starting in 5 minutes. Yeah.
और घर पर इधर ही हो या मुल्तान हो? अच्छा ये थोड़ी तस्वीर है इसी शेयर की तस्वीर हो कि
अरे कौन है जाके इसको बोलते हैं कह रहे हैं बस जा रहे हैं आप एक अनाउंसमेंट करते ना भाई क्या है Hello everyone, we will be starting in 5 minutes.
बस ऊपर से फेंक
ये बैठते हैं चाय पी लेते हैं
फिलहाल प्रोड्यूसर्स आपके
फिर बुला लिए फिर बुला लिए
Hello everyone. Hope you enjoyed the break. And now I will introduce our second session on the international investment arbitration. This session will be conducted by Dr. Nudrat Ijaz Piracha. Dr. Ijaz Piracha, let me read the bio of Dr. Ijaz Piracha. Dr. Nudrat Ijaz Piracha is leading the legal team of Pakistan's first global law firm, Samdani and Qureshi, which is a collaborating firm of Anderson Global. She has served both as counsel and arbitrator in international investment arbitrations and has advised on investment issues in cross-border transactions. She's a Fulbright Scholar, a Weinstein Jams International Fellow for 2018, and a Fellow of Chartered Institute of Arbitrators. She's the first woman in Pakistan to have qualified as an SGD. She's an alumni of London School of Economics and Political Science. In a career stretching over 17 years, she worked as a counsel in the field of ADR in arbitration before ICSID and ICC. She's a solicitor of England and Wales in addition to being a member of High Court Bar Association of Pakistan. She's also nominated to the panel of arbitrators of ICSID by Pakistan in 2018. Dr. Piracha, the floor is all yours.
Thank you. Let me just figure out the technology first. This way? Okay. Bismillahirrahmanirrahim. Thank you to all of you for being here today, and I will try to keep it as interesting as possible. It's a very difficult subject, and trying to condense it into just 1.5 hours or so, it's going to be a mammoth task. But do stay with me. Let's start. So the way I have structured the presentation today is first I will discuss with you the main elements that form the basis of investment arbitrations, the concepts that differentiate investment arbitrations from commercial arbitrations, the fundamentals of bilateral investment treaties. So these are commonly known as BITs. This is the most significant document when you're dealing with the investment arbitration. I will talk about the standards that are guaranteed under investment law through these bilateral investment treaties or other international instruments, the role of international law in investment arbitrations, the procedural dimensions of investment arbitrations, and the relationship of public law with investment arbitrations. So I have the unique perspective of someone who has worked for the investors. I have worked for the states. I have worked as an arbitrator on an annulment committee of ICSID, and I have worked at ICSID. So these are the four main players in ICSID arbitration: the investor, the state, ICSID, and the arbitrator. I have worked in all four roles. So I try to bring to you the unique perspective and all four dimensions. So first of all, the key features of investment arbitrations. The key feature first is the parties. The parties to an investment arbitration will always be either a state against a state, or it will be a state against an investor. The predominant cases that we have had so far globally are the ones which are between the investor and the state. Out of about 750 known investment arbitration cases, about 700 cases were done by ICSID, which is the International Center for Appropriate Dispute Resolution. International Center for Settlement of Investment Disputes. Now, the two governing instruments for Pakistan in particular, when you're dealing with investment arbitrations, you need to remember ICSID Convention of 1965. Pakistan is a signatory to this. This has been made part of the laws of the Pakistan through the International Investment Dispute Act 2011. In addition, the New York Convention of 1958, this too now has been made part of the laws of Pakistan in 2011. The governing institutions predominantly is ICSID, but in addition to ICSID, there have been some cases that have gone to the Stockholm Chamber of Commerce, the Permanent Court of Arbitration. Now, another important player is the tribunals in investment arbitrations. Where do these tribunals come from? ICSID maintains a list of arbitrators. Every state nominates, it used to be about 4 arbitrators. I think now states can nominate up to 3 arbitrators for 8 years. The arbitrators are selected from these lists of nominated arbitrators which are suggested or nominated by the state itself. The procedure, where does the procedure come from for ICSID arbitrations in particular? This could be in the bilateral investment treaty. The procedure is written in the ICSID convention. I will focus a lot more on ICSID because, as I told you, the predominant cases that you will come across in investment arbitrations are going to be under ICSID. The jurisdiction, again, to look at questions relating to jurisdiction, you would have to look at the bilateral investment treaty. You would again have to look at the ICSID convention. In addition to bilateral investment treaties, the obligations could be arising from multilateral investment treaties as well. The applicable laws. Now, what is the law that will apply to investment arbitrations? Invariably, you will find in the bilateral investment treaties, no law is specified. But the ICSID convention says when no law is specified, the law that will govern the arbitration, the substantive law of the arbitration, that is going to be the law of the state. In case there is any conflict between the law of the state and international law, the international law will prevail. And that is critical about ICSID arbitrations, that these are arbitrations which are governed in essence by the international law. The remedies then under the international law are the remedies that are available for any kind of breach arising out of these bilateral investment treaties. So these remedies, under those of you who are students of international law, you would know the chores of factory case. So any breach committed for international obligations under the bilateral investment treaties, the remedy would be what the chores of factory case says, that you need to put the investor in the same position it would have been but for the breach. So that is the key principle that guides us on the remedies. Okay, technology is not with me. Okay, so how would you differentiate? Let us say you are a lawyer and you now have a brief. How do you differentiate? Is it a commercial arbitration or is it an investment arbitration? So some of the key things to look out for are going to be, first of all, the parties. For investor-state arbitrations, you will always have one of the parties would be an investor, the second would be a state, or it might be a state versus a state. In commercial arbitrations, it will always be private parties. Sometimes you will have a state party, but the key thing to look for after that is, let us say you have a commercial arbitration, one of the parties is a state party. Then you will look at the instruments that are governing the arbitration. If it is the treaty or a contract saying that it is a dispute that needs to be sent to ICSID, you would know that probably this is an investment arbitration you're looking at. In commercial arbitrations, it will always be a commercial contract. It will not be a treaty. The breaches in investment arbitrations would invariably always be a breach of the treaty, not the contract. In commercial arbitrations, you would be looking at contractual breaches. The governing law for investment arbitrations is, as I said, the international law. The national law would be the substantive law invariably. You would be looking at the ICSID convention and you would be looking at the law of the state. But in commercial arbitrations, you would be looking at only the substantive law. That substantive law invariably is going to be the law of the state. The remedies, as I mentioned, in investment arbitrations, you would be looking at chores of factory case for principals. In commercial arbitrations, you are looking at damages and specific performance invariably. In terms of openness, investment arbitrations are a lot more transparent in comparison to commercial arbitrations, which are supposed to be confidential. The purpose of investment arbitrations is protection of the investment. On the other hand, commercial arbitrations are to enforce the contractual rights of the parties. One thing that is very unique about ICSID, and this is, I think, one of the critical things that you must remember whenever you are confronted with an investment arbitration, That is that the exit remedy is an exclusive remedy. So if Pakistan or the state has agreed to an exit arbitration, that is going to be an exclusive remedy. Now, what are the sources of jurisdiction and these obligations? Where do the obligations of the state come from? And where do you find issues relating to jurisdictions? What is the instrument that is going to guide you? There are multiple multilateral agreements from which the obligations of the state are arising. So Pakistan has more than 25 multilateral agreements. These are in the form of free trade agreements, multilateral trade agreements, and there are, for instance, OIC investment agreement of 1981. But the predominant jurisprudence in ICSID and in investment arbitrations is arising from the bilateral investment treaties, because the consent of the state, it could be arising from a contract, it could be arising from a bilateral or a multilateral investment treaties. Bilateral investment treaty so far has been the single most agitated document when it comes to investment arbitrations. So let's talk a bit about the fundamentals of a bilateral investment treaty. So what the bilateral investment treaty is doing is it's defining the relationship of the foreign investor and the host state. It is providing you the jurisdiction of the tribunal. It is providing you the protections that are available to an investor. It provides the dispute settlement mechanism, which might be a settlement mechanism between two states, or it might be a dispute settlement mechanism between an investor and a state. Many of the treaties contain both. Now, the most important clause, and I think the most ignored clause in Pakistan, that is the entry into force clause. And the term of the bilateral investment treaty, this is something in all our cases in ICSID. We do not pay attention to this very clause, and I feel this is the most critical clause in a bilateral investment treaty. So when you look at the bilateral investment treaty, what you will see is a preamble. You will see the parties. The parties would be a state. It would be an investor. It would be another state. Then you will have the entry requirements in some of the treaties. What are the requirements for the investment to be made in a state? The standards, which I will come to in just a minute. The standards are defined in the bilateral investment treaty. The dispute settlement mechanism, that again is defined by your bilateral investment treaty. It could be ICSID. It could be the Stockholm Chamber of Commerce. If it's an ad hoc arbitration, no institution is specified. The states could go to the Permanent Court of Arbitration. Very few arbitrations have gone to the London Chamber of International Arbitration and the ICC. Now, entry into force, as I said, this is one of the clauses that is most critical. And whenever you're confronted with an investment arbitration, this is the very clause that you need to focus on, because some of the cases of Pakistan that were decided against Pakistan, in my view, including the Tatian case, there was no jurisdiction. The jurisdiction could not be assumed, and had people focused on the entry into force clause, that was a case in which no jurisdiction should have been assumed. Agility was a similar case. By the time the firm got hold of the case, jurisdiction had already been assumed. It was a $600 million case, and that was the very first thing we went for. Again, it transpired that the treaty was actually not in force. And the investor, after the case had been set up against them, on the day of the hearing, they retreated. They said, we just want to go, we want to withdraw. We told them that you can withdraw only if you pay all the costs of Pakistan, which they did. And after that, they withdrew from their arbitration. This is an isolated case in which Pakistan entered into a settlement and Pakistan actually got money rather than giving money to the investor. Now, a quiz question for you. The treaty comes into force on June 22nd, 2001. The state breached its obligation in 2000, but the effect of the breach was still continuing on the date of the registration of the request for arbitration. Can the tribunal assume jurisdiction over the matter? Right. So this is technically called, she's very right, this is called the temporal scope. The temporal scope again is coming from the clause which I say is the most significant clause that will tell you whether or not a dispute is one that falls within the temporal scope of the treaty. That is what happened in IPRI case against Pakistan. The tribunal decided that the temporal scope, some of the parts of the dispute could not be agitated because they did not fall within the temporal scope of the bilateral investment treaty. Now standards, which is the key component, the key element of the bilateral investment treaties. These guarantees that are provided in the bilateral investment treaty, there are many, but I have picked few that are continuously agitated against Pakistan. FET, which is a fair and equitable treatment, full protection and security, national treatment, most favored nation treatment, expropriation, transfer of funds, umbrella clause. So we'll discuss all of them very briefly. The fair and equitable treatment, as the name suggests, it is merely a guarantee that the investor will not be treated in a manner which is not fair and equitable. So if we state to that, that was simple enough, but the tribunals have extended fair and equitable treatment to concepts of legitimate expectations. So the investor entering into Pakistan or a state has some expectations as to how the investor would be treated. Many of the cases that have been decided against the states have been under legitimate expectations. So this is one of the most controversial concepts at the moment. Non-discrimination, stability and predictability, due process, and that the state will not act arbitrarily. You would see instantly for developing states, some of these concepts, such as legitimate expectations, a state that does not have a lot of stability, stability and predictability, and due process. These have been key concerns for Pakistan because the systems, as you know, they are broken down. So a state might end up taking certain actions which are either not transparent or they are defeating the legitimate expectations. They are against the stability and predictability requirement. So FET, as I say, this is the most controversial standard at the moment. Full protection and security, sorry, just one more thing about the FET. This is again a concept coming from the international law, but under international law, there was a very high threshold, and this was a standard that was difficult to meet. But with these new alterations and new concepts, the FET under bilateral investment treaties is now much broader than the customary international law. Full protection and security, this is again one of the controversial standards. So under customary international law, all the state was ensuring to the investors was no physical damage to the investment. Now it has extended to even expropriation and legal protection under the legal framework. So again, you will see if the legal framework changes, the protection that you are guaranteeing to an investor, it's a very wide concept. Full protection and security, that's where the tribunals try to make the distinction. When it is full protection and security, it is the concept, the wider concept. If it is only protection and security, tribunals have tried to confine themselves to only physical destruction. Two more important standards, national treatment, which merely means that the investor of a state will not be treated any less favorably than the investor of the host state. Most favored nation treatment says that this investor of state will not be treated any less favorably than the investor of another state. Expropriation is not the same as you used to see in the conventional times and the kind of expropriation that we were accustomed to seeing in international law, which was direct expropriation. These days, the states do not go in, nationalize, and take over the assets of the investor. it is more of a creeping expropriation, what we call the indirect expropriation. Most of the investment treaties have arisen from the indirect expropriation. So the expropriation could be direct or indirect. The indirect expropriation is commonly referred to as creeping expropriation. The expropriation may be lawful or unlawful. So what makes that expropriation lawful would be there needs to be a public purpose, there needs to be due process, and there needs to be just compensation. So a state, it is not that a state cannot expropriate, but it has to be a legal expropriation. So if you have a legal expropriation, there is no issue. Now, standards of guarantees, the three remaining standards that I will briefly touch on is the free transfer of capital. The investors should be allowed to take their capital out of the state with ease. The umbrella clause, it is also known as the observance clause, which essentially means a state will observe its commitments. Now, these commitments might be arising out of international treaties, they might be arising out of a contract. So, umbrella clause is again one of the controversial standards because much of the issues that we see is indirect expropriation, and those indirect expropriation are undermining the contractual rights of an investor. So many of the investors try to cover the wrongdoings of the state under the umbrella clause. The last one is, I think this is the last one I'm discussing, right? So the umbrella clause, the contractual obligations are raised to a level where they become international wrongs, but certain criteria has to be satisfied for that. Now, quiz questions based on Pakistan's experience of investment arbitrations. The courts of a country rule that the ships of the investor cannot leave the port. What kind of breach has been committed? Okay. Any ideas what makes it an expropriation? I mean, the ships can't leave the port, okay, but the country is not really saying they are taking over the ships. They are not saying you cannot ever take these ships.
Party can't transfer the asset. Party cannot transfer the asset.
Transfer the asset. Okay. So this is a classic case of judicial expropriation. Pakistan has been found guilty of judicial expropriation on two different instances. One is the Karke case, where the Pakistani courts forbade the ships to leave the ports. There are actually more than two cases. I'll come to them after this. Second, the government uses the software of an investor for 8 years and eventually refuses to provide a rollout to the company and creates its own software which resembles the software of the investor. What kind of breach has been committed? Out of the 6 breaches that we discussed. Full protection. So they are basically just saying we are not giving you a rollout. They are not keeping the software, they are not saying you can't take your assets. What kind of expropriation or what kind of breach are we talking about?
It isn't fair and equitable treatment because it's arbitrary. You're not giving any reasons for why they must have it rolled out and everything is in order.
Right. So here the investor was essentially arguing the legitimate expectations. And yes, expropriation, they said you have expropriated the value of our contract. The investor conducts a feasibility study and has been working towards the grant of license for past 12 to 13 years. The state refuses to grant the license on considerations other than those set out in the agreement. What kind of breach has been committed?
A breach of fair and equitable treatment.
Which aspect?
Because again, they didn't follow due process.
Okay. Any other?
My question is, sometimes states, they reserve the right to reject any investment thereof.
Right.
So in that case, states can't be challenging on that because if the party has agreed, the investing party.
Right.
So sometimes you just cannot challenge the jurisdiction of the state.
If the state has reserved the right, which was the case in the Ricodic case, the Tatian case, here one of the arguments that Pakistan did raise was that there was a requirement that there should be legality of the investment, that is, the investment should be in accordance with the laws of Pakistan. And what the tribunal held was that yes, that is an admissions clause, but once you have entertained the investment has been going on for a certain number of years. Now you cannot go back and retract that admission of the investment and now at this stage say that we do not accept this investment anymore.
Perhaps they did not, government of Pakistan did not enter the clauses whereby the investors delayed the project, investors dilly-dallied, investors did not comply with the provisions of the agreement, or say converting, just taking away the rocks without bringing the smelters and others. So there could be many, I don't know, I haven't seen it, but the question is, when you want to negotiate certain, so it's as per the technical experts, just not the legal, lawyers, but the technical people. I don't know what has happened, and this Ricodic is actually a classic example of inefficiency, incompetence, and I can say because being in the foreign service, we have seen certain agreements where the states always protect their rights, and which was not.
So my personal view is that Pakistan, even in the treaty, which was the underlying treaty, Pakistan-Australian treaty, in the Ricodic case, Pakistan had adequately protected itself. The protections were there. The case was badly represented. It is a case that should not have gone beyond the point of jurisdiction.
So again, the capacity problem.
Capacity issues. Yes, yes. There are, unfortunately, I feel officials, many a times, the people who are involved with these arbitrations, they themselves do not know the acts and omissions that they are doing. They are going to lead to international obligations. And that definitely is a capacity issue.
I have a question. This is related to the current situation of dollars.
Right.
Dollars escalation, the price, non-availability, and restrictions by the government.
Right.
Now these affect two entities. One, the investors who have come from abroad, they have invested there.
Right.
And they want to repatriate the part of profit or whatever. They are restricted not to do this. Secondly, it also affects Pakistani entrepreneurs or business community, which are in business with the people from abroad. Let's say they are importing certain things, whether it's medicine, chemicals, or whatever, building industry. So the government has made a limited restriction not to open LCs.
Right.
So where does this whole thing stand? क्या ये force majeure में आ जाएगा? कैसे जान छुड़ाएगी?
Force majeure has a lot of elements which will need to be fulfilled. I do not think Pakistan will be able to make the force majeure defense, nor will we be able to make the necessity defense. And I do think in the next coming arbitrations against Pakistan, two key arbitrations that you will be seeing would be against the regulations of NEPRA. What Pakistan is doing in the renewable energy sector, that is likely to lead to a lot of arbitrations. Spain has faced about 45 arbitrations. Out of those 45 arbitrations, only 3 arbitrations were decided in favor of Spain. So Pakistan needs to tread very carefully with the regulations it is making in the renewable energy sector. And the second area where Pakistan is likely to see a lot of claims is going to be the free transfer of capital, because investors are going down because of the restrictions that are being imposed on currencies and the taking of the capital out of Pakistan. So those are 2 key areas to watch out for.
What happens to the Pakistanis who are in business? They have invested, they had offers,
Right.
These are lying somewhere in the containers on the port.
Right.
Or somewhere on the seas.
Right.
And they can't actually bend any or become.
Yes. So unfortunately, the Pakistani investors do not have a very strong legal framework to protect them. But the foreign investors, because of the bilateral investment treaties, they will have a recourse. And they will be going to all these forums where they can with their investment claims. Pakistanis, unfortunately, our law, the 1940 Act, it is being run like the ordinary CVRPC and CPC in Pakistan. So I do feel that our local investors are not adequately protected in Pakistan. So if your local investors are not protected and you are not ensuring any real protection to foreign investors, the first thing you're going to see is, would I invest my money in Pakistan? If I did not have a recourse against any wrong that is done or the uncertainty, who should bear the burden of the instability or this patch of uncertainty that Pakistan is going through? Do we leave the investors to bear the burden? I don't think any tribunal is going to find favorably if Pakistan was to run into trouble. Argentina, similar case, they were bankrupt. Again, about 40 cases arose. Most of them decided against Argentina. So we have to be very careful in our policies and how we go through this patch, because there are certainly going to be a lot of claims that will be arising because of the way we are shaping our policies. If we do not have good insight into how other states have run into trouble and what are the actions that governments and officers have taken which have led the states into trouble, Pakistan is definitely at the moment treading a very, very dangerous path.
Excuse me.
Ji?
Like in commercial contracts,
Mhm. Right.
contracts, there's clearly mentioned if there is any changes in state law, the prices may renegotiate or terms may renegotiate.
Right.
So the same clause is in the international investment law as well or not?
The freezing clauses, invariably you will be looking at the law of the state or the contract for these freezing clauses. You're quite right. In FIDIC and some of the standard form of contracts, engineering contracts, there are clauses which freeze the law and which provide freezing clauses for the fluctuation in the currency. But there is no general right that if there are any changes, there is any kind of protection, and these clauses in fact may backfire. For instance, let's talk about the binder contract. In the binder contract, the currency has been frozen to 23 rupees to a dollar, and the investor has not been paid since 2001. That is money that still needs to be paid. The IPCs, the interim payment certificates have been pending since 2001, and the payment has to be made 50% in rupees and 50% in dollars. So these freezing clauses, again, you have to be very careful. They might come back to bite you. In the second binder case, which is likely to go against Pakistan, that is dues that are contractually owed, cumulative interest of, I think it's 8% per day, per month, and we are looking again at a $400 million claim that is likely to go against Pakistan. So with the freezing clause, Pakistan will have to pay the same money that it had to pay in 2001, with the only variation that 50% has to be paid in dollars, and the dollar is pinned to 23 rupees to a dollar. So you can well imagine what kind of money Pakistan will be paying when that money is paid out 4 to 5 years from now. Okay, more quiz questions. The failure on part of a state to approve lesser tariffs and its conduct results in delays in commencement. What kind of breach has been committed? Mm-hmm. Right. Right. So again, we were looking at, in this case, this is still not decided, again, a case against Pakistan. So we will see, but again, the investor is claiming legitimate expectations. A state seizes assets of the investor through its police. What kind of breach has been committed? Direct. Any other standard that comes to mind? So the protection and security. That is a classical case where, again, Pakistan is looking at a case in Punjab where the assets, the investor claims that the assets have been seized. A state terminates pre-shipment contract contrary to the terms of the contract. What kind of breach has been committed? So this is the very first case that Pakistan faced, the STS notorious case, where the pre-shipment contract was cancelled. What the investor argued was a breach of the observance or the umbrella clause. Then you have the last question. The government favors local investors and alterations in pricing structures and mechanisms resulted in the financial ruin of the investor and the sale of its assets to the state entity. Has the state committed a breach? Anyone?
National protection.
Huh?
National protection.
So here again, we are going for the protection standard and again legitimate expectations. But this is a case that was decided in favor of Pakistan. You will be relieved to know there was a case that was decided in favor of Pakistan. The tribunal held that the investor would have been ruined anyway, and the state did not contribute much to the ruin of the investor. Okay, so the Karki case, just summing up what we have already discussed, the Karki case was a case of judicial expropriation. There was a lot of interference by the courts, and I think Pakistan has been getting into trouble because of this one factor predominantly in the past years, that is the judicial expropriation or the judicial intervention. Provisional measures to allow the ships, ICSID had granted provisional measures to let the ships go. The courts denied to do that. The Supreme Court of Pakistan declared the contract void, suspending the company's license and freezing its local bank assets. The court declined to stay the Admiralty's suit on the ground that the institution of ICSID proceedings by Karki had created a situation where recourse to contractual arbitration was not possible or feasible, that is, the arbitration agreement was incapable of being performed. So you would see a lot of intervention from the court in this matter. Agility case, again, a case of creeping expropriation. This was a case, as I said, was decided in favor of Pakistan. The investor left the ground before the battle. Tatlin case, we are looking at cancellation of the contract by the Supreme Court of Pakistan, again, intervention by the court. The Star Hydro case, legitimate expectations. Next, umbrella clause, SCS, binder case, FET, expropriation, national treatment, MFN clause breaches. So these are the predominant clauses that have been used against Pakistan so far. Now, briefly, turning to the jurisdiction. When we talk about jurisdiction, the first thing that you need to see is what we call the ratione personae, which is the person for the arbitration. The ratione personae would cover the investor and the state. The investor is defined by the bilateral investment treaty, and the state under the ICSID convention, the state has to be a party. But what has happened in Pakistan is predominantly it was not the state that was signing the contract, and the investor was complaining against breaches of the contract. So we had, for instance, WABDA, NHA, these are not technically the state as such. So ICSID convention says if it is an instrumentality of the state or if it is an agency of the state, then it has to be designated by the ICSID convention, under the ICSID convention. That was not the case for WABDA or NHA. So the only way to claim against NHA, WABDA would be attribution. that the acts of these entities are attributable to Pakistan. The second jurisdictional question is the rationale materiae. That is what is the matter of that arbitration. The rationale materiae for ICSID arbitration is going to be an investment. Your investment is going to be defined in the bilateral investment treaty. Sometimes it may be defined in the national law that would be guiding what an investment is. The tribunals, as I said, if there's a conflict between the national law and international law, they will always refer to the international law. Some tests have been defined by some of the tribunals, like the Salini Tribunal, define the elements of investment. Consent is the critical foundation stone for international law as well as investment arbitrations. Consent to arbitration is invariably given by the states through the bilateral investment treaties, multilateral investment treaties, legislation. There are few cases in which Pakistan has provided ICSID as an option in the contracts that they have signed. You need to look at the conditions. Are there any conditions of going to ICSID before you can actually, are there any conditions before going to ICSID? For instance, some of the bilateral investment treaties have a clause which say you have to wait for, let's say, 6 months. There is supposed to be an attempt on amicable settlement before you can go to ICSID. There might be what we call a fork in the road clause, which means the clause says you can either go to the courts or you can go to ICSID. If you choose one, your other remedy is forfeited. You can choose one of the two, not both. Another thing to be aware of is the MFN clause. MFN clause, as I said, essentially says you cannot treat one investor any different from investor from another state. So if you were to guarantee one investor that they don't need to wait for 6 months, they can directly go to ICSID. And in another treaty, you have a clause which says you do have to wait for 6 months and try settlement before you go to ICSID. The investor can rely on the MFN clause to pick and choose between favorable provisions in different treaties. The procedure, I will go in a bit detail in the procedure because again, that is where Pakistan makes the most mistakes. The substantive law, we've already discussed the obligations arising out of the bilateral investment treaty, but the substantive law usually is not defined in the bilateral investment treaty in terms of which law of the state is going to apply. So if there is no law specified in the investment treaty, then it is going to be the law of the state by default, and this tribunal would look at international law. The remedies, again, defined by ICSID convention, there are only 2 remedies. Either you can, 3 remedies, you could go for a clarification, interpretation, you could go for annulment or a revision. Under ICSID, there is no appeal. 2 quiz questions again. The lead consortium member who is Italian applies against breaches committed by the state against not only the company, but for other investors of states not having a bid. Can the lead member file for damages to the company and the shareholders? So I'll rephrase. The Italian or one of the lead partners, that's the party or the investor having a bilateral investment treaties, can this Italian investor bring a case on behalf of the company as well as other stakeholders? Any guesses?
It's a matter of jurisdiction and wouldn't the tribunal should decide something like this?
So this was the Impergillo case in which the tribunal said that you cannot bring a case on behalf of any of the other investors if the bilateral investment treaty exists with one investor. That investor can claim only to the extent of its own damages, not the other consortium members. So the bid provides that investment be made under the law of the state. Subsequently, state courts decide the contract was void ab initio. The contract constituted the investment of the investor on claimant's case. Is there a valid instrument? investment, sorry. Is there a valid investment? So the investment has to be made in accordance with the laws of Pakistan, and the Court of Pakistan is saying that the contract is void ab initio. That contract is the very investment that the investor has made. Is there a valid investment? Yeah, which goes back to your question. So in Ricotech case, this is the very question that the tribunal was looking at, and that is what they said, that the conduct of the state itself in saying that the contract was void ab initio, which was unsupported by any evidence, they said you cannot now go back and declare at this stage that there was no valid investment. This was something that had to be decided at the time that the investment was made. So the state cannot come back years after the investment was made and now claim that it is not a valid investment. Sorry, you had a question?
This is regarding balancing project. If you go to that point of time, the Supreme Court had a bias between about that time.
Right.
So it is just not a situation. It was PSA Singapore, it was therapy, it was that government, Mr. Zardari's government. And since Mr. Zardari was reluctant to restore the Chief Justice, Mr. Robbery,
right.
So throughout his government, his attitude was biased against government. Therefore, no investment on Assam State. That was challenged, and that was the judgment was given. You cannot put a single judge as a which was ever favorable.
Right.
So here I don't know how the laws of the land were applied and how the courts, quote unquote, its own neutrality was in place. I don't know, I haven't read any commentaries, but since I can say, I was recruited to the presidency as a additional secretary dealing with foreign affairs. And since some of them had something to do with the foreign governments.
Right.
So here I want to pick up your phrase on that, because plain laws we talk about an arbitration fine. All of the land fine. But what to do with the court, because itself was biased.
Yes. Yes. So that is unfortunately judicial expropriation. If your courts are not behaving in a manner they should, international law is not going to take a sympathetic view. The courts have not acted in a way they should. Unfortunately, Pakistan would be held liable for the wrongful conduct as a state, not just as confining the obligations to the judiciary. It would be Pakistan who would be held liable. Yes. In Pakistan, I think we have been most unfortunate. Most of the cases that I have been involved with, all these cases in some capacity or respect, and I think it has been very unfortunate that in Pakistan we have this typical problem of the what I call the change of the political winds. As soon as you have a change in government, the first thing that the government will do is to undermine the investments of the previous government. It might seem okay from their perspective, but what it does lend us into is a lot of trouble when it comes to meeting our international obligations. So Pakistan times and again, people do ask me this question that, I mean, why have treaties? If Pakistan cannot meet its obligations under those treaties, why set the standard so high that Pakistan cannot meet those obligations? Generally, my response is that we have to keep in mind the fact that this international law and investment arbitration, I feel, is premised on a significant assumption. That is, the government is working in the interest of the state. In Pakistan, unfortunately, the interest of the government might not align with the interest of the state. And when you have that situation, having international law at least ensures that the governments are held accountable. The state suffers in the shorter run, yes, but in the longer run, if there is no accountability for those governments, there is going to be no change.
Isn't that calling into question the integrity of the legal minds who are involved while entering into that agreement?
Right now,
when you say that the change of the trumpet, the goalpost changes.
Right.
Okay. It is a question of the integrity of those people who were involved in entering.
Yes. And I feel the government.
The legal one, because it is the legal document which ultimately lands Pakistan into embarrassment.
So the governments will come and go, and I think the ultimate people who suffer in investment arbitrations are the people of Pakistan. For in awards of $6 billion, these are not awards that are going to be paid by the government. It is the taxpayer who will be paying through their nose for these awards. And these awards are rendered essentially because of not representing the cases properly and conduct of the government. So I will come to the procedure and guide you through what has been done wrong, why Pakistan keeps running into trouble when we have investment arbitrations. So just briefly, role of the national law. In case the dispute settlement mechanism is defined by the legislation of a state, you can see why the national law is important there. The bilateral investment treaty might say you need to exhaust the local remedies, so the national law is important. Interim injunctions, as we just saw, the courts have been trying to stop ICSID from proceeding with the arbitration or providing other kinds of interim injunctions, which again was under the laws of Pakistan. Anti-arbitration injunctions, all cases before ICSID have had some form of application from Pakistan, encouraging anti-arbitration injunctions. Applicable law is that of the state, as I said. Whenever the treaty does not mention the law is going to be that of the state. So that's where the national law is important. Entry requirements, whenever the bid has entry requirements for the investment, you need to look at the national laws. Public policy and validity of the contract. These are again questions that are guided by the domestic laws. The definition of investment and investor sometimes might be guided by the national law. Instrumentalities of the state. As I said, the instrumentalities and agencies of the state cannot go to Pakistan go to ICSID directly. But looking at whether or not an organization is an instrumentality or an agency of the state, you will have to look at the national laws. There is reliance on national laws and regulations to justify breaches by the state sometimes. For instance, there is a change in the tariffs or the renewable energy regime. The government would be relying on its own laws to justify why they did it. Again, I would re-emphasize, in case of conflict between international law and national law, the international law will prevail. Standard of review is another issue in which the tribunals will be looking at the national law. Enforcement of awards, you need to go back to a state, whether it be the same state against whom the award was passed or any other state. The state laws would become important. Now, procedural dimensions. This is, I think, the most significant aspect where Pakistan keeps going wrong. In the Tatian case, which is the RICO Dick case, the tribunal in a 1,000-page award have attributed about 3 pages just to say how badly Pakistan represented its case. And I think that is unheard of. Having sat as an arbitrator, that is not something you would do unless you were really, really mad about something, and I have never seen it done before. The tribunals did write against one of the financial experts, Navigant. Other than that, I have never seen a tribunal go that far in writing down how badly a case was represented. So it starts with the notice to commence the arbitration. The key elements of the procedure are the selection of the institution, the appointment of the arbitrators. I will walk you through the steps, just giving you a general overview. There are preliminary objections on jurisdiction and admissibility, provisional measures, you can go to ICSID for that. There is the merits phase, the document production phase. You have a hearing, the evidence, post-hearing submissions and costs, award and its enforcement, annulment and revision, the enforcement and the issue of confidentiality. So whenever anyone talks about procedure, these are the key elements that will be discussed over and over again. But rather than going through all of these elements, I thought I would walk you through what an investment arbitration actually looks like. So if you were sitting as a government officer or as a lawyer, you were dealing with an investment arbitration, this is how it starts. You will receive a request for arbitration. I will keep guiding you as to what Pakistan has done so far. So Pakistan gets a request for arbitration. ICSID Secretariat will do an initial screening. They will see whether or not this is something that is devoid of jurisdiction prima facie. They would reject in the initial screening any case that they feel is not going to qualify on the face of the documents. The letter from Secretariat to the state, if they feel there is a prima facie case, there would be a letter received from the Secretariat to the state. Now here is where the problem starts. The letter is received, for instance, the contract is with FPR or the contract is with NHA. So the letter is received from NHA or it is received by FPR. What is going to happen is it is going to sit there for 6 months. No one will know what to do with that letter. They are not going to inform the relevant people. And while everything else is happening, Pakistan would be sitting with that document, the letter received from ICSID, for good 6 to 7 months. So in that time, the state party needs to file a reply to that request for arbitration and object whether or not it is a case that is fit to be heard by ICSID. The representation of the parties, mind you, the rules that I have written, these are under the 2006 rules. Now there are 2022 rules. This needs to be updated. These are the rules, they have not changed much, but I think the numbering has changed now. Apportionment, of course, so the very first thing you will receive is going to be as soon as there are talks about registering the arbitration request. Pakistan usually would not reply in time. The request will get registered after 7-8 months of back and forth. ICSID would keep trying to get to the government, try to get a response. As soon as there is registration, ICSID is going to ask for the fee of administration, which I think is around $25,000 to $30,000. Then comes the critical stage. Whether or not you are going to lose or win a case is going to depend on the constitution of your tribunal. And this is the most critical step, that you need to identify the right arbitrator for your case. In most of the cases, Pakistan never identified the arbitrator. So the arbitrator was selected by ICSID, and that was huge opportunity we lost on. So the arbitrator would give a declaration of impartiality and availability, any objections that the parties have under the IBA rules, which identifies what amounts to impartiality. The parties would provide their objections, the fees and expenses of the tribunal, that would be determined at this stage. The fees are identified by ICSID rules. So ICSID, I think, is one of the cheapest in comparison to other forums that are available for investment arbitrations. But even with ICSID, they pay us as arbitrators $3,000 a day. That is an 8-hour day. And this is considered to be the cheapest when we are talking about investment arbitrations. At this stage, you would start looking at some kind of request for provisional measures as soon as the constitution is done. How the constitution is going to be, one of the arbitrators is going to be selected by the investor, the second arbitrator by the respondent, and both the arbitrators are then going to select the president. The response to, if there are provisional measures requested, there is going to be a response to those provisional measures. The first, procedural call. This is again one of the most significant steps in the arbitration proceedings. This is where you are going to decide most of the important things, right? So upfront, the parties with the tribunal are going to decide the applicable arbitration rules, which are going to be ICSID convention, if it is an ICSID arbitration, the presence and the quorum, how many arbitrators do you need to have, communication between the parties, how is that going to be? Is it going to be directly with the arbitrators? You would go through ICSID secretariat, you send your emails to ICSID, and ICSID will then forward it to the tribunal. That is up to the parties, they can decide. Then we have rules about rulings of the tribunal. How are those rulings to be given? I will share this presentation so you can take a look at the sections and details as to how the rulings are to be. Then the place of proceeding. The place of proceeding for ICSID, if none is specified, it is going to be Washington, D.C. The tribunal has the power to fix the time limits of arbitration. So this again is going to be something the parties are going to decide in accordance with Rule 26, how much power they want to give to the tribunal. The procedural language, invariably it is going to be English. And the details of how you are supposed to then submit the documents which are not in English language, it's quite sophisticated, the translations. We have had arbitrations in which what they have is a live translation. So while your witness is speaking, there is going to be live translation for the rest of the people in the room. So these again are things, testimony of the witnesses who do not speak English. These are things that you will decide upfront in accordance with the rules. The most important thing that is decided at this stage is going to be the bifurcation. So bifurcation, what it essentially means is, do you want to separate the issue of jurisdiction from the merit? And in some cases, what was requested was that even the quantum phase, that is the damages phase, that should be separated. All of these steps are going to add on to your costs. So in Tatian case, there was a separate jurisdiction which was then mixed with the liability phase, but then there was a separate quantum phase. We have ended up in situations where there is at least a bifurcation between jurisdiction and the merits phase, if not the quantum phase. Now, you will decide in this first procedural hearing what the number of copies and methods of filing of parties would be. Then you will decide the number and sequence of pleadings. So whether it is you are talking about jurisdictional hearing or jurisdiction, or you're talking about liability, these are the things you will have to agree to. So what you generally look at is there is going to be a memorial from the claimant. There will be a counter memorial from the respondent. There will be a rejoinder again from the claimant. And then there is going to be a reply from the respondent. The evidence, again, the convention guides you regarding evidence. It is something you can tailor according to your needs. This is what is commonly agreed to. The evidence has to go in with your pleadings. Again, here Pakistan keeps going wrong. We do not submit our evidence. At the proper stage, we will not submit the evidence, and then we keep going back and forth for submitting additional documents, especially in our claims relating to corruption. No one is willing to give evidence, and when we get a finding against Pakistan, we want to go back to the tribunal and submit some evidence, and if you have not submitted your evidence with your filings, it becomes extremely difficult to bring something on record. So neither party shall be permitted to submit additional or responsive documents after the filing of its respective last written submission, unless the tribunal determines the exceptional circumstances exist based on the reasoned written request followed by observations from the other party. So I think in Tatian, we went back several times with evidence that we had. Karke, the same. We had a lot of evidence of corruption, which we did not produce at the proper time, and then we kept going back to the tribunal and different courts at the time of enforcement, trying to somehow get that evidence on record, but once you pass this stage, it becomes extremely difficult to get any evidence in. So in evidence, the rules again the ICSID rules define all the parameters that you need to know about the evidence. If the tribunal grants an application for submission of additional responsive documents, that is the only situation you can get additional documents in. The tribunal may call upon parties to produce evidence and documents. Exhibits shall be numbered. For the claimant, you number it as C and CL. It's going to be consecutive. For respondent, it will be R and RL. The witness statements again need to come with your submissions. If you try to put in witness statements after the pleadings have been submitted, you will not be able to put in those witness statements or expert reports. So everything has to go in with your filing. And if it is something that should have gone with, let's say, your memorial, it would become extremely difficult then to push it in with your last or second submission. So examination of witnesses, again, you can look at rules 35 and 36, how the witnesses are to be examined. Now, before the hearing, once all the submissions have been made, there is going to be during those submissions, a stage after your first round of submissions, there is going to be a document production phase. So the documents that you do not have in your possession, custody and control, you can ask from the other party. Those documents you can then use in your last or second round of submissions. So just before the hearing, you will have a pre-hearing organizational meeting again with the tribunal and the other party. The hearing, that's covered by arbitration rules 20 and 32. So the hearings are usually oral hearings. What the hearings actually look like, some of the hearings, for instance, it's a 10-day hearing. You will have the opening statement. After the opening statement, the claimant side witnesses would be testifying. You would be cross-examining them if you are the respondent's counsel. Then starts your cross-examination of your witnesses. So what is happening is every day when you go back to your hotel room, you will have with you the issue of dealing with the cross-examinations next day. If it is examination of your witnesses, you need to be sitting with your witnesses, just going through the documents and facts. In addition to that, you will be done around 6 o'clock, 7 o'clock in the evening. You go through things with your witnesses. That's about 10 o'clock. At 10 o'clock, you will receive a live transcript, which is going to be about 450 to 500 pages long, and you have the night to go through that to prepare your closing. Every day, this keeps going on. Then you have your expert witnesses, same routine. By the 10th day, you are working on about 2 to 3 hours sleep. And in the hearing, it's just the adrenaline that is keeping you going. So investment arbitrations are a lot of fun. So records of the hearing and sessions, as I say, the transcripts, you're going to receive every night. After that, you're going to submit everything that was said. Some of the tribunals are going to allow you to give post-hearing briefs, which is generally the case. In investment arbitrations, parties do prefer having the post-hearing briefs. The publication of the award, again, the parties would have to, at the time the award comes out, you have to decide, if you have not already in your procedural order, your procedural hearing, you will have to decide whether or not the award should be published. The remedies, as I mentioned, it's only going to be interpretation, annulment, and revision. So the annulment tribunal has very, very limited scope. Even if it was something that is glaring, the decision is wrong, the annulment committee cannot say anything. The total mandate of the annulment committee is so limited that if any person, reasonable person, could have come up with that decision, that is fine. So if you have had a decision against you, annulment really, it's not a lot of help, neither is revision. Pakistan in the Tatian case tried both annulment and revision. So before the settlement, the annulment hearing was done. But I think Pakistan would have had a very difficult time trying to prove that what was said by the tribunal, what was wrong and why it was wrong. So the last aspect that I wanted to cover is the relationship of public international law with investment, the international investment law. So international investment law is only a subset of the international law. The key elements that you will see running through both these laws, sovereignty, again, is a key concept. The public international law recognizes the principle of state sovereignty, in particular the issue of consent. They are at the heart of both investment arbitrations and international law. Both public international law and investment law, the treaty, because that is the foundational document, you will see that both public international law and investment law are based on principles of treaty law. Now, because they are based on treaty law, that should tell you that for interpretation, you need to go to the Vienna Convention on the Law of Treaties. International law becomes critical because we have been reading about, we've been talking about the rights of the investor. So what is the defense that is available to the states? This defense can be coming from either the bilateral investment treaty itself. For instance, there might be exceptions. In addition, you would be looking at the common defenses that are available to the state. These defenses are coming from the international law. The principles of proportionality is something that is discussed by the tribunals every now and then. In addition to the bilateral investment treaties, some of the obligations of the states might be arising from the customary international law. For dispute resolution, international law disputes are going to, for instance, the Permanent Court of Arbitration. So there are certain overlaps in the institutions that you may go to for settlement of your investment disputes. The sovereign immunity, again, is an international law concept widely used in investment arbitrations. ICSID Convention does not provide states immunity when it comes to enforcement of the awards. State consent, as I mentioned, it's a fundamental concept of international law and investment law. Another concept that you will not hear about generally is puissance publique. Now, what puissance publique is, especially in cases where there is an act under a contract, what the tribunals have insisted is, as was the STS case, when there is a breach of the contract, should the state be held liable under international law for a breach of the contract? So puissance publique essentially says that whatever breach has been committed has to be an act that has been committed by the state in its sovereign capacity. So any act that is committed by a state merely as a contractual party is not going to give rise to a wrongful act or international obligation. So the key principle of state attribution that is extremely relevant and critical to the investment arbitration regime, because in order for the state to be held liable, you would have to show that there is a wrongful act. That wrongful act could be of the state itself, which is, or its agencies, so it could be direct attribution, the action of the state organs such as government ministries or agencies, or it might be indirect attribution where the acts of that organization were controlled by the state. So last quiz question, an agency of the state fails to fulfill its contractual obligations, can the acts and omissions be attributed to the state? I'm just checking everyone is awake or not, because this is a very simple one. So agency of the state, as I said, either under the ICSID Convention, the agency or the division has to be designated by the state under the ICSID Convention. If that is not done, then how has WAPDA, NHA, how has the tribunals, how have they assumed jurisdiction in relation to WAPDA, NHA and other agencies of the state? That was through state attribution. So something I think that every law student who will be dealing with investment arbitration in future, you must bear in mind, this is where Pakistan is struggling the most at the moment, that is government and acts of government and judiciary. The International Law Award, it's at state responsibility for judicial acts. Now, what kind of judicial acts are going to give rise to state responsibility? The decision is clearly incompatible, there is denial of justice, or a decision is contrary to the municipal law where it is shown the decision itself constitutes a treaty violation. And that is where we were. With Tatian, with Karke, the tribunals found that the decision of the court in itself was contrary to the municipal law and the decision itself constituted a treaty breach. If there are delays, now this is something that India has run into trouble with, and you would see close resemblance with Pakistan. In the white industries case in India, after which India decided to get out of all its bilateral investment treaties, the white industries case was one where there were delays by the courts. The award was not enforced by the courts for 10 years. Can anyone see that happening in Pakistan? That our courts do not enforce an award for 10 years or 8 years? So here again, what the tribunal said was that because of the delays, the courts had committed a breach of the international obligation. Failure to provide due process, can anyone see that happening in Pakistan? In the government departments, in the courts? Going beyond jurisdiction is another way that the officers and the judiciary can get into trouble. Intervention by the courts, this is typical of what we have been doing in exit arbitration so far, interfering with contractual rights, directing Pakistan to withdraw and cause to be discontinued any proceedings in the courts of Pakistan which seek to restrain. So in the agility case, this is what happened. There was a provisional measure and our courts were still trying to somehow stop the exit arbitration. Rico Dick case, again, the court granted a stay, but it had instead directed the government to request ICSID not to take any further steps. So in all the cases, as I said, Pakistan has tried very hard to stop the ICSID proceedings without any success. Interim injunctions is another way that our courts are interfering. So courts have power to grant interim injunctions, but what happened in the Karke case, or the delays in enforcement of domestic awards, as I said, where India rendered itself in difficulties. That is what we are doing as well every day in the courts. There are significant delays. It is only a matter of time where with an investor we are going to delay and we are going to run into difficulties like India did in white industries case. Refusal to stay proceedings in face of a valid arbitration agreement, that's another way we can possibly get into difficulties. I do feel a trend where the courts are moving more towards arbitration friendly regime. So maybe in years to come, we do not see the same kind of hostility that we have seen in the past decade. So I would leave you only with 2 tips as an investment arbitration lawyer. If you can remember these 2 things, chances are the chances of error would significantly reduce. Do bear in mind that ICSID is an exclusive remedy. Whether you're sitting as an officer, as a lawyer, or as part of the judiciary, ICSID is an exclusive remedy. Section 7 of ICSID Act specifically excludes application of provisions of the 1940 Act to any proceedings under ICSID Convention. And while the tribunal is to take into consideration domestic law in a conflict between domestic and international law, the international law will prevail. If you keep these 3 things in mind, as I say, the chances of error will reduce. With that, I would thank you for your patience and a very, very long lecture. And if you have any questions.
You can
Right. Under international law, the defective clauses, what you call as defective clause, they are referred to generally internationally as pathological clauses. And where you have a clause which gives you two options, either to go to the courts or to go to, let's say, ICC or ICSID, this is not a pathological clause. This is what we call a multi-tiered clause. So there might be two kinds of multi-tiered clauses. One is where they say you can go to forum X, or you could go to the courts, or you could go to forum Y. So this is an option between the three. What is going to decide where you eventually go is going to be the first choice that is made. Let us say the claimant or one of the parties makes that choice. They decide to go to the courts. That is the end of story, because this is conventionally referred to as the fork in the road clause. You select one option, the other option closes. There are some clauses which are not actually a fork in the road clause. They are multi-tiered clauses. So there what you will say is, for instance, that the dispute would be referred to the courts, right? If they are not referred to the courts, you might say, for instance, it would be referred to ICSID. Let us say if the state has not signed the ICSID convention, then the matter would be referred to ICC. This again is a choice clause. You can choose between one of the three. Multi-tier is going to be, first you are going to attempt amicable settlement, 60 days. If that does not happen, then you would be able to go to, let's say, ICC. And if for some reason ICC, let's say ICSID, if for some reason ICSID does not have jurisdiction, then you will go to ICC. So this is more of a multi-tier clause. So both of them are permissible. Either it be commercial contracts or it be investment contracts. Multi-tier clauses and fork in the road clauses, both of them are permissible.
Ma'am, is India arbitration friendly, or what is the core conclusion and the recent development?
Yeah.
And what and the benefit India got benefit from the foreign judgments?
So generally India is investment friendly, but that is domestic investment friendly. Generally what has happened in the past 10 or so years is the states did not think that they would actually have to face cases in ICSID. So there has been a lot of backlash against investment arbitration, and India is no different. They have come up with a model treaty clause, and a case was decided against them under the most favored nation clause, the White Industries case, after which they decided to get out of their bilateral investment treaties. So India in its model treaty, and I think Pakistan has followed suit, we too have come up with a model treaty. And what is happening is, throughout the world, the states are diluting the rights of the investors. So this is the general trend, and India is no different. India too is to some extent hostile to investment arbitrations, and they are trying to dilute the right of investors. Any other questions?
If I may, sorry.
No, sure.
I don't want to monopolize because this is a law students, but being a practitioner, we face certain problems. As an ambassador, I have to face problems regarding investment. And then I want to understand the difference between investment policy and investment law. Secondly, I presume that investment policy has a legal value. It has a legal value. When you want to affect investments from abroad, so to give certain policy. But down the road, it's not implemented. Reason being that if today I invite all the law students to request Board of Investment to tell us which are the 10 industries that ready for investment.
Right.
If you get the answer in a couple of years, it will be one. Secondly, the question of local activity. All investors abroad, they want local activity. Where are the local partners? Again, invite all of you to ask the Board of Investment which are the local partners or local activity available. Please give us their names and addresses. Get down to the interviews. So one of the causes where Pakistan lands into trouble is because that he may announce about investment, he may plead for investment, but down the line, since the rules and regulations are not there, you cannot open an industry maybe in 2 years or 3 years. But in UAE warehouse or Basra or in Iran warehouse or Basra, UAE particularly, in 24 hours you get a license and the next day you can start your industry.
Right.
So this is the difference.
Right.
And that's how we get the people on the legal side.
Right. So coming to your question, the policies, why they have become important is, while exit tribunals have recognized it, that the states should have the right to change their policies as they deem fit. But where the problem starts is that once you have policies and you have held out in those policies, for instance, the renewable energy policy, I think of 2006, certain assurances were given to these investors. There were things that were being expressly held out by the state. Under international law, unilateral statements of a state might also give rise to international obligations. So these policies, one, might be treated under international law as unilateral statements by the state, giving rise to international obligation. Secondly, what happens is, once you ask an investor that come and invest in Pakistan, and this is what we are promising you, and any investment made under these policies are guaranteed these rights that are written in this policy, then 8 years after, when all the investments have been made, you say, okay, we are getting rid of the policy of 2006. Now what you have technically done is, the investor has not only made the investment, she has acted out on that statement, on that commitment that was made. And to top that, contracts have been signed. Now that policy is saying that this policy and what is guaranteed under this policy is going to be available to you for the term of your investment. After 8 years now you say that, okay, we're getting rid of the policy of 2006. What you have effectively done is you have breached the legitimate expectations of the investor who had invested in Pakistan based on the assurances that were given at that time. So policies, generally it's a soft document, I would agree, but because of the issues that you have with unilateral statements and the concept of legitimate expectations, you are likely to be held liable for breach of an international obligation if the matter was to go to exit. Any other questions? I'll share it with the organizers. Yes, they can share with you. Okay. Thank you so much.
Thank you, Dr. Pracha, for an extremely insightful lecture. Now we will have a lunch break till 2:30 p.m. Afterwards, we will have a third lecture on BITs for Developing World Perspective by Dr. Sadia Zahoor. Thank you.
हसन नहीं है आज चैनल में क्या क्या है मुझको नहीं बता रही है आपको कोरमा सब
आई सब मेरे साथ आके छोड़ा गया दबा करेंगे वो किधर है कारी हसन किधर है
जाना अभी कहीं बढ़ते हैं
हम सही है
सही नाम लगा ना नाइस शर्ट यार इस
कारी हसन ये क्या हो गया तोबा क्या है
नहीं ये आपको ये अगर ये कहते ना हमारी जाते टाइफाइड रहता है
क्या चीज नहीं सॉरी
यार इसको यहाँ से मैंने यहाँ से कोशिश की है इसको मैंने किया मान के यहाँ से ये नहीं होगा
मुझे बात करना है नहीं वैसे नहीं सर
बस मेरे लिए
तू जाओ यार तू क्या कर रहा है
बस छोड़ दे वो कब शब्द है ऐसे वो भी नॉन पेंशनेबल है इस तरह का थिंक टैंक ना और 17 का भी है
नहीं नॉन पेंशन में ना जाना
अभी वो दोस्त गए हैं वो गए थे कि एक क्वेश्चन करता है डिजिटल लाइब्रेरी वाला आया कितना में पहले से बंदा लिया हुआ है तो एक क्वेश्चन करके जी कितने निकलो
यही तो मसला है ना
1 बजे स्टार्ट हुआ 1:05 में निकाल कितने 3 बंदे को फारिग कर दो किस तरह
ये अच्छा
वो कहता है आपका 10वां नंबर है जल्दी आओ मैंने कहा 6-5 मिनट में 3 बंदे फारिग हो गए तो मेरे कहते फिर उसको दोबारा कहा कहता है मैंने कहा मैंने नहीं है ना कहता मैंने इसलिए कहा कहता खाना ही नहीं है आपने
तो काम चल कैसे लग रहा है तुम्हारा in terms of learning? बहुत मजा मैंने रिसर्च का काम किया है जैसे हाईकोर्ट स्लो है प्रैक्टिस करते हैं तो हाईकोर्ट कचहरी वाला सीन तो यहाँ है कोर्ट की जब जाते हैं हम ऐसे ऑडियंस जाकर मतलब बोलते हैं हम अगर पिटीशन फाइल करना चाहें तो पिटीशन we are like जो भी चीज इसका कॉन्ट्रैक्ट भी हुआ है और कुछ ने छोड़ा भी है ब्रेक में एक और अच्छा तो सेकंड मंथ भी रहेगी नवंबर में उसकी जगह पे लेकिन हम सबकी इधर इस तरह अच्छा डबल 1 मंथ हमें डबल अच्छा 90 एक्स्ट्रा और 45 चलो ये तो हो गया पैसे कैसे मिल रहे हैं सही है अभी तुम लोग क्या करें क्या है सस्ती थी पहले से क्या अब तो इस कॉन्ट्रैक्ट कुछ भी नहीं आप तो लेकिन जब तक हम आगे करती 11 से आगे काम कर फर्क नहीं पड़ता अगर होगा अब फर्क पड़ता हाँ मेरी पे जो है कुछ कवर करती है बचपन से कोटा जा रहे अगर मास्टर्स के लिए गई तो कैसे करोगे कोई रोला भी डालेंगे
आप जाइए बात जाइए फौरन चली जाइए इसमें जा और कहाँ गया इनको मैंने नहीं जाए वो पहली बात मतलब लाइक करो जल्दी कर जल्दी कर दो पॉसिबल हो जाएगा अलग लेवल की डिटर्मिनेशन चाहिए मैं अपनी जगह को नेचुरली मैं तो कदरे आसान है कदरे आसान अभी देने पड़े 10-12 आपको कुछ नहीं मिला प्राइवेट की जाओ तो आसान आपको अब मुझे कह रहे हैं ह्यूमन राइट्स पर जॉब मेरा मूड यार कॉर्पोरेट में रह गया मेरा टैक्सेशन पढ़ाया और खराब है लेकिन क्योंकि मैं पर्सनली कुछ ऐसा चाह रही हूँ कि कुछ बातें तो कॉम्प्रोमाइज तो पहली
कज़न है यार, अब इसका मुझे पता है कि वो कितनी अच्छी है। अब बचपन में और भाई की भी है। अम्मा was rethinking about it, but before she could say anything, and I was in no position to oppose or regard it. She sensitive or something. ऐसी भी है जिसकी ये है वो बहुत सारी चीजें समझ बट शी इज काइंड ऑफ सिंसियर पर बदले में कभी पेश तो होते हैं बहुत ही नई तरीके हैं उससे ज़्यादा तो पता है मुझे मेरे भाई को नहीं पता मुझे लगता है ग्रेटफुल जैसे कंप्लीटली मेरा कोई इरादा नहीं करता प्रॉस्पेक्ट नहीं देखा मेरे घर वालों को कोई प्रॉस्पेक्ट नहीं never interested starting my show कोई भी पढ़ता नहीं है पता नहीं क्या होगा दो जगह नहीं करूँगी ये बात होगी हमारे वाला का डिस्कस सबसे लॉ करके निकल अब मुझे हम जा रहे हैं
यार ये YouTube पे लाइव जो
हमें भी जा रहा था हम करते हैं बिल्कुल करते हैं एक्चुअली आप मुझे हमारी एक और कॉफी खाने को लाइव किया था जैसे कोई बात सारा कुछ अच्छी बात
कसम खुदा की हमारे ये देख सुन रहे हो ना पूरी जगह फंस गया जब मैं आ गया नीचे तुम कहाँ हो जानचो तो नहीं करेंगे
हमारे लिए प्रेजेंटेशन इसमें कन्वर्ट कर दीजिए
ये वाला ऑन कर दे ये
इलेक्ट्रिशियन को करना ये नहीं है पॉइंटर भी
पॉइंटर तो उधर ही है रिमोट का है
और ये पड़ा
ऑन
अब उनकी स्लाइड से वो चल जाएंगे आपके पास वो है
वो तो पड़ा ना
उसको ऑनलाइन कुछ भेज के हाँ that's a problem with all these kids बच्चे का बस बात करते हो I think but they can set table and not do anything and that's on the job ये भी बात सही है I think अगर वो रोज में कहेंगे कि मैं जान दूँ तो मना तो नहीं करोगे ना लाइक आई भी आपने देखना नहीं अगर मैं पिछले वाले को निकाल सकती हूँ मैं इसको मना नहीं कर सकती हूँ और इतना लेताड़ी हूँ मेरे पास बहुत कह देती है लेकिन जब मैं स्टार्ट हुआ इसमें ये नहीं आया
नंबर वाली कर देते
प्रॉब्लम बहुत
काफी हो गए हाँ वो भी है
लैपटॉप से जा रही थी बंद हो इसको मीट कर देते ऐसा करना ये तो ट्राई तो करते ये तो भी है
Now we will have our third lecture on the topic of bilateral investment treaties from developing world perspective by Dr. Sadia Zahoor. I'll cite a brief introduction of Dr. Sadia Zahoor. Dr. Sadia Zahoor is a policy expert, non-traditional security at the Strategic Policy Planning Cell, National Security Division, Pakistan. Earlier, she worked at the ICRC as a legal consultant, at the Ministry of Foreign Affairs as an assistant legal advisor, and as an assistant professor at Bahia University, Islamabad. She has taught at the International Islamic University, Islamabad. Moreover, she has received her LLB honors, LLM International Law and PhD from Islamic University, Islamabad. She has attended the Center for Studies and Research in International Law and International Relations at the Hague Academy of International Law, the Netherlands. She holds a diploma in Investor State Arbitration from the College of Law, American University, Washington. She also attended the Singapore International Arbitration Academy 2022 and earned her Humanitarian Response to Conflict and Disaster certification from Harvard University. Dr. Zawar, the floor is all yours. Yeah.
Obviously, you want me to speak at the mic, right? I can't walk. So, okay. I have tried to listen to some of the conversations that you had earlier with other lecturers and speakers. Obviously, they have obviously both of them. I work with them in different capacities, and I understand they're the scholars of their and practitioners of their area. However, I'm here to sort of contradict everything that they have told you so far. It's not because my lecture topic is to give the perspective of developing world, but also because the history shows that the purpose of the BITs was never to increase investment in developing countries. That was never the idea. That was never the story. In fact, I even heard a lot of speakers saying that Pakistan was the first country to sign a bilateral investment treaty with Germany, which is absolutely correct. But was it something new, something path-breaking? Maybe not. When I'm saying this, I understand that maybe I'm crossing that sort of line that people expect from somebody who has an interest in investment arbitration. So first thing first, before I start my lecture, is that I am representing myself. I'm wearing the I am not representing the government of Pakistan or my institution. Also, I think the idea is not to undermine the importance of investment arbitration mechanism or bilateral investment treaties. The idea is to understand what you want to achieve from these treaties. And I also want to talk a bit about, I know that Mudad has tried to explain to you the capacity issues that Pakistan has, and the blunders that we have made in earlier arbitrations. But I will still talk a bit about that too, because you can't blame everything on international organizations, on bilateral investment treaties, and not understand what you are doing wrong. So the idea is okay, so it's difficult for me to stand in one place and talk. Anyways, the idea is that I just don't want to create some sort of disturbance with the voice. The idea is to have this discussion and understand that these bilateral investment treaties are important, and will remain important in coming times at least. But the idea is that but you have to also understand what is the direct link between the direct investment and foreign direct investment and BITs. Also, you have to understand whether this mechanism was a product of colonialism, and because these countries were getting independence, but they were trying hard again to make sure that they don't have their control over the resources. Obviously, these ideas are like not in a black and white. You have to operate in a gray area. So I will try to explain the origins of BITs. Then I will try to make you understand the link between FDI, foreign direct investment, and BITs. And then the capacity of countries like Pakistan or other third world countries to deal with these BITs and investment arbitration. So it's just not the BITs mechanism, it's not the international institution, but it is also our own capacity, our own blunders, which has made it difficult for us to work smoothly with these systems. And lastly, obviously, जब चीज़ें बहुत ख़राब होती हैं तो फिर obviously इसमें corrections भी आती हैं. And ये natural सा एक phenomena है. when there was a lot of criticism, there was a lot of debate. Obviously, there are reforms now, not only in the mechanisms, investment dispute settlement mechanism, but also new age BITs are emerging. Pakistan itself is in the process of negotiating new BITs, and we'll try to discuss that. Third world countries or global south or countries like Pakistan have this belief that these BIT system did emerge as a reason for, because that we want to make sure that कोई unfairness ना हो, ठीक है, और unfairness को खत्म करने के लिए और investment के right को protect करने के लिए हमने BITs बनाई थी. लेकिन eventually हुआ ये है कि ये BITs खुद ऐसा system बन गई हैं जो unfairness को promote करती हैं. So आइडिया ये था कि जो फॉरेनर्स बाहर से पैसा इन्वेस्ट कर रहे थे वर्ल्ड कंट्रीज में और डेवलपिंग कंट्रीज में और न्यूली इंडिपेंडेंट स्टेट्स में, इन 50s एंड 60s की बात कर रही हूँ, उनमें जो लोगों का इन्वेस्टमेंट है प्रोटेक्ट हो. और इसकी रीजन क्या है? इसकी रीजन ये है कि जब कंट्रीज का फर्स्ट वेव ऑफ इंडिपेंडेंस शुरू हुई, लोगों ने इंडिपेंडेंस लेना शुरू की 40s में, कंट्रीज लाइक पाकिस्तान, इंडिया, एंड देन सेकेंड वेव आना शुरू हुई. तो जब ये नए कंट्रीज जब इंडिपेंडेंस दिया कॉलोनिस्ट से, तो उनको ये ख्याल था कि जो हमारे रिसोर्सेज है इन पे हमारा हक है. We are the sovereign state now, independent state now, and we own our resources, and we will use our resources the way we want. ये आइडिया था. अब इस आइडिया को एग्जीक्यूट करने के लिए इन कंट्रीज ने क्या किया? इन कंट्रीज में कुछ गवर्नमेंट्स ने जो फॉरेन इन्वेस्टर्स थे, क्योंकि ज़ाहिर जैसे पाकिस्तान था, इसमें बड़ा बिजनेस कौन करता था? हम हमेशा ही कहते हैं ना कि गोरा हमारा सारा रिसोर्सेज लूट के चला गया, आज तक हमारे पैसे पे कर रहा है, कोहिनूर भी ले गया, आज इंग्लैंड के पास है क्या सिवाय हमारे रिसोर्सेज के, हमारे मसाले, हमारा सब कुछ. सो द आइडिया वॉज कि उस वक्त ज़्यादातर जो बिजनेस इंटरेस्ट थे फॉरनर्स के थे, और यहाँ पे या तो उनको नेशनलाइज कर दिया गया, ठीक है, और उस नेशनलाइजेशन के रिजल्ट में उनको कॉम्पनसेशन नहीं दी गई, कुछ जगहों पर अटैक किया गया, ठीक है, ये एज्यूम कर लिया गया कि ये हमारे रिसोर्सेज है, हमने आज़ादी ली है तो हम इनको भी अब कंट्रोल में करेंगे, ठीक है. सो दैट वाज द आइडिया ऑफ डेवलपिंग एंड न्यूली इंडिपेंडेंट स्टेट्स. और इंडिपेंडेंट स्टेट्स को क्या फिक्र हो रही थी कि हमारा जो इंटरेस्ट है, हमारा जो बिजनेस इंटरेस्ट है इन डेवलपिंग कंट्रीज में, वो खतरे में है. तो हमें ऐसा मैकेनिज्म बनाना चाहिए कि इन डेवलपिंग कंट्रीज में या ये जो न्यूली इंडिपेंडेंट स्टेट्स है, इसमें हमारे इंटरेस्ट, बिजनेस इंटरेस्ट प्रोटेक्ट हो और हमारे प्राइवेट जो प्रॉपर्टी है वो प्रोटेक्टेड रहे, ठीक है. सो दैट वाज द आइडिया जिसके उस पे बेसिस पे BITs क्रिएट हो रही थी. सो ultimately that turned into a system which itself is now unfair, which is unfair to third world countries or developing countries or global south. So that because उसका मैकेनिज्म ऐसा बन गया कि प्रोटेक्ट करते करते डेवलपिंग स्टेट्स का या होस्ट स्टेट का तो बहुत ज़्यादा राइट्स बन गए, लेकिन ड्यूटीज बन गई, कोई राइट्स नहीं बने, और जो आपका इन्वेस्टर है उसके सब राइट्स हैं और ड्यूटीज नहीं हैं, ठीक है. ये जो आपकी फर्स्ट वेव ऑफ BITs थी. सो मैंने खुद भी और बहुत से लोग आपको सबसे पहले बताते हैं कि पाकिस्तान पायनियर था BITs का, और पहली BIT जो थी जर्मनी और पाकिस्तान के बीच में. यू कैन इग्नोर माय प्रेजेंटेशन बाय द वे, सो यू कैन लिसन टू मी ओनली, क्योंकि आपको जस्ट पॉइंटर्स एंड आई जस्ट वांट टू गिव यू द हिस्ट्री. जब ये बनना शुरू हुई कि जर्मनी और पाकिस्तान को एक BIT साइन की है और पाकिस्तान इनिशिएट किया था, तो स्टोरी है कि पाकिस्तान क्यों, जर्मनी क्यों, why Germany and why Pakistan? So there is history. Germany की history, Pakistan की history. Pakistan was independent state जिसने इंडिपेंडेंस के फौरन साथ ही 2 ट्रीटी साइन कर दी अमेरिका के साथ, और गुड ट्रेड एंड फ्रेंडशिप कॉमर्स एजुकेशन ट्रीटी साइन की. और उस कॉन्टेक्स्ट में पाकिस्तान के जो ब्यूरोक्रेट्स हैं वो बहुत ईगर थे दुनिया के साथ ट्रीटी साइन करने के लिए, obviously with the best of the intention, and the intention was to make sure that Pakistan has the first mover advantage और हम अपने ज़्यादा से ज़्यादा एडवांटेज ले सके, अपने मुल्क में इन्वेस्टमेंट ला सके. जर्मनी की स्टोरी क्या थी? जर्मनी की स्टोरी ये थी कि अमेरिका ने उस वक्त एक केस हुआ था, ग्वाटेमाला में एक कंपनी थी, अमेरिकन कंपनी थी, फूड्स की कंपनी थी, और उसको नेशनलाइज कर दिया गया था. अमेरिका ग्वाटेमाला का साइज एंड पावर इवन इन 40s एंड 50s आज भी बहुत डिफरेंस है उनके बीच में. तो ये डेवलप्ड कंट्रीज के बीच में एक फियर था, if Guatemala can do this to America, all these countries can do this to us also. And Germany by that time, in the 1940s and 50s, both US and Germany were our largest trading partners. हमारे उस ज़माने में भी 47 में भी अमेरिका, और आज भी by the way still America is our one of the largest trading partner. हमारी सबसे ज़्यादा imports जो है exports जो है वो अमेरिका के लिए है. So उस जमाने में भी था, तो पाकिस्तान की एक तो ट्रीटी अमेरिका के साथ हो गई, फियर भी बन गया कि ग्वाटेमाला कर सकता तो कोई मुल्क भी कर सकता है। जर्मनी के साथ क्या है, जर्मनी लॉस्ट मोस्ट ऑफ इट्स इन्वेस्टमेंट, फॉरेन इन्वेस्टमेंट्स, बिकॉज आफ्टर सेकंड वर्ल्ड वॉर। सेकंड वर्ल्ड वॉर के बाद उनके साथ काफी आपको हिस्ट्री, आई होप आई डोंट नो यू गाइस आर गुड, इफ यू आर लॉ स्टूडेंट्स एंड यू आर स्टडीइंग इंटरनेशनल लॉ, आई एम श्योर कि आपने सेकंड वर्ल्ड वॉर के बारे में in other subject matters also पढ़ा होगा, and they lost a lot of their foreign investment to the second world war, जो second world war जब हो गया, तो उनका ये फियर और बढ़ता जा रहा था। लेकिन जब उनकी इकॉनमी दोबारा डेवलप कर रही थी 50s, so they have a trade surplus। ट्रेड सरप्लस का मतलब है उनके पास पैसा है लेकिन इन्वेस्टमेंट करने की जगह नहीं, तो इन्वेस्टमेंट कहाँ करते हैं, फिर आप जाके उन जगहों पे करते हैं जहाँ पे रिसोर्सेज हैं लेकिन इन्वेस्टमेंट नहीं है, इट्स ईजियर टू इन्वेस्ट। तो उनके लिए बहुत अच्छी मार्केट थी डेवलपिंग कंट्रीज एंड न्यूली इंडिपेंडेंट स्टेट्स लाइक पाकिस्तान। सो उनका एक फियर ऑफ जो कि अमेरिका के साथ हुआ, सेकंड दे हैव सरप्लस फंड्स, तीसरा उनकी अपनी हिस्ट्री वेयर दे लॉस्ट अ लॉट ऑफ फॉरेन इन्वेस्टमेंट बिकॉज़ ऑफ सेकंड वर्ल्ड वॉर, एंड तीसरा ये अब है कि उनकी ट्रेड सरप्लस है और उनको कहीं ना कहीं इन्वेस्ट करना है। लेकिन वो डर रहे हैं कि अगर हमने इन्वेस्ट किया और वहाँ पे हमारे इन्वेस्टमेंट जो है वो डेवलपिंग कंट्रीज लाइक न्यू इंडिपेंडेंट कंट्रीज लाइक पाकिस्तान और नेशनलाइज कर दिया, प्रोटेक्ट ना किया, बिकॉज दे आर एसेंशियली कंसीडरिंग यू बारबेरिक नेशंस आल्सो ना, कि कोई तमीज नहीं है, ये उनकी ये दिस इज नॉट मेक इट अप, दिस इज ये आपका आप यू कैन रीड, आई विल गिवन द रीडिंग लिस्ट एट द एंड, ब्रीफली उसमें पहला आर्टिकल यू कैन रीड दैट एंड यू कैन फाइंड आउट कि वो एक्चुअली ये समझते थे कि ये मुल्क जो है इनको अब रिस्पेक्ट नहीं रही है प्राइवेट प्रॉपर्टी के लिए, वी कैन नॉट ट्रस्ट देम विद आवर प्राइवेट प्रॉपर्टी एनीमोर। सो उनका अंडरस्टैंडिंग ये है कि आप लोग यू आर नॉट सिविलाइज्ड इनफ टू एंटरटेन इन्वेस्टमेंट फ्रॉम अदर कंट्रीज, ठीक है। सो नेवर फॉर अ मोमेंट इमेजिन कि वो आपके मुल्क को तरक्की देना चाहते थे, डेवलपमेंट करना चाहते थे और फॉरेन डायरेक्ट इन्वेस्टमेंट लाना चाहते थे आपके मुल्क में, बस वो आपको ट्रस्ट नहीं करते थे और अपने ट्रस्ट प्रोटेक्ट करना चाहते थे, which is fair from their side, it is absolutely fair, every state should do that, protect their own people and their own interest, ये हर मुल्क का राइट है, justified right है। So Germany has जो जर्मनी है वो यूएस के साथ constant contact में था कि कैसे ये किया जाए, और अमेरिका ने सिस्टम निकाला था फेडरल सिक्योरिटीज का कि अगर वो अपने वो इन्वेस्टर से कहते थे कि अगर आप किसी डेवलपिंग कंट्रीज में, थर्ड वर्ल्ड कंट्रीज में इन्वेस्ट करेंगे और उधर आपको कोई नुकसान हुआ तो फेडरल गवर्नमेंट जो है आपकी वो हमें आपको सिक्योरिटी देती है कि आपके फंड जो हैं हम उनको सर्कुलेशन जो होती है हम आपको आपकी कॉम्पनसेशन स्टेट कर देगी और फिर स्टेट टू स्टेट जो है वो हम क्लेम कर लेंगे। सो फेडरल सिक्योरिटीज के बारे में जर्मनी में बहुत डिस्कशन थी, अमेरिकन प्रिंसिपल ये था और जर्मनी के अंदर भी ये बहुत बड़ी डिस्कशन थी कि हम फेडरल सिक्योरिटीज देते हैं लेकिन हम ट्रस्ट करते हैं डोमेस्टिक लॉ ऑफ द होस्ट कंट्री को। फॉर एग्जाम्पल पाकिस्तान में अगर कुछ है तो हम अपने लोगों से कहते हैं कि आप इन्वेस्ट करो और अगर कुछ गड़बड़ हुई तो हम कॉम्पनसेट हम कर देंगे तुम्हें, लेकिन हम उनको रिलाई करेंगे उनके डोमेस्टिक लॉ में। एंड देन दे रियलाइज कि नहीं, these barbarians do not have this capacity to defend or do not have a rule of law, तो उन्होंने कहा कि नहीं हमें इनसे करनी पड़ेगी ट्रीटी, और फिर ट्रीटी का कॉन्सेप्ट आया और उन्होंने एक लिस्ट बनाई 25 कंट्रीज की जिनके साथ आराम से ट्रीटी कर सकते और एक एग्जाम्पल सेट कर सकते। These are the language of their communication with Americans. ये कोई मैं खुद से नहीं बता रही हूँ कि प्रूव की बुरी चीज है, नहीं बुरी चीज नहीं है, पर वो ये बात समझ रहे थे कि आप लोग all the developing countries do not have this capacity and fair enough। जब भी मुल्क इंडिपेंडेंट होते हैं, खास तौर हमारे ऐसे मुल्क जो कॉलोनीज थे वो ऑब्वियसली उन्होंने हमें बैकवर्ड रखा है, हमारे लीगल सिस्टम को भी इतना एडवांस नहीं किया है, सो वो ट्रीटीज करना चाहते थे। उन्होंने 25 मुल्कों की लिस्ट बनाई, पाकिस्तान वाज नॉट टॉप, उनको ये ख्याल नहीं था, लेकिन पाकिस्तान वाज ईगर। सो देयर वाज पाकिस्तान की ईगरनेस इसलिए थी कि पाकिस्तान इंडिपेंडेंट हुआ था और आपको मालूम है कि जो इंडिपेंडेंस के वक्त में जो डिवीजन हुआ था रिसोर्सेज का वो फेयर नहीं हुआ था, वी डिडंट गेट मच ऑफ द मनी एंड रिसोर्सेज एंड शेयर दैट वी हैव इंडिया से। तो वो पाकिस्तान के लिए जो क्रंच था, आपको पता है पाकिस्तान ने शुरू में ही विदिन फ्यू इयर्स वी स्टार्टेड लुकिंग फॉर लोन्स एंड एड एंड सारा कुछ, एंड हमने उसमें हमारे लिए प्रॉब्लम था फाइनेंशियल क्रंच। आई थिंक व्हेन आई वाज रीडिंग द हिस्ट्री आई वाज थिंकिंग कि कुछ भी नहीं बदला इस मुल्क में, द मोर वी change, the more we remain the same. Sorry, but again, not our fault in most cases, but some cases heavy. So उसमें जर्मनी ने पाकिस्तान ने अपनी ईगरनेस शो की। इंटरेस्टिंगली पाकिस्तान के जो ट्रेजरी जो थे सेक्रेटरी थे ट्रेजरी सैनी साहब, वो इंटरेस्टेड थे इस ट्रीटी को और इसमें वो नेगोशिएट कर रहे थे, अमेरिका के साथ भी किया और जर्मनी के साथ भी किया, बट अदर पीपल वर नॉट दैट एक्साइटेड विद इन पाकिस्तान ऑल्सो। वर्ल्ड बैंक ने हमें बताया कि आप ये मत करें, वर्ल्ड बैंक ने एक्चुअली इसके अगेंस्ट कहा कि आप ये ट्रीटी साइन मत करें इन्वेस्टमेंट की, और हमें अब लोन्स के बारे में भी थोड़ी थोड़ी हल्की हल्की धमकी दी उस वक्त में भी. दिस इज रिकॉर्डेड, यू कैन रीड अबाउट दिस एंड आई एम नॉट मेकिंग अप. एंड उन्होंने जब ये बात की तो फिर the secretary of IPRI was not willing to do this and हुसैन साहब बहुत एक्साइटेड थे. फिर जर्मनी ने एक्चुअली वर्ल्ड बैंक को कन्विंस किया और जर्मनी से वर्ल्ड बैंक उधर से कन्विंस हो गया और हमने वो ट्रीटी साइन कर ली. एंड अगेन आइडिया ये होता है कि एंड इट्स वेरी इंटरेस्टिंग, आई डोंट नो मैंने इसमें लिखा या नहीं लिखा, लेकिन जब हुसैनी साहब वापस आए ट्रीटी साइन करके तो उन्होंने बताया कि ये पाकिस्तान को फर्स्ट मूवर एडवांटेज देगा, पाकिस्तान में इन्वेस्टमेंट आएगी, पाकिस्तान का सुनहरे दौर का आगाज हो गया. दिस इज व्हाट इज कोटेड टू मीडिया एंड आई वाज थिंकिंग God, this is cycle that we are never gonna get rid of. तो वो हमारे सब कुछ अच्छा होगा हमारे लिए, हम फर्स्ट मूवर एडवांटेज है. What's the Pakistan could cash on the lead and try to press home the advantage to attract foreign capital. So this was Hussaini telling us India कि बहुत amazing काम मैंने कर दिया और आपका. Hussaini later became retired and he became the governor of Pakistan and अयूब ने उनको बना दिया था. Interestingly, अयूब खान को मिलने आए थे जर्मन मिनिस्टर और उन्होंने कहा था कि पाकिस्तान को ना अपनी इंडस्ट्रियलाइजेशन वाली सोच छोड़ देनी चाहिए और एग्रीकल्चर को फोकस करना चाहिए और लेबर को जो डिवीजन ऑफ द लेबर ग्लोबल डिवीजन है वो करनी चाहिए. यानी हम इंडस्ट्रीज हैं, हम आपको प्रोवाइड करेंगे इंडस्ट्रीज और आप खाना उगाएं और हमें खाना प्रोवाइड करें. सो और लेबर आपका काम है ज़राअत करना, हमारा काम है इंडस्ट्री बनाना. तो आप इंडस्ट्रियलाइजेशन मत जाए. ही केम एंड ट्राई टू कन्विंस यूथ टू फॉरगो हिज इंडस्ट्रियलाइजेशन प्लान. ठीक है, और उसके बाद हमने ट्रीटी साइन कर ली. सो मुझे समझने से मुश्किल है मेरे लिए समझना कि हम एक्चुअली कैसे समझते हैं कि DITs बनाई गई थी हमारे मुल्क के अंदर फॉरेन डायरेक्ट इन्वेस्टमेंट लाने के लिए या किसी किस्म की इन्वेस्टमेंट लाने के लिए. इट वाज नेवर द आइडिया. इट वाज टू कीप अस वेयर वी वर, वी आर एंड एंड उसमें कोई कसूर नहीं है. ट्रीटी अगर आप पढ़े तो उसमें सब अच्छी बातें लिखी हैं. एक्चुअली द प्लॉय वाज प्लांटेड कि ये तो हमारा कंसर्न है ना कि हम करेंगे, लेकिन अगर हम जर्मनी पाकिस्तान को चाहता है कि वे देखो हमारा मसला ये कि अपने लोगों को प्रोटेक्ट करना चाहते हैं, ट्रीटी साइन कर लो, आप ना करते. लेकिन ये डॉक्यूमेंटेड चीजें हैं कि उधर कहा गया कि हमने अगर सेल करना है इस ट्रीटी को तो हमें उनको बताना है कि आपके लिए डेवलपमेंट आएगी, आपके लोगों की जॉब क्रिएशन होगा. ठीक है, जो अगर आप जर्मनी की ट्रीटी निकाल के पढ़े आपको इंटरनेट पे मिल जाएगी आराम से. और ट्रीटीज आई होप समबडी हैज आपको टाइम बताया होगा कि आप सुन सकते हैं. A lot of the material was and by the way, जैसे जर्मनी ने हमें वो ड्राफ्ट दिया था जो कि उनके बजट में उन्होंने बजट डॉक्यूमेंट के साथ एक्ट के साथ लगाया था, उसमें कोई चीज नहीं था. It was by and large what was approved by the parliament, shared by their ministry. हमने उस पर कोई ज़्यादा जिद किए बगैर उसको अप्रूव कर दिया. आई एम नॉट सेइंग कि ये गलत बात है या अच्छी बात है, मैं जजमेंट कॉल नहीं कर रही हूँ, पर मैं वैसे एक बात कर रही हूँ. अगर मैं और आप एक नेगोशिएशन कर रहे हैं और हम दो सॉवरेन कंट्रीज हैं और आप मुझे डॉक्यूमेंट दे रहे हैं तो फिर मेरी कोई इनपुट तो होनी चाहिए ना. कुछ मुझे भी तो सोचना चाहिए ना कि इसमें मेरा इंटरेस्ट क्या है. उनका बजट का डॉक्यूमेंट अटैचमेंट जो थी जो उनकी मिनिस्ट्री ने हमारे साथ शेयर की बाय एंड लार्ज वो अप्रूव हो गई. एंड ऑब्वियसली देयर इंस्पिरेशन वाज अमेरिकन ट्रीटीज. लेकिन अमेरिकन जो FCN ट्रीटीज थी उनका प्रॉब्लम ये था कि वो बहुत बड़ा डॉक्यूमेंट होता था, उसमें इन्वेस्टमेंट एक पोर्शन था बट द अदर थिंग टैक्सेशन एंड एवरीथिंग एंड वाज डिफिकल्ट टू एग्री ऑन दोस बिग डॉक्यूमेंट्स. सो DIT ने उसमें से जो जर्मनी में पाकिस्तान की थी एक्चुअली उसमें से निकाल लिया था इन्वेस्टमेंट वाला पोर्शन. एंड इसलिए लोग कहते हैं एंड बाय द वे इट वाज केप्ट सीक्रेट फॉर 2 years ताकि बाकी लोग इंसिस्ट ना करें बाकी मुल्क. फिर वो आफ्टर 2 years इट वाज पब्लिश्ड बाय जर्मनी बट इट बिकेम वेरी फेमस. जर्मनी के जितने बड़े कैपिटल्स में एम्बेसीज थी उन्होंने डॉक्यूमेंट मंगवाया और फिर उसको साइन किया और फिर विद इन नेक्स्ट 10 years hundreds of new DITs were signed by different countries, mostly by developed countries with the colonists. So देखिए वो क्या है, ट्रेंड क्या है कि जर्मनी ने कर लिया, बाकी जो कॉलोनिस्ट कंट्रीज है UK है, स्पेन है, अब वो ट्रीटीज DIT साइन कर रही है कॉलोनीज के साथ, जो फॉर्मर कॉलोनीज है उनके साथ अपने इंटरेस्ट को प्रोटेक्ट करने के लिए. और DIT जो जर्मनी और पाकिस्तान के बीच में साइन कर लिया which was inspired from FCN अमेरिकन. अमेरिका ने खुद एक्चुअली रेजिस्ट किया DITs को साइन करने के लिए until very late in the 70s जैसे स्टार्ट जो प्रोग्राम होते उन्होंने एक साल बहुत साइन की. तो आप दो बातें आपको नजर आएंगी अगर आप शुरू की DITs का ट्रेंड देखें. एक देयर वाज अ डीकोलोनाइजेशन की एक मूवमेंट जहां मुल्क आज़ाद हो रहे और these treaties are mostly between colonists फॉर्मर कॉलोनिस्ट एंड फॉर्मर कॉलोनीज, ठीक है, यानी यूके पाकिस्तान, जैसे हम उनकी कॉलोनीज और हम बाकी लोग के साथ कर रहे हैं। सो इनिशियली द बीआईटी बिटवीन टू इक्वल्स नहीं थी, यानी कि जर्मनी यूके को कोई इंटरेस्ट नहीं था यूके के साथ ट्रीटी साइन करने में, यूके यूएस को नहीं था। लेटर ऑन देयर आर स्लाइटली थोड़ा चेंज हुआ है, लेकिन नहीं, मोस्ट ऑफ देम स्टिल अभी भी जो है वो एसिमेट्री बहुत ज़्यादा है। ओवरवेलमिंग 55% अभी भी जो होता है, जहाँ पे एक वीक कंट्री होता है, पावरफुल कंट्री होता है, ठीक है। ये भी मैंने देखा है ट्रेंड, 2 मिलियन पावर्स टाइप जो मिडिल पावर्स होती हैं वो साइन करती हैं, बट रेयरली अभी होता है, लेकिन रेयरली होता है कि 2 इक्वल कंट्रीज, डेवलप्ड कंट्रीज साइन बीआईटी। आई एम नॉट सेइंग दैट it's non-existent, but I'm saying it's not the trendy thing. Trend यही है कि ये जो barbaric middle class, lower class countries हैं जिनको पता नहीं है लॉ कैसे फुलफिल करना, उनकी ये ट्रीटी बना दो तो वो करें। So there is an asymmetry between the resources. आप इक्वल स्पीच पर ट्रीटी नहीं करें, इसका ये बात बताने का जरूरी क्यों है? ये बताना इसलिए जरूरी है कि जब एक पावरफुल कंट्री एक वीक कंट्री के साथ ट्रीटी साइन करता है तो आपके पास डिसएडवांटेज होता है और a lot of different levels. एक डिसएडवांटेज ये है कि जाहिर है उनके पास पावर है, यू आर द नीडी वन, आपको रिसोर्स चाहिए, आप ये अज्यूम कर रहे हैं कि फॉरेन डायरेक्ट इन्वेस्टमेंट आएगी तो हम इनकी स्ट्रिक्ट से स्ट्रिक्ट बातें मानते जाते हैं, ठीक है। दूसरा ये जो एडवांस कंट्रीज हैं, when I was looking for material, I was reading about Germany और उनका नेगोशिएशन अमेरिका से पूछ रहे हैं, कॉन्वर्सेशन हो रही है, इंटरनल डिबेट हो रही है। I didn't find anything of within Pakistan. पाकिस्तान के अंदर क्या डिबेट है सिवाय इसके कि एक मिनिस्टर ने रिजिस्ट किया, गिव अप कर दिया पॉइंट, बिकॉज उनके रिसोर्सेज डिफरेंट है, उनका स्किल लेवल डिफरेंट है। आज भी I was listening to earlier lectures and I was आपको बता रहे थे कि सीट लंदन में भी होती है, I think you said hypothetically, you know, it could be Istanbul also, but how many हाँ but कितनी proceedings, you know, आप सिंगा को बना दिया। Apparently Bombay is emerging as something, you know, important of arbitration के लिए, but लंदन है और I think you said that मौसम अच्छा है is not an issue, but I can guarantee you I have seen people adding the clause कि लंदन में करते हैं मेरे बच्चों का फिर पेट्रोल लग जाता है, सर क्या करें, डाल दें। So laundry list of arbitration cases पाकिस्तान ने किया है। So if I'm on YouTube and people listening to me, this has happened in this country where people have अपने इंटरेस्ट के लिए उन्होंने इस मुल्क के इंटरेस्ट को कुर्बान किया है। और again the seriousness was never there of BITs. मखदूम अली खान फेमसली हमारे अटॉर्नी जनरल पहला वो केस नहीं था बेसिकली, लेकिन दूसरा केस था जब स्विट्जरलैंड की BIT में वो किया गया। So उनको जब मिनिस्ट्री में जब लेटर आया, I know those were trying to explain to you कि हमारे पास लेटर आता तो हम क्या करते, हर वक्त नहीं सोते, कभी हम भिजवा देते हैं अटॉर्नी जनरल ऑफिस को कि ये नो क्या आ गया है, क्या करना है, तो हम बोलते हैं कि हर डे पहला ये रिकॉर्डेड चीज़ है। मधु मरी खान ने लेक्चर में बहुत दफा कहा है, मैंने आज अपनी किताब में लिखा है, तो लॉट ऑफ पीपल एंड गोरा सर आल्सो मेंशन दिस इन देयर बुक्स, अ लॉट ऑफ बुक्स मैं वाज स्टडीइंग बाय द पाकिस्तान के जो केस स्टडी है ना, वो हर यूनिवर्सिटी में जब आप पढ़ते हैं इन्वेस्टमेंट आर्बिट्रेशन वो जरूर पढ़ाते हैं, और उस वक्त आप सोच you know, it's difficult to speak or say a lot of you know hard truths in Pakistan, but globally when people talk about investment arbitration and you know court case studies, तो पाकिस्तान पढ़ाते हैं। तो मधु मरी खान साहब को कहते हैं कि मुझे मिनिस्टर एक्सेक्रेटरी ने भेजा कि ये हमारे पास केस आ गया, तो उन्होंने कहा कैसे कर सकता है कोई मिसू, हम तो सॉवरेन कंट्री हैं, हमें तो नहीं सू कर सकते। मधु मरी खान कहते हैं मैंने पहली दफा पढ़ा कि BIT क्या होता है, बायलैटरल इन्वेस्टमेंट ट्रीटी क्या है, तो कहते हैं मैंने गूगल किया कि बायलैटरल इन्वेस्टमेंट ट्रीटी क्या है, फिर हमें सर्च करना पड़ा कि पाकिस्तान की बायलैटरल इन्वेस्टमेंट ट्रीटी विद स्विट्जरलैंड कहाँ है, फिर हमें पता चला हमारे पास कोई रिकॉर्ड नहीं है। ये मैं सच बता रही हूँ, पाकिस्तान के पास कॉपी नहीं थी BIT की, और उन्होंने स्विट्जरलैंड से रिक्वेस्ट करके अपने फॉरेन ऑफिस से मंगवाई कि हमें प्लीज उसकी कॉपी देते, हम पढ़े तो सही हमने साइन क्या किए हैं। सो यू टेल मी आप क्या समझते हैं कि इन्वेस्टमेंट आर्बिट्रेशन, नो, he mentioned it and a lot of people have mentioned it in their books, that's what I'm saying, कि आप जो है हमने BIT साइन की क्योंकि हमारा तो मिनिस्टर जा रहा था, कोई वज़ीर आज़म जा रहा था, वो साइन करने के लिए पिक्चर फोटो ऑप के लिए कुछ नहीं था, तो फोटो ऑप के लिए हमें साइन कर दिया। मैं आज सरकार में आई गेट समटाइम्स कि वो मिनिस्टर साहब जा रहे हैं तो आपने वो इससे पहले कंक्लूड करिए, आपको अगर हो जाए तो हो जाए, if you agree on things it's fine, but this can't be a deadline that minister has to visit and there has to be something for all कि आपने BID साइन कर दी. So पाकिस्तान केस फेस कर रहा है और पाकिस्तान को मालूम, पाकिस्तान के पास किसी के पास कॉपी नहीं है उस डॉक्यूमेंट की. किताब में लिखा है, मैं अपनी पर्सनल इन्फॉर्मेशन नहीं शेयर कर रही. I want to tell you this again and again. And this is what Pakistan is. And then we आप सोचें कि उसके बाद पाकिस्तान को ख्याल आया कि पाकिस्तान की BID साइन करता है, जनरल साइन की है. पहली साइन करना फर्स्ट मूवर एडवांटेज. सैनिक साहब जिंदा होते तो उनको दुख होता कि उनको लगा था कि सबसे पाकिस्तान ने अगर पैदा किया था तो उसके बाद हम अपनी स्किल क्या डेवलप की. आप हम लोग ये आज IPRI के साथ भी, and I have a small contribution making this chair, so I will take small credit at least. तो कितनी मेहनत के साथ, कितने to find a person to head this chair, to find a house for that chair, everything was difficult. And so point is कि again the ideal point is कि आपके मुल्क में आज भी इस बात को सीरियस नहीं लिया जाता कि ये important issues हैं. Now we have people like Nudrat and other people who have this international exposure and मैं इस बात से इतनी नहीं करती क्योंकि मैंने जब सरकार में काम किया तो we have a working group of people. I'm not saying every member of the working group is exceptionally well versed with international investment arbitration, but we have people and 2 of them have given you lectures and they have given us input on investment arbitration treaties and other issues. So ऐसा नहीं है कि लोग नहीं और अब हैं आपके साथ कल भी होंगे. young people who are our hope, people like Rohini who is coming tomorrow, and so स्किल की बात नहीं है बट सीरियसनेस की बात है. ये सब लोग अपनी डिफरेंट कैपेसिटी में काम करते हैं. स्टेट के लेवल पे स्टेट की कैपेसिटी बिल्ड करना भी जरूरी है. एंड देन अगेन हम लॉयर्स को क्रिटिसाइज करते हैं और मैं सबसे ज़्यादा क्रिटिसाइज करती हूँ. अगर आपने there must be somebody here on the internet me bashing bureaucrats and civil bureaucracy, but the idea is कि लॉयर्स का कसूर नहीं है. आपको अपने तमाम लोगों को समझाना है. आपने हम अभी ये बात कर रहे थे, आपको अपने म्यूनिसिपल अथॉरिटीज के ऑफिसर्स को समझाना है कि जाके किसी फॉरेन कंपनी का चीज़ें नहीं बंद कर सकते, उसकी बिल्डिंग नहीं तोड़ सकते बिकॉज इसके रिपरकशंस हैं स्टेट के लिए. ठीक है, तो आप ये नहीं कर सकते कि मेरा दिल किया हम सॉवरेन कंट्री में जो मर्जी करें. हर बात की तो सोवरेनिटी एब्सोल्यूट नहीं है. हमने फुल अपनी सोवरेनिटी अपनी ट्रीटीज बाइंडिंग है. And remember, it's not international law which says that treaties are binding. It's also the religion that most of us follow. It says that treaties are binding. And I don't think there is any religion or any domestic law which says that treaty binding नहीं है. ठीक है, पाकिस्तान के पास इश्यूज बहुत सारे हैं. उसमें एक इशू हमारा ड्यूलिस्टिक स्टेट होना भी है. हम जब ट्रीटी साइन करते हैं, हमारा एग्जीक्यूटिव करता है तो हमारी पार्लियामेंट उसको एक्चुअली रेटिफाई नहीं करती. हमारी कैबिनेट इसको रेटिफाई कर देती है. सो अ लॉट ऑफ टाइम मुझे कई दफ़ा कॉल आते हैं, लोग पूछते हैं कि यार वो ट्रीटी साइन हुई थी तो रेटिफाई होती है बिकॉज वो रिकॉर्ड नहीं होता. अगर कभी वो खबर आ जाए तो आ जाए न्यूज़पेपर में, पर हम ये नोटिफाई नहीं करते प्रॉपरली कि हमने ट्रीटी रेटिफाई कर दी. नाउ इट्स एप्लीकेबल. एप्लीकेबल का मतलब है कि अब उसके कॉन्सिक्वेंसेस हैं आपके लिए ना और सरकार के लिए भी. फिर जब वो हो जाती है हमारी कोर्ट्स उनको मोस्ट ऑफ टाइम इम्प्लीमेंट नहीं करती. वो कहती है कि लॉ नहीं है. जब तक लॉ ड्यूलिस्टिक स्टेट या लॉ बनेगा, डोमेस्टिक लॉ बनेगा, पार्लियामेंट अप्रूव करेगी तब हम लाएंगे. सो ट्रीटी साइन कर लेते हैं, रेटिफाई कर लेते हैं, इंटरनेशनल अरीना में मार खाते हैं, डोमेस्टिक कोर्ट्स कहती हैं. एंड सुबह भी बात आपके साथ हुई जुडिशियल ओवररीच की, तो उसमें ये क्वेश्चन था पाकिस्तान इज अ सॉवरेन कंट्री. पाकिस्तान ने ट्रीटी साइन किया, हम क्या करें? कौन सी कहती हैं क्योंकि उनको आपने बताया कि डोमेस्टिक स्टेट है, आपके वो फाइंडिंग है सिर्फ जो कोर्ट पार्लियामेंट अप्रूव करती है. सो आपके अंदर सिस्टम के अंदर इतना गैप है कि आपको समझ नहीं आ रही है कि ये सब बात किस तरह लिंक है. जो जुडिशियल शुड बी वेल वर्स्ड इन इंटरनेशनल लॉ. हर लॉयर नहीं हो सकता, but people should understand, and then the parliamentarians should understand the consequences of ratifying a treaty and not making it a law. और देखिए ये सब बातें आपकी इकोनॉमी के साथ भी जुड़ी हुई हैं. आपकी इकोनॉमी वीक है इसलिए आपकी स्टेट कोशिश करती है. आपकी स्टेट की टेंशन वैसे टेंशन होती है कि यार कोई एग्रीमेंट हो जाए, कोई इन्वेस्टर आ जाए. आई थिंक गुजरात आपको बता रही थी when you give extra shorties to the investor और आप उनकी legitimate expectation बनाते हैं कि आप आ जाएं हम आपको सब कुछ करके देंगे. क्यों करते हैं? ताकि हमारे पास जॉब क्रिएशन हो, इन्वेस्टमेंट आए, क्योंकि हमारे इकोनॉमी जो है उसके हालात अच्छे नहीं है. That's the problem. Why हम क्यों GSP प्लस को तरह करते हैं? क्यों हम ट्रीटी साइन किए जाते हैं उनके साथ? उनकी ह्यूमन राइट्स से एक डिमांड चार्टर है, वो कहते हैं साइन करो फिर GSP प्लस मिलेगा. क्यों देते हैं हम GSP? क्योंकि हमारी इंडस्ट्री स्ट्रॉन्ग नहीं है, वो अपने ओन पे नहीं खड़ी हो सकती है, तो हमें उनसे कंसेशंस चाहिए. सो बट पीपल से ना कि ये किसी और का प्रॉब्लम है, किसी और का प्रॉब्लम नहीं है, ये आप सबका प्रॉब्लम है, ये मेरा प्रॉब्लम है. बिकॉज ऑल ऑफ अस आर नॉट डूइंग आवर ड्यूटीज, आवर इंडस्ट्रीज आर नॉट level, we need this concession. और उन concession के लिए हमें agreement करने पड़ते हैं. And obviously, the bureaucrats and lawyers should be more vigilant and understand this. But then, political will भी चाहिए to understand इसकी consequences क्या होंगे. आप photo op के दौरान deal करेंगे तो फिर results यही आएंगे. But this is not Pakistan problem. This is a whole world country problem. कि आप श्रीलंका क्यों उठा के देख? Actually, आप लेबनान श्रीलंका उठा के देख लें, ये स्टडीज के तौर पे. और BIT श्रीलंका का एक बहुत बड़ा प्रॉब्लम है. Poorly drafted BIT is a huge problem in Sri Lanka. And I can understand the economic crisis, the asymmetry of power, and then these poorly drafted BITs. ये एक पैटर्न है जो पूरे थर्ड वर्ल्ड कंट्रीज में है. And then Latin America में बहुत ज़्यादा था. Latin America में we'll talk about that also. But before that, but Latin America also faced a lot of consequences of उनका जब डेट क्राइसिस आया 1980s में, तो उन्होंने भी पहले 60s और 70s में बहुत पीरियड साइन की जब उनका फ्यूज हमारे साथ हमसे बात करते हैं. सो जब ये मुल्क जब इंडिपेंडेंस ले रहे थे तो फिर ये इंडियन नेहरू, प्राइम मिनिस्टर नेहरू एंड अदर पीपल, उन्होंने यूएन में एक शोर मचाया था कि हमारे रिसोर्सेज हैं, हम इन पे काम करेंगे, हमारी हमने आज़ादी ले ली है, हम ट्रू सेंस में अपने रिसोर्सेज के. तो यूएन रेजोल्यूशन जो ये आपको बताती थी कि अब जो है जो न्यूली इंडिपेंडेंट स्टेट्स हैं उनकी सोवरेनिटी है अपने रिसोर्सेज पे. लेकिन ये भी उन्होंने कहा कि अगर आपने किसी चीज़ को नेशनलाइज करना है, एक्सप्रोप्रिएट करना है, तो आप उसको कॉम्पनसेशन देंगे. लेकिन इसको एग्जाम्पल को सिर्फ सेट करने का यहाँ मतलब ये है कि यू अंडरस्टैंड दैट दिस कंट्रीज वर फाइटिंग अ बैटल इन द यूएन आल्सो टू फाइंड आउट कि कैसे आपके लिए इम्पोर्टेंट बात है कि आप जो है अपने रिसोर्सेज को जो है, हम एक भी लड़ाई करके आज़ादी ले चुके हैं, लेकिन हमारा हक है कि हम अपने रिसोर्सेज को आज़ाद हों, क्योंकि जब तक हमारे रिसोर्सेज हमारे पास नहीं, हम तरक्की कैसे करेंगे. एंड देन वी वांट टू यूज देम द वे वी वांट. और ऐसा नहीं कि आपकी कंपनीज जो है तो आप यहाँ से चले जाएं, लेकिन हम आपको कॉम्पनसेट कर देंगे जो आपकी फेयर वैल्यू है. तो ये बट 60s और 70s में ये वेब क्रिएट हो गया इन्वेस्टमेंट ट्रीटीज का, जो एसेंशियली हमने ये it's not like a true depiction of what happened, but this is known as a spaghetti noodles of BIT. आपने इतना ज़्यादा फैला दिया और आपने क्या कर लिया कि आपने अपने राइट्स फॉरगो कर दिए. डेवलपिंग कंट्रीज अपने राइट पहले 60s में लड़ाई की, 50s में लड़ाई की कि हमारे रिसोर्सेज हैं, हमें आज़ादी दी है, हमारे रिसोर्सेज हमारे हैं. फिर 60s और 70s में ये BIT साइन करके फॉरगो कर दिया. अच्छा ठीक है यार, हमारे पैसे लाते तो हमारे लोग गरीब हैं, हमारी डेवलपमेंट नहीं हो रही है, हमें और ट्रीटी साइन कर दी. ट्रीटी सिर्फ साइन की और स्ट्रिक्ट ट्रीटी साइन की जिसमें अपने राइट्स फॉलो करते कि यार आप हमारी कोर्स को नहीं मानते, ना मानो, हम आपको इंसिस्ट ही नहीं करते. बाय द वे, पहले जो पाकिस्तान जर्मनी BIT थी उसमें हमने इट डजंट हैव इन्वेस्टर स्टेट डिस्प्यूट सेटलमेंट क्लॉज. इट हैज अ स्टेट टू स्टेट डिस्प्यूट सेटलमेंट क्लॉज बट नॉट इन्वेस्टर स्टेट डिस्प्यूट क्लॉज. ठीक है, तो दैट वाज लेटर ऑन एडेड फॉर. तो आपने तो 1980s का 1970s में लैटिन अमेरिकन कंट्रीज के पास बहुत पैसा आ गया था बिकॉज ऑफ देयर ऑयल एंड सब कुछ, और वो उनसे ऑयल जाता था, फिर वो एक पूरा साइकिल बनता था, उनको इंडस्ट्रीज लगानी थी. कंट्रीज लाइक अमेरिका हैव अ लॉट ऑफ पेट्रोल मनी, फिर वो पेट्रोल डॉलर्स को वापस इन्वेस्ट कर देते थे, लोन दे देते थे, आपसे लेके जाते थे, वापस आपको लोन दे देते थे डेवलप करने के लिए. एंड 1980s में, अर्ली 1980s में अमेरिका को ये शौक चढ़ा कि गोल्ड स्टैंडर्ड डॉलर का खत्म करना है. हम गोल्ड के रेशियो गोल्ड फॉर सर्टेन अमाउंट ऑफ मनी, उन्होंने कहा ये नहीं होगा. तो उससे वो शॉक में चली गई इकॉनमीज. एंड सबसे ज़्यादा लैटिन अमेरिका जिन्होंने बहुत सारा डेट लिया हुआ था, और हाइक पे वो इंजॉय कर रहे थे कि हमेशा तेल इतना महंगा रहेगा और हम इंजॉय करेंगे सारा कुछ. वो जो अमेरिका ने पॉलिसी चेंज की, उधर से इन्फ्लेशन बढ़ना शुरू हुई, उधर से पेट्रोल की प्राइसेस कम हुई और पूरा एक क्राइसिस बना, परफेक्ट स्टॉर्म. और आप ये देखेंगे पैटर्न भी ना हर 10-15 साल तक आता है. हम उसमें जी रहे हैं अभी, जब जहाँ पे डेट आज सबसे बड़ी बात क्या है, अनसस्टेनेबल डेट, और उसमें कभी ये बात की, और इन्फ्लेशन और वो सारी चीज़ें जो थी ना वो आपके हो रही थी. एंड देन दिस कंट्रीज अपने डेट को ख़त्म करने के लिए उन्होंने BIT साइन करना शुरू किया ज़्यादा. और BIT साइन करके क्या कर रहे थे कि आप हमारे लोग इन्वेस्टमेंट लेके आए. अब इन्वेस्टमेंट का मतलब अपने आवाम को ठीक करना नहीं है, इन्वेस्टमेंट लेके आओ, हमारे पास पैसा है, उस पैसे से हम आपका डेट वापस करें. तो आज आप क्या करते हैं? आज आप ये नहीं कह रहे कि हमारे पैसे आ रहे हैं ना तो हम एजुकेशन ठीक कर रहे हैं. आप पैसे देते हैं, हमारा के ना $35 बिलियन का हम हर साल कर्जा लेना. आज आपका सबसे बड़ा इशू आपका डेट सर्विसिंग है. एजुकेशन, एवरीथिंग एल्स इज अ लो प्रायोरिटी नाउ, ठीक है, क्योंकि आपका डेट सर्विसिंग वापस करनी है. सो यू वांट इन्वेस्टमेंट सो दैट यू कैन रीपे दोज पीपल जो आपने उनसे डेट लिया. So this is a vicious cycle. And if not understand this, and again, not blaming them, but you have to understand कि आप ये चीजें कैसे काम कर रही हैं. People are so sleepy after food. I wish it was not last. I better say something more. So आपकी इस सारे जो मैं बोला कि सारे क्राइसिस से बचने के लिए they went on again to make sure that BIT साइन करें और सारा कुछ. क्वेश्चन इंपॉर्टेंट क्वेश्चन मेरा जिस पे सबसे बोल रहा है कि आप प्रूव करें FDI और BIT का लिंक. आप कहते हैं कि FDI हम इसलिए करते हैं क्योंकि सॉरी BIT हम इसलिए साइन करते हैं कि हमारे पास इन्वेस्टमेंट आएगी. प्रूव कर दे कि मुझे ये एक फैक्ट है. किस मुल्क में के जो BIT बढ़ गई है. तो मैंने एक साल पहले एक स्टडी की थी सरकार के लिए. सिर्फ स्टडी है, किसी को दिखा नहीं सकते हैं अदरवाइज. कंक्लूजन बताती हूँ आपको कि more than 10 studies by different scholars जिन्होंने प्रूव किया है कि कोई लिंक नहीं है FDI का और BIT का. नहीं आती है FDI. ठीक है. There are some studies जिन्होंने कहा कि marginal किस्म का इफेक्ट आता है. And then there was another important study which said कि FDI आती है लेकिन अगर आपने कोई केस ना करे तो, यानी आपको फायदा होता है लेकिन अगर आपको केस ना करे तो, यानी वो जो 1 अरब रुपये आपको दिए वापस 7 अरब वापस ना मांग ले तो तब आपका होता है. सो कंक्लूसिव एम्पेरिकल डाटा नहीं है. आप बात करेंगे लोग कहेंगे आप देखें आप जब BIT साइन करते हैं प्रोटेक्शन होती है, लोग आते हैं वो इन्वेस्टमेंट करते हैं. My experience, little experience is that sometimes big companies come into Pakistan, invest here, then they fear कि कुछ हो ना जाए. They pressurize their governments to sign a BIT with Pakistan. Often हमें पहले से पता होता है कि BIT हम साइन करते हुए किस कंपनी को प्रोटेक्ट कर रहे हैं. उस कंपनी की उस मिनिस्ट्री में जो जिस कंपनी की वो जिस लेट्स से बिग पेट्रोलियम कंपनी, तो उस नेगोशिएशन में पेट्रोलियम मिनिस्ट्री बैठी होती है. तो मुझे पता है कि इस मुल्क से हमारे पास क्या बड़ी कंपनी है जो यहाँ बैठी है. So it's other way around. It's not to bring investment. It's to protect the existing investments. तो ऐसे स्टडीज आपको जरूर मिल जाएंगी. If you Google, you find out that there is some studies which say कि आपका लिंक होता है. लेकिन लिंक उसके लेकिन इंडिपेंडेंट लिंक कभी भी नहीं होता. जैसे maybe I will answer your question for you even ask. So the point is कि कुछ स्टडीज ये कहती है कि अगर आप इंडिपेंडेंटली देखेंगे तो शायद इफेक्ट नहीं होता. लेकिन अगर आप कलेक्टिवली देखें, सो आपने BIT साइन कर ली, उसके बाद आपने अपने लीगल सिस्टम भी ठीक कर लिया, आपकी एडमिनिस्ट्रेशन भी ठीक हो गई, आपका टैक्स सिस्टम भी आपने नहीं बढ़ाया, आपके मैक्रो माइक्रो पॉलिसीज भी इकोनॉमिक पॉलिसीज भी ठीक रहती हैं. तो शायद कलेक्टिवली BIT इज ऑल्सो वन ड्रॉप इन द मशीन दैट हेल्प यू टू मूव द मशीन करेक्टली. बट इंडिपेंडेंटली यानी बाकी तमाम मुल्क में कोई लॉ ऑर्डर नहीं है, टेररिज्म फैली हुई है, ब्यूरोक्रेट्स अपने अयाशी में और मजे में लगे हुए हैं, वो कुछ नहीं पढ़ा to do anything. I'm scared of you because वो मुझे डर लगता है कि आप मुझे कहेंगे कि आपने जो ये बात की ना ये आपने बिल्कुल गलत की. So because I assume that you're totally verified to know.
ब्यूरोक्रेट को गालियां आपने बना दी क्या?
So again, I have to be clear on this that it's not the bureaucrats. But again, I can't emphasize more. Everybody is responsible. ठीक है? Everybody is responsible because अगर एक बंदा भी काम नहीं करे, एक बंदा भी काम ना करे, I give you one example. एक टीवी चैनल पे बैठ के बंदा जर्नलिस्ट शो कर दे रात को कि हमने अपना मुल्क बेच दिया इस ट्रीटी साइन करने से, दैट इज इक्वली रिस्पॉन्सिबल बिकॉज वो एक साइकिल शुरू करता है जिसमें पर्सनल डिफेंसिव होते हैं और एक्सप्लेन करते हैं कि नहीं हमने नहीं बेचा मुल्क और हमने ये गलत काम नहीं किया. ठीक है. सो आई थिंक इट्स एवरीबॉडीज रिस्पॉन्सिबिलिटी. लेकिन इफ यू थिंक कि आप BIT साइन कर लेंगे बाकी तमाम सिस्टम वैसा का वैसा रहेगा तो आपकी इन्वेस्टमेंट नहीं आएगी. सो मेरा सबसे ज्यादा एक्यूरेट हुई स्टडी की तरफ जो ये कहती है कि BITs और इंटरनेशनल इन्वेस्टमेंट एग्रीमेंट्स आपको फायदा दे सकते हैं if everything else is also improving and moving. And then it's one element that can help you. But independently, बाकी कुछ भी ठीक ना करो, this alone will not help you. Okay, that's the first thing. Second thing is that it is also the quality of the BIT. ठीक है. So I have never और ये मैं again the studies are not by scholars but also by institutions. And I want to add one more thing. पाकिस्तान ने खुद स्पॉन्सर किया था BOI ने एक स्टडी कोलंबिया यूनिवर्सिटी से. अगेन इट्स अ सीक्रेट डॉक्यूमेंट, नोबडी कैन सी इट.
सिर्फ कोलंबिया यूनिवर्सिटी वाले देख सकते
और हम देख सकते हैं जो सरकार में देख सकते हैं.
Please don't inform us if you cannot reveal it.
No, no.
And you just leave the mystery.
नहीं अभी बता रही है
Question is,
No, I'm explaining.
listen, here the ideals would be misguided. They will have misperception.
No,
You have to bring clarity.
I am
whatever you want.
I want to say the study is not available. Secret का मतलब है कि आपको अगर आप इसको Google करेंगे, you will not find it. That's my point. But secret in that sense, it's not secretly marked secret. अगर वो secretly marked secret होती तो मैं बताती ना. It's a study that we have, हमने खुद कंडक्ट की है और वो कहती है कि पाकिस्तान का BIT साइन करने के बाद कोई इन्वेस्टमेंट डायरेक्ट कॉन्ट्रैक्ट इन्वेस्टमेंट कोई प्रॉफिट पड़ा. मैंने खुद आई हैव स्टडीड द डेटा जो अवेलेबल था कि जिस मुल्क से हमने BIT साइन किया उसके बाद और उसके पहले उस मुल्क के साथ हमारा FDI क्या है वो नहीं है. On the contrary, there are studies which says कि उन मुल्कों में एक्चुअली इन्वेस्टमेंट बढ़ी है जिन्होंने अपनी BITs कैंसिल कर दी. लैटिन अमेरिका जो मुस्लिम आया और उन्होंने बहुत सारी अपनी एक्सेल को वो किया, अपनी BITs को किया, तो उन्होंने मार्जिनली अपना नॉट सेइंग कि बिल्कुल उनकी इन्वेस्टमेंट बढ़ गई, बट एक्चुअली उनके मुल्क में इन्वेस्टमेंट आई है. तो यू इफ यू ट्राई टू फाइंड आउट स्टडीज वो डिफरेंट है. आपका जो भी जनरल यू फाइंड अ स्टडी ऑन इट, बट पाकिस्तान की अपनी स्टडी भी ये कहती है कि FDI से कोई FDI से कोई फर्क नहीं पड़ता BITs का until unless you improve other things. For example, ease of doing business, and hence BOI has worked a lot to improve that, but obviously we're still far from developing.
एक सिंपल क्वेश्चन है,
जी जी.
जब फॉरेन डायरेक्ट इन्वेस्टमेंट आती है, कोई ना कोई एग्रीमेंट तो साइन होता होगा. अच्छा, व्हाट इज द डिफरेंस बिटवीन दैट एग्रीमेंट एंड BIT? मेरे जैसे आदमी के लिए जो नॉन लॉयर है,
बिल्कुल,
क्योंकि वो भी तो एक इन्वेस्टमेंट आपने साइन तो की है.
So that's an interesting part.
क्योंकि लेट्स से कोई एक्स कंपनी है,
बिल्कुल,
उन्हें यहाँ पे इन्वेस्ट कर लिया, चाइनीज कंपनीज आ रही हैं वो इन्वेस्ट कर रही हैं.
So Pakistan has a very interesting legal mechanism right now. A lot of time we have a trade agreement, FTAs, big investment chapter in it. Then we have with the same country, and then we have a BIT with the same country, and then we have every single company that comes have their own commercial contracts, जिसमें हम उसके अंदर भी investment dispute settlement डाल देते हैं. Even if there is no BIT, they will still sue us in international arbitration forums. I'm right, right?
BIT is BIT is country to country, state to state.
State to state. BIT is normal bilateral investment treaty, state to state. Then we have FTAs, which also state to state, and then the regional. For example, जो हमारे OIC countries, we have an OIC document. We have bilateral investment with them. Then we are having an FTA with GCC. Then we have FTA with individual countries, and our
GCC के साथ FTA
हुआ नहीं है. It's in process. It's in process. GCC के साथ. So you know, and BITs, FTA and OIC. FTA is subject to signing and ratification. So it doesn't make sense. कई दफा ये problem.
CPEC किस कैटेगरी में आएगा? CPEC.
I don't know. No, I don't know. Sorry. And then जो कंपनीज इंडिपेंडेंट आ रही होती हैं उसके साथ हम अलग से एग्रीमेंट करते हैं, which are normally commercial agreements, and that commercial agreement also have a dispute settlement mechanism which has, अगर वो BIT भी ना हो, वो FTA भी ना हो, वो regional और multilateral mechanism भी ना हो, वो फिर भी हमें हमारी कोर्स पर ट्रस्ट नहीं करती हैं. So small companies, they have now a provision कि लंदन में arbitration होगी, सिंगापुर में arbitration होगी, and in fact हमारी commercial agreements में भी हम उनको ऑप्शन देते हैं लॉन्ड्री लिस्ट की कि ये 6 ऑप्शन है जिस मर्जी में चले जाएं. My biggest problem with Pakistani BITs is not just that we have an investment state dispute settlement mechanism, ISD clauses, but मुझे प्रॉब्लम ये भी है कि आप बैठ के गेस करते रहे अब आपको कहाँ लेके जाएंगे. वो are they taking to Unistral, are they taking you to ICSID, वो लंदन लेके जाएंगे, वो सिंगापुर लेके जाएंगे, वो स्वीडन लेके जाएंगे, आपको नहीं पता. उसका एक और प्रॉब्लम भी है. our provinces जो क्या वो भी एग्रीमेंट्स करते हैं, जाहिर है जैसे कि आप अगर आपने सिंगापुर डाला है तो हमारे प्रोविंस के अंदर तो किसी के अंदर कैपेसिटी नहीं है टू अंडरस्टैंड कि सिंगापुर का लॉ क्या है या उसके आर्बिट्रेशन के रूल्स क्या है. ठीक है. एंड देन कम्स जो हम कहते हैं कि होल ऑफ द स्टेट की जो जरूरत है कि अगर फेडरल गवर्नमेंट के अंदर कैपेसिटी है, अगर वो निगोशिएट कर रही है, प्राइम नेगोशिएटर वो है, वो कह रही है कि सिंगापुर डालो, तो ये सोचना कि जो कंट्रीज हम स्पेसिफिकली कर रहे हैं, मार्क कर रहे हैं, वहाँ के आर्बिट्रेशन रूल्स जो हैं वो डिफरेंट हैं, कैसे हैं. सो ये भी एक इम्पोर्टेंट बात है. सो वन थिंग दैट वी हैव मल्टीपल सोर्सेज, इवन इफ देयर इज नो BIT, देयर इज स्टिल अ डोमेस्टिक सो नॉट डोमेस्टिक बट कमर्शियल एग्रीमेंट जिसके अंदर जो है आपकी डोमेस्टिक कोर्स की जुरिस्डिक्शन खत्म कर दी गई है. Interestingly, another part which is not part of my discussion, but उसको उसकी इम्प्लीमेंटेशन इज अनदर मैकेनिज्म, अनदर इशू कि आप सब कुछ करा लेते हैं दुनिया इन्वेस्टर्स 6-7 साल उसके यहाँ पे इन्वेस्टमेंट इम्प्लीमेंटेशन जो अवार्ड्स है उसकी भी कहानी है, और रिसेंट केस लॉ भी है. I think he's better person to talk about that, but that's a problem. So yeah, we have commercial agreements also जो कि अपनी जात में होते हैं. So there is no BIT, और ये मैं we have I have at NSD we have tried to now digitalize the agreements and BITs and commercial agreement also, कि एक जो पॉलिसी मेकर है चाहे वो मोफा में बैठा हुआ है कहीं बैठा, उसको पता तो चल जाए कि अगर हम इस मुल्क से डील कर रहे हैं तो एग्जैक्टली कौन कौन से एग्रीमेंट्स हमारे साथ हैं, अगर BITs हैं, और हमें कौन सी कहाँ पे गैप है जिसको हमें फिल करना है. एंड सबसे बड़ी बात कि इज देयर समथिंग different between BIT, we have a different obligation in BIT and FTA, for example. Again, we have FTAs and BITs which have different obligations with one particular country, at least that I know of. Which BIT says something else and I know FTA says something else. So अगर आप BIT को देखेंगे तो आप कहेंगे नहीं हमारा कोई मसला नहीं है, फिर जब आपको FTA देखते हैं तो आपको पता चलता है कि प्रॉब्लम देयर. सो ये आपके लिए एडिशनल प्रॉब्लम आती है कि आपको ट्रैक रखना पड़ता है हर कमर्शियल एग्रीमेंट का भी, और BITs का, और फिर आपके ट्रेड एग्रीमेंट्स का, एंड देन मल्टीलैटरल ट्रेड एग्रीमेंट्स का भी. सॉरी, आप कुछ पूछ रहे थे? जी.
जी मैम, I had a question कि so far we have been discussing कि BITs की वजह से FDIs नहीं आ रही, तो let me rephrase it, मतलब जो हमारी bilateral investment treaties है उनकी वजह से, मतलब the term says कि it's bilateral, लेकिन the big country is getting more of the benefit, और जैसा
okay, so BIT is bilateral.
मतलब इसमें ये हो सकता है कि जो टर्म्स हैं बायलेटरल इन्वेस्टमेंट ट्रीटी की, वो टर्म्स हम अच्छी तरह कंप्रीहेंड नहीं कर देते, हम अंडर प्रेशर आके डिप्लोमेसी की भी ऑब्वियसली वो आ जाता है, फैक्टर इन हो जाता है. तो हमारी अच्छी बार्गेनिंग पोजीशन नहीं है कि हम अपनी मर्जी के क्लॉजेस उसमें ऐड करवा लें जो इन स्पिरिट भी बायलेटरल हो, नॉट इन जस्ट वर्ड्स.
अब I understand your sentiment, but I want to explain this another way. Point ये है कि आप डॉक्टर के पास जाते हैं ना, और डॉक्टर आप भी शायद बहुत बड़े पढ़े लिखे इंसान हो, बट योर रिलेशनशिप कांट बी इक्वल, बिकॉज आप मदद लेने गए हैं और वो मदद दे रहा है. सो रिगार्डलेस ऑफ योर स्टेटस आपका एक डिफरेंस आ जाता है, ठीक है. तो इस तरह जब आप BIT साइन कर रहे हैं और जो डिफरेंस है वो ये है कि एक कैपिटल इंपोर्टिंग कंट्री और एक कैपिटल एक्सपोर्टिंग कंट्री है, तो इक्वालिटी हो नहीं सकती. हम जब आई थिंक समबडी हैज डिस्कस्ड दिस अर्लियर कि आपका जो हमारे जो इन्वेस्टर दूसरे मुल्क में बैठे होते हैं उनकी प्रोटेक्शन, हम जब BIT साइन कर रहे होते हैं तो वी आर ऑलवेज लुकिंग कि हमारे मुल्क के अंदर जो होगा वो क्या होगा. तो हमारा इन्वेस्टर दूसरे मुल्क में है, उसकी कंसेशन कम होती है, बिकॉज वो है नहीं ना, बहुत कम है. होते हैं हमारे मुल्क में इन्वेस्टर्स होते हैं दूसरे मुल्कों में, पर बहुत कम है. सो हमारा कंसिडरेशन ज़्यादा ये होता है कि जो हमारे मुल्क के अंदर आ रहा है, बिकॉज वी नॉर्मली इम्पोर्ट कैपिटल, हमारी ख्वाहिश है कि हमारे मुल्क में FDI. वी डोंट हैव दिस प्रॉब्लम कि हमारे लोग जा के दूसरे मुल्कों में जो है इन्वेस्टमेंट करते हैं, बट उसका रेशो वो नहीं है कि उसके लिए हम करें. तो हम BIT साइन करते हुए हमारा इट्स नॉट देयर प्रॉब्लम ओनली, इट्स ऑल्सो हाउ वी परसीव. आर परसेप्शन इज कि हमारी स्टेट को कम से कम नुकसान हो, ज़्यादा बेनिफिट लोगों को हो, हम लीगल केसेस में कम से कम जाएं, ठीक है. एंड again this realization of negotiating these treaties with more finance, more data, with more knowledge is not an old phenomenon in Pakistan. It's a recent phenomenon in Pakistan. I'm not saying the last 3, 5, 10 years. लेकिन after we start facing these investment disputes at international forum, then we start realizing कि हमें इसको थोड़ा सा carefully negotiate करना है, ठीक है. So वो जो अक्सर देखें हमारी treaties, जैसा हम आपको बात कर रहे हैं कि हमारी treaties पुरानी treaties है, first generation, second generation, third generation treaties. So now we are trying to have new generation of BITs where we are carefully negotiating. And again, ये बात भी clear. As much as I criticize our own system, I want to tell you that this was not the problem that we were facing. वो लैटिन अमेरिका ने फेस किया. Countries like India जिन्होंने एक साइन भी नहीं किया था, उन्होंने भी अपनी treaties सारी टर्मिनेट कर दी. उन्होंने अपने, and globally the trend is, I follow these news a lot. Globally the trend is to sign more FTAs, trade agreements. क्योंकि trade agreements में दोनों तरफ का आप बैरियर्स वगैरह, आपको जो एक्सपोर्ट करना है, आपने इम्पोर्ट करना है, उसके अकॉर्डिंगली आप बैरियर्स को फिक्स करते हैं. So globally there was a resentment against BIT. So it was not that we were like, हमने हमारी एडिशनल गलती जरूर थी, केयरलेसनेस जरूर थी, लेकिन इट वॉज नॉट दैट सिस्टम बड़ा अच्छा था और हमें सिर्फ जाहिर का समझ नहीं आए, क्योंकि ग्लोबली ही इवॉल्व किया है. So you know this Latin American countries be or India be or Indonesia be, so all of them have faced this problem. And I think woman asked this somebody, so she said about Argentina for example facing a lot of cases. And so ये लैटिन अमेरिका कंट्रीज के साथ हुआ और उन्होंने किया. इंडिया के साथ तो बहुत छोटा सा केस हुआ था और उन्होंने इसके बाद अपनी सारी ट्रीटीज थी वो रीनिगोशिएट करने के चले गए और अब वो उनके सक्सेसफुल नहीं हुई कि मॉडल BIT भी इतनी कोई अच्छी नहीं है. But the point is that it's not just our problem, it's everybody's problem, because the system was that way बनाया गया था, बन गया था, in fact evolve कर गया था, लेकिन because of the interest of the developed countries. And the second thing was that I think nobody expected कि हमें 7-7 बिलियन के जो हैं और 8 बिलियन के और 10 बिलियन के अवार्ड्स हमारे आ जाएंगे मुल्कों के खिलाफ. एंड आई थिंक वो रियलाइजेशन बहुत बाद में आई और उसके बाद चेंज हुआ. लेकिन अगेन रिमेंबर दैट यू नो एज लॉन्ग एज यू आर नॉट अ डेवलप्ड कंट्री, एज लॉन्ग एज यू आर जस्ट वेटिंग फॉर अदर कंट्रीज टू इन्वेस्ट इन योर कंट्री और इन्वेस्टर्स फ्रॉम अदर कंट्रीज टू इन्वेस्ट इन योर कंट्री, तो आपका बार्गेनिंग पोजीशन अच्छा नहीं हो सकता. तो आप दुनिया का बेस्ट लॉयर बिठा दें, बेस्ट बार्गेनिंग डिप्लोमेट बिठा दें, उसके बेस्ट डिप्लोमेटिक स्किल्स हो जाए, उसको ग्राउंड रियलिटीज पे करना है. आज मैं सुबह बैठ के सोच रही थी FTS के बारे में कि मैं बताऊंगी कि हम लोग FTS साइन करते हैं. तो मैं सिर्फ आपको बताना चाहती हूँ FTS साइन करेंगे और लेट्स से मैं आपकी नेगोशिएशन टीम में हूँ, तो मुझे बता दो दें आप लोगों ने क्या बेचना है, आपके पास क्या है इस क्वालिटी का और इस मकदार में जो आप बेचना चाहते हैं जिस पर हम टैरिफ कम कराएं. सो यू ऑल्सो हैव टू अंडरस्टैंड कि आपका लॉयर, आपका डिप्लोमैट विद ऑल इट्स डिफिशिएंसीज स्टिल हैज टू रिलाई ऑन द बिजनेस कम्युनिटी कि हम एक्चुअली क्या बेचना चाहते हैं, क्या सेल करना चाहते हैं. सो यू नो अगेन we have to evolve, understand that the problem is not one institution, one person, one BIT. It's the collective system which has to improve. Governance का system, negotiation का system, education system, and you know then we have. And तो आपको जो मर्जी treaty आप sign कर लें, जिस मर्जी बिठा लें. By the way, Maham is the best person to tell you this. With all our best, हमारे जितने भी cases हैं, we hire actually top-notch lawyers globally. हमारे दुनिया के हम आप कभी अगर वो निकाल के बैठ जाएं पाकिस्तान के जो केसेस हैं उनकी जो हमारी जो फॉरन हमारी टीम्स होती हैं, फॉरन लॉयर्स होते हैं ज़्यादातर, लेकिन जब आप उस टीम्स को पढ़ते हैं यू नो दैट वी हैव हायर्ड द बेस्ट ऑफ द लॉ फर्म, बेस्ट ऑफ द स्कॉलर्स. पाकिस्तान को बेस्ट ऑफ द स्कॉलर्स को करते हैं. अनफॉर्चुनेटली योर मेमोरी इज ऑफ मोर ऑफ अ कुलभूषण के केस जो लाइव टीवी पे चला और आपने वो देखा. अगेन हाउ कैशियस नो वाज नॉट जस्ट आवर लॉयर, वो भी दुनिया के एक फेमस लॉयर है, लेकिन आपका लॉयर दुनिया का बेस्ट लॉयर होता है. सो यू नो आप किसी भी केस पे निकाल के देख लें, आप ये इंडियन वॉर ट्रीटी को निकाल के देख लें, आप यू विल फाइंड आउट दैट यू विल हायर बेस्ट ऑफ द पीपल, बेस्ट ऑफ द ग्लोबल जो आपके एलीट लॉयर्स हैं वो हायर करते हैं. तो इसलिए मतलब ये कि चलो पाकिस्तानी लॉयर्स तो चलो हुए, पर प्रॉब्ली देयर आर सम प्रॉब्लम कहीं और भी वेयर यू हैव टू फिगर आउट की चीज़ें कैसे होनी चाहिए. So, which is what you want to sell also. आपके मुल्क का अंदर मैकेनिज्म क्या है, बिजनेस का एनवायरनमेंट क्या है, लॉ एंड ऑर्डर एनवायरनमेंट क्या है, तो वो सारी चीज़ें जो हैं वो इम्पोर्टेंट बात है. सॉरी आई डोंट ओके. Is there a link between FDIs and IMF? I don't know आप किस चीज़ की पिक्चर ले रहे हैं, रैमलिंग है सब वहाँ पे. No need to take pictures. But मुझे बताएं आपके ख्याल में इस तरह लिंक between IMF and DIPs and World Bank and DIPs? तो IMF को क्या पता है?
But again, you actually say again to at least take that.
किसी और कुछ है? आपको ख्याल है कि लिंक है IMF का वर्ल्ड बैंक और DIPs का?
If, for example, BIT, I don't know the working of the सारी जो मेरी वो था कि if a BIT is signed under the supervision of IMF or World Bank, then they will have a role in conducting it.
Again, I understand आपकी reasons क्या है उसको बाद में. So बेशक एक्सेप्ट वर्ल्ड बैंक का वो है.
एक सिमिलरिटी नजर आती है जो 59 में वर्ल्ड बैंक ने किया था, ये मैं सभी वही कर रहा हूं हमारे साथ.
So yeah, वो आप सॉवरेन कंट्री आप जैसे बड़ी BIT साइन करें, लेकिन कुछ चीजें हैं जो BIT में लिखी होती है ना वो सिमिलर है जो वर्ल्ड बैंक और IMF को है. so again, who is the World Bank and IMF? Who has more shares into it? Countries like US and these countries have the more voting power. और वही फिर आपका वहाँ से क्या IMF कहता है आप ये करें, आप इसमें से पैसे ना इन्वेस्ट करें. फॉर एग्जाम्पल आटा स्कीम में पैसे इन्वेस्ट ना करें, आप इस वक्त ये इन्वेस्ट करें, अपना डॉलर को खुला छोड़ दें, वर्ल्ड स्टेट बैंक को खुला छोड़ दें. तो अपनी पॉलिसी स्पेस को कर्टेल करें. दिस इज व्हाट IMF says to you and this is what BIT says to you कि देखिए हम आपके मुल्क में इन्वेस्टमेंट तो करेंगे, आपसे ट्रीटी साइन करेंगे, लेकिन आप फिर फ्लो ऑफ कैपिटल पे पाबंदी नहीं लगाएंगे. फिर अगर बंदा पूरा प्रॉफिट लेके जाना चाहता है तो रोकेंगे नहीं उसको. तो दिस आर द थिंग्स, तो जो डिमांड्स हैं या जो प्रोविजंस हैं जो कि BITs में लोग हमसे एक्सपेक्ट करते हैं, नॉट ऑफ पाकिस्तान. अगेन दिस इज ऑल थर्ड वर्ल्ड कंट्रीज. श्रीलंका के एग्जांपल आपके सामने है, लेबनान है. तो उनके साथ जो डिमांड्स आती हैं वो डिमांड्स आती हैं विद BITs कि आपने अपना फ्लो कैपिटल करना है, आपने टैक्स रेजीम को कंट्रोल रखना है, आपने नेशनलाइजेशन नहीं करनी है, आपको so maybe there is not a direct link, but if you think that the system, international economic system, वो सारा लिंक अप होता है और डिमांड्स आर सिमिलर, then you understand कि how these things are, you can't operate in void में नहीं कर सकते. When you are facing those problems, जब आपके मुल्क के अंदर, तो देखिए BITs मेरा एक हमेशा as a student भी मैं सोचती थी और आज भी मैं इस बात पे कन्विंस हूँ. BITs in a way is also a charge sheet against your legal system. It is a charge sheet against the legal system कि यार इस मुल्क में अगर मेरा प्रॉपर्टी किसी ने कब्जा कर लिया तो इस मुल्क की कोर्ट तो मेरा कब्जा नहीं छा सकती, या इस मुल्क की कोर्ट तो मुझे इंसाफ नहीं दे सकती, टाइमली इंसाफ भी नहीं दे सकती, और अगर बहुत लंबा प्रोसेस है तब भी नहीं दे सकती. So it is in a way charge sheet against your legal system. Not just on court but बाकी सब तरह के legal lawyers ये करेंगे. So एक सिस्टम, एक मैकेनिज्म है जो आपको समझना चाहिए. Again, so I'm not saying that it's not, but if the dollarization, the economy, the World Bank, IMF, and this international economic regimes, they are connected in a more subtle way, in a more maybe not on the face way, but it is you can find the similarities there, and the demands are similar. एक प्रॉब्लम जो और थर्ड वर्ल्ड कंट्रीज को फेस करना पड़ा है पाकिस्तान जैसे मुल्कों को भी, मैं इससे ज़्यादा बात नहीं करी, आई थिंक यू अपने पिछले लेक्चर्स में आपको बहुत एक्सप्लेन किया इसको, व्हिच वाज दैट यू हैव साइंड अ ट्रीटी एंड आपने क्लॉज डाली है, बट अब दो केसेस चल रहे हैं दो डिफरेंट ट्राइब्यूनल के सामने, एंड यू डोंट नो कि वो इंटरप्रिटेशन क्या करेंगे. तो प्रेडिक्टेबिलिटी जो सिस्टम की होती है, इंटरप्रिटेशन की होती है, अगेन रिमेंबर दिस सिस्टम इज आल्सो इवॉल्विंग ग्लोबली. कि BITs की इंटरप्रिटेशन है, एक ट्राइब्यूनल के पास बैठा हुआ कुछ और कह रहा है, वो कुछ और किस्म की एग्जाम दे रहा है. फॉर एग्जांपल फेयर एंड इक्विटेबल ट्रीटमेंट की एक क्लॉज होती है, और ज़्यादातर केसेस इसी चीज़ के बारे में होते हैं कि आपने हमें फेयर और इक्वल ट्रीट नहीं किया, आपने हमारे साथ ये किया, दूसरे मुल्क दूसरे साथ ये कर लिया. इसकी इंटरप्रिटेशन वाज लाइक इट वाज सो वेग, फॉर सम ट्राइब्यूनल्स इतनी डिवाइड कर दी कि हमें मालूम नहीं होता था कि क्या. अभी इसलिए जब हम नई BIT साइन कर रहे हैं तो हम इसके अंदर या हम और ग्रुप साइन कर रहे हैं वो इस क्लॉज को खास तौर पे वो कर रहे हैं. सो अनदर प्रॉब्लम दैट वाज क्रिएटेड बाय दीज ट्राइब्यूनल वाज जिसकी वजह से थर्ड वर्ल्ड कंट्रीज को प्रॉब्लम हुई कि उन्होंने ट्रीटी साइन की कंसिडरिंग हम फेयर एंड इक्वल ट्रीटमेंट करेंगे. लिटरल सेंस में उन्होंने इसका अपना नॉमिनल मीनिंग होता है उसका सेंस में लिया उसको, बट कोर्ट्स हैव ट्राइब्यूनल्स हैव interpreted in a different way, in such a wide way, and different. इसलिए कई लोग दो ट्राइब्यूनल्स डिसीजन नहीं होते हैं. You are always confused about this, and I can show you that even today, if you are signing a treaty, you have to be careful. उस ट्राइब्यूनल ने फैसला दिया था, but you never know कि कल और ट्राइब्यूनल क्या फैसला देंगे. तो अभी आप क्लॉजेस को बहुत डिफाइन कर सकते हैं. So you can see this कि आपका फेयर इक्वल ट्रीटमेंट का क्या मतलब है, कि आप जस्ट होंगे, अनबाइस्ड होंगे, या आपने कुछ ऐसा कर दिया जो आपको एक ऐसे कहे कि दूसरे बंदे जो इन्वेस्टर है उसको भी फील ना हो कि उसके साथ कोई ज्यादती हुई है. देन दैट बिकम्स वेरी सब्जेक्टिव थिंग, वेरी वाइड कि उसको क्या लगा था, हमें क्या एक्सपेक्टेशन उसने लेके आया था. एंड आई जस्ट फॉर एग्जांपल आई जस्ट गिव यू एग्जांपल द न्यू BITs जो है केसेस फेयर इक्वल ट्रीटमेंट पे, बट नाउ द न्यू BITs जो है वो ये बात करें पाकिस्तान की BIT से एक लाइन मैंने आपके लिए किया है. तो आइडिया था एक्सप्लेन करने कि आप इसको नहीं कहेंगे, इसको आप फेयर इक्वल ट्रीटमेंट नहीं कहेंगे, या ये इक्वल ट्रीटमेंट नहीं होगा. सो नाउ आप जो हम सबक सीख रहे हैं उसको दुनिया फॉर एग्जांपल पाकिस्तान के लिए बाकी मुल्कों के लिए नाउ व्हेन यू आर तो वो कोशिश कर रहे हैं लैंग्वेज ऐसी रखी कि ज़्यादा वाइड इंटरप्रिटेशन ना हो सके और आपकी डिफिकल्टी का सिस्टम है कि यार अगर ये किसी ने मुझे पूछ लिया तो मुझे पता हो कि फेयर इंटरप्रिटेशन का क्या मतलब है. So you know all these clauses in the case of देखेंगे तो आप wider courses या university पढ़ेंगे या पढ़ेंगे तो find out कि कैसे लेकिन you will find the newer trends जहाँ पे जो drafting is more controlled drafting, more careful drafting. And Pakistan, when example से जैसे you understand कि it's not a Pakistan is also evolving. Pakistan is also careful कि आपको ऐसी चीज़ें डाले. जब वाइड इंटरप्रिटेशन की बात आती है, श्रीलंका के साथ एक केस हुआ और इंटरेस्टिंग केस ये था. इसलिए इसको एक श्रिम्प फार्म था और आपको पता है श्रीलंका में इंसर्जेंसी थी, जंग का आलम था और उधर अटैक हुआ और एक केस ये था कि श्रीलंकन गवर्नमेंट ने उनको प्रोटेक्शन प्रोवाइड नहीं की, जो कि इसमें लिखा हुआ है आप पूरी कोशिश करेंगे टू मेक श्योर दैट दे आर प्रोटेक्टेड. केस पार्शियली श्रीलंका के फेवर में था, लेकिन द क्वेश्चन दैट इज दैट आर्बिट्रेशन ट्राइब्यूनल्स जो हैं अब प्योर पब्लिक इंटरनेशनल लॉ के इश्यूज जो हैं कि जंग थी, प्रोटेक्शन का लेवल क्या था, जंग में क्या प्रोटेक्शन दी जा सकती थी, दिस इज नॉट देयर जॉब. जब हमने BIT साइन किया तो हम अपने दिमाग में ट्रेड रख के कर रहे हैं. व्हेन दे आर गोइंग टू निटी-ग्रिटीज कि हमारा मिलिट्री ऑपरेशन कैसा श्रीलंका के केस में कि ऑपरेशन कैसे डिवाइस हुआ था, दिस वाज नॉट एक्सपेक्टेशन दैट थर्ड वर्ल्ड कंट्रीज और द कैपिटल इंपोर्टिंग कंट्रीज के दिमाग में था कि यार हमारे मिलिट्री ऑपरेशंस पे भी जो गुफ्तगू होगी वो ट्राइब्यूनल्स पे होगी. सो इन सर्टेन केसेस कंट्रीज हैव फelt that it's just not an interpretation which was wide and unpredictable, but also the problem was that they are going into the areas which was not meant for them. So this is one example.
But wouldn't it be classified as an attempt to defend itself by saying that it was force majeure and it was war, people were reasons about it?
Force majeure war बिल्कुल उन्होंने कहा था, मैं उनका क्लेम नहीं था, हमने पूरी कोशिश की कि हमें करें, इट वाज नॉट इंटेंडेड नहीं था, बट दे एवरीथिंग इन द पावर टू सेव देम और उस तरह की चीज़ों के बारे में. उसमें प्रॉब्लम है, इट्स मोर ऑफ अ डिस्कशन, लेकिन सब कंट्रीज का लेवल ऑफ पावर डिफरेंट है ना. तो पाकिस्तान का पुलिस एंड आर्मी का स्टैंडर्ड बिल्कुल डिफरेंट है फ्रॉम लेट्स से other countries, and there are countries which are more powerful than us and more police and more intelligence and more army operations exercise कर सकते हैं, जो हमसे बहुत बेहतर काम कर सकते हैं. So it's not equal पे नहीं है, it's not भी, and जंग होती है, सब कुछ होता है, आपको मालूम है, किसी हम कोशिश करते हैं कि फॉरेनर्स को और फॉरेन प्रॉपर्टीज को इवैक्यूएट करें सबसे पहले ताकि इस तरह की कोई चीज़ ना आए. तो वो बिल्कुल उन्होंने क्लेम किया कि वी हैव डन आवर बेस्ट जो हम कर सकते थे और ऑपरेशन जरूरी था और हमने नुकसान पहुँचाया, बट देयर स्टिल वाज वेदर वी हैव डन इनफ. So that's the idea, na, कि what is the best, what is your best and my best and your best will be different, and that's why a lot of countries now when they put the protection clause into it, they say according to the capacity of that country, police force की और military की capacity उसके accordingly levels different, so we can't have a one standard for everybody. So again जो मैं इसके बारे में बात कर चुकी हूँ, जो आपकी तरह की इशू है और श्रीलंका के इशू है, पाकिस्तान के इशू है, या इस वक्त डेट का इशू है, जो BIT साइन की है और IMF के प्रोग्राम में भी है, वो दोनों से क्या बात करते हैं. ये एक रैंडम नॉर्मली क्लॉज इस तरह होती है, ऊपर भी है नीचे भी है, जो कह रहा है एक्सपेंसिव है नीचे वाली थोड़ी. आप क्या कहते हैं, अगर आपके रुपये में इन्वेस्टर आया है और उसने कोई प्रॉफिट कमाया है, उसकी प्रिंसिपल अमाउंट है, तो जिस वक्त चाहे वापस लेके ला सकता है इन फ्रीली कन्वर्टेबल करेंसी. अगर कोई क्लेम जीता है, उसमें कोई प्रॉफिट्स हैं, तो IPOs है, कुछ भी तो पैसे लेके आके मजदूर से जा सकता है. ये आपने BIT में उसको लिख के दे दिया नॉर्मली प्रोसेस एंड छोटी होता क्या है. एंड तो IMF जैसे डॉलर में मत कंट्रोल करो, रेट मत कंट्रोल करो, और IT बिजनेस के बारे में आपको बात की है, एंड ये मत करो, बात करो I think you did also that you probably face a lot arbitration claims also, कि आप लोग फंड नहीं जाने दे रहे बाहर फ्रीली, तो उसका प्रॉब्लम तो these are the issues that you have, but आपने BIT लिख के दिया है कि आप फ्रीली जिस वक्त चाहेंगे आप वो करेंगे, आप लेके ला सकते हैं, पूरा लेके जाना चाहते हैं लेके ला सकते हैं. इनफैक्ट हमारी जो इन्वेस्टमेंट पॉलिसी है उसमें हमने बहुत लिबरलाइज की 90s में, और फर्स्ट इन द रीजन जिसने बहुत लिबरलाइज फॉरेन इन्वेस्टमेंट FBI पॉलिसी बनाई थी, और हमने कहा था कि अगर हमारे मुल्क के अंदर से 100% भी कोई प्रॉफिट जो है वो रिपेट्रिएट करना चाहता है तो इशू नहीं होता. But that's the problem when you have a lot of money and आपके फॉरेन रिजर्व अच्छे हैं. लेकिन आज के ज़माने में जहाँ पे आपको एक रुपया की मुश्किल है, every dollar is important for us. You cannot allow countries or the investor to take 7 billion or 8 billion और निकाल के लेके जैसे 5 billion or that matter 1 billion भी लेके जाए हमारे प्रॉब्लम है. And Pakistan, because Pakistan investment policy ऐसी थी with BIT, and again the BIT is not for us. And then because there was a trend कि आप liberalize करें 90s में, इंडिया ने किया, हमने किया, that became problem. लेकिन जब ये crisis बढ़ना शुरू हुआ तो lot of countries felt कि ये नहीं हो सकता. ये अगर आपने free flow कर दिया, आपने इसमें करके तुम्हारा balance of payment का issue होता है. खास तौर पे जब आपके मैक्रोइकोनॉमिक इंडिकेटर्स अच्छे नहीं होते, जब आपको इन्फ्लेशन होती है, अनएम्प्लॉयमेंट होती है, आपकी प्रॉब्लम है, आपके फॉरेन एक्सचेंज रिजर्व अच्छे नहीं है, तो आप अलाउ नहीं कर सकते किसी मुल्क को, किसी भी इन्वेस्टर को इतने सारे पैसे को कर सके. So you have to have certain controls, and that's why the newer BITs and this was third world country balance of payment का बहुत बड़ा इशू कि आप ये नहीं अलाउ कर सकते और फिर आपको IMF को फंड लेना पड़ता है to allow कि वो सारे स्मूथ ट्रांजैक्शन हो. फिर IMF कहता है जब खुला छोड़ दें सारे के पैसे खत्म हो जाते हैं. So again, vicious cycle. But this is one of the important things. I'm running out of time, but so the core debate always is to balance the आपकी interest है. तो interest क्या है? एक तरफ आपका global economy है, international system है कि आप free करेंगे capital का flow. दुनिया में से जहाँ पे भी जो इन्वेस्टमेंट जहाँ किए है उसका प्रॉफिट है, उसकी अमाउंट है वो लेके जा सकते हैं. The currency that they think is free convertible. आपको again डॉलर आके भी ऐड करेगा, उसको कंट्रोल करना चाहेंगे भी रेट को, तो उसका अलग प्रॉब्लम है. But the point is that these things are problematic and all countries, including Pakistan, have to struggle to make sure that investment भी आए, investment कुछ भी रहे, and ऐसा भी ना हो कि balance of payment issue में चले जाएं. पाकिस्तान अलाउ करता है कि कोई बंदा उसमें आके 100% इन्वेस्टमेंट कर सकता है, कोई लोकल पार्टनर की जरूरत नहीं है और वो 100% प्रॉफिट लेके जा सकता है. तो हमारे मुल्क में फॉरेन डायरेक्ट इन्वेस्टमेंट से एक्चुअली कभी लॉ क्रिएशन तो होती है, लेकिन हमारे फॉरेन के रिजर्व या हमारी एक्सपोर्ट की बढ़ती है. इसलिए आप देखें whether it was national security policy or whether it's your new investment policy, they kept on saying that investment लाई जाए, but in sectors which are export sectors. हमारे मुल्क इंडस्ट्री लगे कि वो एक्सपोर्ट की जाए और उससे हमारा रेवेन्यू बढ़े. So there is things, and again अगर FDI में लोकल से इंफ्रास्ट्रक्चर अगर इन्वेस्टमेंट नहीं होगी, अगर हमारे वेंचर कैपिटल प्रोजेक्ट्स, तो फिर प्रॉब्लम ये होती है कि सारा का सारा प्रॉफिट जो है बाहर चला जाता है. So for example, let's take a great example, पाकिस्तान लोग इस्तेमाल करते हैं, we won't charge them for water, वो आपको पानी बेचते हैं, आपको देने में खर्च करते हैं, प्रॉफिट कमाते हैं, पैसों में कमाते हैं, जाते हैं डॉलर में जाते हैं, and that's your problem. So आपको PPI साइन करते हुए, and again the more I can't emphasize enough that it's not that you can सारे जनरेट कर दें, हमें कोई एग्रीमेंट नहीं चाहिए, हमें कोई ट्रीटी नहीं चाहिए, हम नहीं मानते किसी को, ऐसा नहीं हो सकता because you have to live in a system. तो आपको ऐसा सिस्टम में काम करना है कि मेक श्योर दैट आपकी you have BITs, you have agreements, international agreements, bilateral, multilateral trade, investment, हर तरह के agreements होंगे. तो आइसोलेशन नहीं कह सकते, आपको केसेस भी फेस करने पड़ेंगे. अगेन आप अगर पाकिस्तान की विक्ट्रीज देखें और पाकिस्तान से देखें तो हमारा ट्रैक रिकॉर्ड बहुत बुरा नहीं है. मैं although I feel like the moment there is a case that filed against Pakistan has to spend millions because हम hire करते हैं और उसके सारा कुछ. But again, just because कि आप अगर बिजनेस करते हैं तो आप अगेंस्ट कोई ना कोई क्लेम आता है, तो क्लेम आ जाना कोई बड़ी बात नहीं होती है, और केस हारना भी बुरी बात नहीं. पॉसिबल नहीं है कि हम हर केस जीतेंगे, ऐसा होता नहीं है ना, कोई लॉयर भी कोई कुछ भी नहीं हर केस जीतता है. The idea that don't be scared of treaties or don't be scared of arbitration claims or even losing, because that's a part of the system. There's no country which has won all the cases या उनके साथ कभी कोई केस फाइल नहीं हुआ. वो बेस्ट ऑफ द कंट्रीज भी होती हैं, उसमें भी होता है, उनका सिस्टम भी होता है. So the idea is to be vigilant, to understand कि legal system कैसे कर रहा है, और capacity. I know कि रिक्रूटमेंट में I think has talked about this कि पाकिस्तान के एक्चुअली केस स्ट्रैटेजिस्ट को जो है एक मुद्रत का खुद का केस जो इम्पोर्टेंट था. पाकिस्तान में एक्चुअली पाकिस्तान को 2 साल लगे बताते थे कि आपकी जुरिस्डिक्शन ही नहीं है एंड यू डोंट हैव अ जुरिस्डिक्शन. पाकिस्तान को जो पाकिस्तान को तो BIT was not ratified by Pakistan, किया नहीं था, तो applicable ही नहीं थी और उसके arbitration panel के पास jurisdiction ही नहीं थी, लेकिन 2 साल हमारा वकील जाके चीजें करता रहा और फिर Gujarat was hired as a lawyer and obviously was simple jurisdiction पे case dismiss हो गया. So capacity issues हैं and on different levels हैं और आपको करनी है, but when I say that capacity issues doesn't mean that Pakistan doesn't have lawyers. And younger people आपके बात में बीच में बहुत अच्छे लोग आ रहे हैं, बट एक बात और है, एक चीज़ आप किताब में पढ़ते हैं, स्कूल में पढ़ते हैं, फिर आपको लोगों को एक्सपीरियंस देना है, लोगों को एक्सपोजर देना है, तो अंडरस्टैंड एक्चुअली स्टेट कैसे काम करती है. एक कमर्शियल आर्बिट्रेशन और एक स्टेट लेवल आर्बिट्रेशन आर नॉट सिमिलर or not same, similar maybe but not same. So you have to make sure that you train your people. अब स्कूल में किताब पढ़ना बिल्कुल एक अलग बात है. I was a teacher myself and I thought that I was obsessed with international law. And there's one student of mine who refused to acknowledge me being my student. But in nowadays, but I thought that I was an amazing teacher, but obviously I was not. But he made me realize it's नहीं करेंगे मुझे किसी ने फॉर्म का एक बार आपको तो दूसरी वो तो शायद टाइम होता. But the idea that I understood that what we are teaching in the classroom, I was taught, but I taught other people. कुछ भी नहीं था, but just like love, कुछ भी किताबी बातें, international law, दो states के बीच में सब कुछ, you give exposure to people to understand the system. Unfortunately, we don't have that many law firms. We don't entertain a lot of younger students to give exposure. International law firms पाकिस्तान में नहीं है, उनके offices भी कम हैं. People are trying to work with international ताकि बच्चों को exposure हो. These things are exposure. You get to know a lot of stuff that people have done over the years. So capacity issues ने contribute किया है. मैं पाकिस्तान की example दे रही हूँ. Other countries have faced similar issues for our countries में. तो एक system को बनाया, फिर उसके अंदर क्योंकि they have the advantage of understanding that system, वो amendments करते हैं. Amendments में हमारे working group में हमारे private entities जाती हैं, contribute करती हैं, ताकि amendments के process हो रहे हैं, एक्सेप्ट की हो, इंस्टॉल की हो. State level contributions are not very effective. जाते हैं उधर वो भी हैं, लेकिन the state level of contribution आप contribute करेंगे, you understand the system, you participate in the system, and I want to tell you, which I said the last time also when I was here, Pakistan in initial years was very active in the development of international law at the global level because of our foreign minister at that time, and then later on our foreign ministry, and we had people जो कि contribute करते थे, draft बनाते थे, क्या करते थे. Recent times में I think also bogged down by the terrorism thing and Afghanistan, that I think that हमारा attention towards other thing has been less, लेकिन हमारी हमेशा within the system के लिए contribute करना चाहिए. This is small. I want to talk about. I know the running out of time. I think you have a question also. Loans. BIT और loans. BIT इसको abuse किया जा रहा है to bring claims against states for their loan defaults. इसका example ग्रीक और अर्जेंटीना में हुआ था. दोनों ग्रीस और अर्जेंटीना के खिलाफ केसेस आए थे. उनकी बॉन्ड की जो रीपेमेंट्स होती हैं, but because आपके पास डेट आपका सस्टेनेबल नहीं रहता तो आपको रीस्ट्रक्चर करना पड़ता है. So some of the bonds जो आप इशू करते हैं तो वो उसको इन्वेस्टमेंट के अंदर ला के आपको क्लेम कर सकते हैं. एंड ग्रीस और अर्जेंटीना के खिलाफ केसेस सक्सेसफुल नहीं हुए थे, बट जुरिस्डिक्शन एक्सेप्ट कर ली गई थी. वो फिर खुद ड्रॉ कर लिए गए एंड सारा कुछ. सो इमेजिन इफ दे वर अगर वो परस्यू किए जाएं. तो फॉर एग्जांपल श्रीलंका हैज डिफॉल्टेड. We are living in a fear of default for a year now. So every time I read this, and I fear कि अगर BITs को इस्तेमाल करना शुरू कर दिया to file claims against bonds. Jurisdiction, jurisprudence is not developed, but I'm saying that there is an example where tribunal has accepted the case at least for jurisdiction के लिए, तो इसका मतलब अब आगे भी जा सकते हैं. So I'm worried about this is the misuse. This is the third world countries haven't signed for this कि यार हमारे जो loans हैं उनके लिए भी BITs में आप restructure नहीं कर सकते. Because I hope that you understand. I'm so quickly saying this. It's just some Paris Club loans and China loan and but there are investment जो आपके bonds वगैरह करते हैं, issue करते हैं, private entities से लेते हैं. So that could be an issue for countries like Sri Lanka who has already defaulted, but for Pakistan also. And ये है. This is so. A lot of countries have terminated their treaties. Pakistan haven't terminated its treaties, but Pakistan की भी एक 2 साल पहले policy आई थी, and this cabinet has also approved that.
पॉलिसी में हमने टर्मिनेट करने के ट्रीटीज नहीं कर जा रहे, बट व्हाट वी आर डूइंग इज वी आर ट्राइंग टू रीनेगोशिएट ट्रीटीज विद अदर कंट्रीज. हम उनको अपना मॉडल ड्राफ्ट दे रहे हैं एंड वी आर डूइंग रीनेगोशिएटिंग ट्रीटीज. क्योंकि देखिए एक ट्रीटीज का एक और प्रॉब्लम भी है, ऐसा ट्रीटी बट अगर हमने उसके अंदर सर्वाइवल क्लॉजेज होती हैं. सर्वाइवल क्लॉजेज का मतलब है कि ट्रीटी आप टर्मिनेट कर भी दें. सो इन सम केसेस, इन पाकिस्तान के केस में सर्वाइवल क्लॉजेज लिव अप टू 30 years. From 3 years to 30 years आप ट्रीटी टर्मिनेट कर दें. आपके हम सॉवरेन कंट्री हैं, सारी ट्रीटी टर्मिनेट है, तो उसके बावजूद ट्रीटी फॉर द एग्जिस्टिंग इन्वेस्टर विल रिमेन फॉर द नेक्स्ट 30 years. तो वो हम अफोर्ड नहीं कर सकते. तो द बेस्ट थिंग इज टू रीनेगोशिएट and negotiate with the best of knowledge and intentions, and I hope Pakistan will be successful, because it's just not our problem, other countries are facing problems also. So I hope that Pakistan will have this, but it's just not Pakistan. India is doing the same, Australia has made a policy, Indonesia, but other countries are exceedingly, especially India is focusing on FTAs, UK is focusing on FTAs which are free trade agreements, which is more जो कि एक्चुअली रिसर्च ने साबित किया है कि FTAs आपके मुल्क में ज़्यादा फॉरेन डायरेक्ट इन्वेस्टमेंट लाते हैं. सो ट्रीटी टर्मिनेशन प्रोसेस दुनिया में जारी है, रीनेगोशिएशन जारी है. मॉडल BIT कंट्रीज लाइक पाकिस्तान एंड इंडिया मॉडल BIT. ऑस्ट्रेलिया हैज़ वन, आई डोंट चेक पब्लिक की है या नहीं की है. रिफॉर्म्स ट्राइब्यूनल लेवल पे, यूनिस्टार पे, एक्सिड में रिफॉर्म्स आ रही हैं, which ask for more transparency, more better systems, timelines, so that and cost may be. And there was always an objection with कि same lawyers जो होते हैं, एक केस में lawyer होते हैं, दूसरे केस में double hacking करते हैं और दूसरे केस में वो arbitrator बन जाते हैं. So there's a problem. These things have been discussed, which was our problem. We raised them. I just hope Pakistan and other third world countries contribute more and actively participate in this reform process. Thank you so much for listening to me, and you have to learn to make sure that Pakistan has a better options in future. Thank you. Sorry, any questions?
Who is pushing us to sign BIT? If we are not supporting anything towards any European, why we can't sign a bilateral treaty with Iran? So, what's the problem in that?
We have bilateral agreement.
We don't.
Okay, so एक बात again, the bilateral system. Not only just we have treaties, but also we have a bilateral project here, because we live in a global system. Yes, or we live in a more sanctions region. It's not just Iran. China is having a lot of sanctions. Afghanistan is sanctioned. तो हम और region में रहते हैं, बहुत sanctioned region है. तो देखो BIT अगर हो भी जाए, किसी मुल्क के साथ ईरान का बहुत अच्छी BIT साइन कर रहे हैं, अगर global financial system से वो cut out है, तो हम क्या कर सकते हैं? And it's just not us, it's everybody else also. So and जो चीजें उनके सेंक्शन में नहीं है, वो हमारे क्रिएट करते हैं, हम सब क्रिएट करते हैं. जो चीजें सेंक्शन, because the fuel and the energy sector is under sanction, and the mineral sector sanction of it, जो इससे आधार है, वो उससे हम ट्रेड करते हैं. तो इसमें कोई वो बंदी की बात नहीं है. It's the sanction system, and remember there are multilateral sanctions by different countries, and अगर आप उसको फॉलो करते हैं, इसलिए फॉलो करते हैं कि आप नहीं चाहते कि आप उस सेंक्शन में, अगर आपको फर्क नहीं पड़ता तो कोई आपको प्रेशराइज नहीं करता. जैसे कि हमारा डॉलर इस पे नहीं जाएगा, हमारा बैंकिंग सिस्टम इसके साथ नहीं काम करेगा, और अगर आपका बैंकिंग सिस्टम स्ट्रॉन्ग है, आपको फॉरेन रिजर्व स्ट्रॉन्ग है, और आपकी कैपेसिटी विलिंगनेस किसी भी मुल्क, नॉट जस्ट पाकिस्तान, और जो कर सकते हैं विद द सिस्टम मैकेनिज्म है वो है. So sometimes जब मैं आपके मन में थी तो शायद ऐसे ही सोच रही थी, पर you have to understand कि it's not always conspiracy नहीं चल रही. Now coming back to the export, FDI हम चाहते हैं कि FDI एक्सपोर्ट सेक्टर में, यानी कि जब वो कोई इन्वेस्टमेंट लेके आए तो बजाय इसके कि किसी यूटिलिटी स्टोर में बनाए, कमर्शियल स्टोर में बनाए, कॉफी चेन बनाए, उसके बजाय वो कोई इंडस्ट्री लगाए कपड़े की, और हम उसको बाहर भेजें. अंडरस्टैंड डिफरेंस. We have इस हालात में भी इम्पोर्टेंस तो आ रहा है ना, हम तो पैसे दे रहे हैं, बट दैट्स अ कंज्यूमरिज्म ना, वो पैदा कर रहा है, आपको बेच रहा है, तो कोई ऐसी चीज़ नहीं यूज़ कर रहा है कि जिससे हम एक्सपोर्ट करें और अपना FDI कमाएं. So we are getting investment. We want more investment into the export sector, and nobody is stopping us. And it's just sometimes the situation make us can't be choosers. Well, they're not better.
Actually मुझे ये लगता है कि वो गुलाम खाने के दिल के हैं, बट आपने जैसे कहा PITs जो है वो लीगल सिस्टम को कमजोर करते हैं। अब आप अगर आप इंडिया की केस स्टडी को देखें, जयशंकर को देखें, उसने उड़ा के रख दिया। उन्होंने जब कौन सैंक्शंस जो हैं, तो पाकिस्तान के अंदर कौन कैसे
इंडिया ने ऑयल बंद कर दिया है और आपने अमेरिकन प्रेशर के बावजूद IPRI ईरान पाकिस्तान के आपके पास इन्वेस्टर जो है को आए थे, ये था आपके पास खुद पैसे नहीं कि आप प्लेटफॉर्म बता सकें इसके इफेक्ट्स को इफेक्ट्स
Also, I think you want to concrete things because Iran sanctions.
अभी भी $2 billion प्लस का ट्रेड और ये ग्रोइंग, लेकिन ये है कि उसके अंदर क्योंकि हमारे बैंक डॉलर बेस हैं तो इसलिए वो बैंक दे जाते हैं। आप हम स्वैप लेगा ये अलग बात है कि you should not do public diplomacy or
So, okay, so the idea also is to understand the India is not to get permission to get Pakistan. And BITs and FTAs and exports and sanctions, previously, I understand that the system itself, the creation ऐसा है, जैसे हम बोलते नहीं कहते कि हमारा legal system favor the rich people. It's just structurally वैसा बन जाता है. So it's not that people have something against Pakistan. It's just that the developing countries fail to work around the system.
ना आपने शहीद करोड़ों को पढ़ा होगा, आपने हमें बारबेरियन कह दिया, रिच लैंड हमारा है, अरब हमारा है, इंडिया की जो तारीख है, वो आप जो कॉलोनाइजर हैं, बेसिकली उन्होंने डिस्ट्रॉय किया है, वो बारबेरियन हैं। आप उनको कहते हैं कि वो लीगली रिफॉर्म हैं, उन्होंने अपना लीगल सिस्टम डेवलप किया है, लेकिन इसको आप जो है वो थोड़ा सा बैलेंस।
I tried very hard to explain to you that was the initial idea behind it. But I think 1950s से लेकर 1990 और I think independence के बाद में obviously my system so yeah, but we have to be confident in the board that your course will get the PIT. फिर अपनी कोर्स अपने कोर्स बनाना है अपने कोर्स में पाकिस्तान को मिलेगा लेकिन remember the South Korea is having a PIT with UK for example. Both of them are just putting it in just the legal framework भी अच्छी बात नहीं है. So I mean if it's one element but it's not the whole PIT. I should not be clear on this. Other questions? Thank you so much.
Thank you, Dr. Zahur, for a very insightful and learningful lecture from the perspective of developing world. With this lecture, we conclude the day 1 of our summer school. Please note that our summer school will resume tomorrow at 10 a.m. and only those participants will be issued certificates who attend both days of the summer school.